Morning, Mum.
Good morning, everybody. It's 9:30, so we will resume the inquiry.
Morning.
Just to remind anybody who is watching online, if you want to ask questions of the witnesses, please contact the council. So the rules are, you can ask questions of the team that you're opposing. So if you're objecting, you can ask the appellant's questions. If you're supporting, you can ask the council's witness questions, but you can't introduce any new evidence. Are there any procedural matters that need to be brought to my attention this morning? No. Okay, thank you. Okay, Dr. Bowes, if you'd like to call your witness, please.
Thank you and good morning, Madam. I'd like to call Mr. Tivy, please, our final witness for the council. Good morning, Mr. Tivy.
Good morning, Dr. Bowes.
I'd like to introduce you to the inquiry through your proof of evidence. Now, if you could take that up and turn to page 3.
Yes.
You're Christopher James Tivy, is that right?
That's correct.
And you say there that you hold a Bachelor of Science degree with honours in environmental planning, specialising in natural resource management from the University of Central England, now known as Birmingham City University. And you also hold a postgraduate Bachelor of Planning diploma from the University of Manchester. Is that true?
That's true, yes.
Lovely. And you explain you're a chartered town planner, having been made a full member of the Royal Town Planning Institute in 2001. And at 1.4, you explain that the evidence you've given and will give is prepared in accordance with the guidelines of that professional institution. Is that correct?
That's correct.
And at 1.3, you set out your experience. You say you've worked in the planning profession for 22 years in public and private practice and have run your own consultancy, Chris Tivy Associates, since June 2006, of which you are a director. You worked for the District Council as a planning consultant frequently during that time, and in more recent years tended to work on major residential and commercial development proposals on sites across the district. Is that right?
That's correct, yeah.
Okay, now you've produced a proof of evidence and a rebuttal proof, which I'm going to take as read and just focus on the key issues and get you to summarise your evidence on those points. So the first point I'd like to deal with is the community park and open space requirements. You say in your proof that limited weight should be attached to that. Could you explain in summary why you're of that view?
Well, primarily due to the fact that it falls within an area of high flood risk for both fluvial and pluvial flooding. So it's questionable, whilst of course can't be guaranteed how frequent those events will be. I think particularly bearing in mind surface water, it's quite likely that particularly during the sort of the winter months that it won't be usable, or if it is used by local residents, that it'll probably end up a quagmire, because I don't believe that the appellants are proposing to install any sort of hard path. Certainly discussions I've been party to were in essence leaving it as it is, as a field.
Thank you. Are there any other issues you had with the community park you wanted to draw to the inspector's attention?
Well, I mean, I acknowledge that, in terms of the quantum of public open space proposed, it's highly likely that there will be an over provision when taking into account the community park. However, I mean, quite rightfully, the appellants are looking to retain the majority of hedgerows, but also what that does then lead to is the question of whether or not there would be sufficient natural surveillance, for example, to enable parents, guardians of young children to play sort of safely within that area, bearing in mind that unless they were within the park itself with them, they would be essentially hidden from view, particularly bearing in mind the proposals to interplant and to reinforce hedgerows on the site. And by virtue of that lack of natural surveillance, it could also give rise to shall we say, slightly unsavoury behaviour, perhaps antisocial behaviour, perhaps. Whereas, as a general rule, I would suggest that areas of open space that are overlooked by housing would probably less likely suffer such activities. Yeah, they're the main issues with the community park, and that's why, as I say, as a benefit, and I accept that there would be a benefit there, but I think the weight to be attributed is questionable and potentially attributing limited weight.
Thank you, Mr. Tilley. Next topic is the character of the area, and obviously Mr. Brown has given the council's evidence as a landscape architect, but at pages 24 to 32 in your proof, you set out your concerns with the ability to accommodate up to 80 units on the development area. Do you want to, in short form, summarise what those are for the inspector?
Well, I mean, I realise that the description of development is up to 80. You know, it's not a set figure, but I think we need to be mindful of the fact that when the application was originally submitted, it was up to 90 units, and the developable area was reduced as a result of the Environment Agency objecting originally due to climate change increasing the scope of the flood risk area, certainly the fluvial flood risk area. So in essence, dwellings within that high flood risk zone were removed on the indicative layout, but in essence, the density was, or the density now before the inspector, is very similar to that previously proposed. Again, whilst I acknowledge it is only indicative, I provide a plan which is appendix. My appendix 1 to my proof of evidence, CJT1.
Yeah.
Which highlights, and have to admit that obviously bearing in mind that it is an indicative layout, of course, means that what's built on the site, if the inspector was so minded to allow the appeal, could be completely different to what we're looking at here on the illustrative layout. But nonetheless, just simply, I mean, I request the council's urban design consultant to look at the plan, and those garden areas shaded in orange signify properties that are likely to have private rear gardens below the standard of the adopted Essex Design Guide, which is the 2005 version, I believe, that the council adopted. I will just double check that date. Yes, the 2005 version, page 76 on or within core document. Forgive me, because we've got two versions listed. It's in the 7 section. 7.21, core document 7.21. That's page 76. I mean, the inspector may well be aware as well that the illustrative layout plan was revised after the submission of the appeal. I think that was primarily to deal with the National Planning Policy Frameworks, or the latest version of the National Planning Policy Framework, to require tree-lined streets. And looking at the illustrative layout, the inspector will note that particularly on the northwestern edge, the estate road there, on the whole, trees are only lining one side, and I'm sure different people have different interpretations of what tree lined means, but certainly in my mind, tree lined generally means trees on both sides. I would also note that the front garden areas within that illustrative layout do look rather shallow, particularly when comparing in the main front garden areas for dwellings along Brain Valley Avenue. And also there are a number of parking courts which are in close proximity to the rear of a number of properties in Brain Valley Avenue. the ones that back onto the appeal site, onto the southern portion of the appeal site. So in essence, what I'm trying to say is here that on behalf of the council, I'm not convinced that 80 dwellings would fit comfortably on this site within the council's adopted standards. And from personal experience, and I know, from experience of my colleagues at the council as well, all too often, if, for example, a developer buys a site with outline planning permission, such as in this case up to 80, then quite often they will do their utmost to squeeze that number on, because I think in many cases probably the land buyer has assumed that they'll get 80 units on the site. I mean, I realise, of course, dwelling mix, will constitute, significant sort of variables in terms of the returns from the site. But yeah, I mean, ultimately, the density, as signified by the appellant's density study, which is called document 8.12, shows that this development, and I note, I think my density figure was slightly different from Mr. Holliday's yesterday, but nonetheless, it's still a higher density than the majority of development within Black Notley, including the former hospital site, which was a brownfield site, which is the aforementioned Mary Ruck Way development. I do note, however, though, on that drawing in CD 8.12 that 2 areas of open space or sort of amenity space have been omitted.
Just a minute, Mr. Tivy. You want to go to 8.12?
Yes.
Got that open. Let's just.
Sorry.
That's all right.
I'm rushing.
Get it in front of us. 8.12. That's the housing density study.
That's correct.
Sorry.
I'm not entirely sure, though, because when you look at the key plan in the bottom right-hand corner of the drawing, it doesn't actually include the whole of the hospital site. There is a sort of a green corridor that separates the area the subject of this study with the westernmost portion of the former hospital site. But notwithstanding that, purely looking at the parcel that's been identified alone, as I say, it does exclude a couple of areas of open space. There's a crescent, as you know, a circle there has been omitted, which does bump the density up slightly for that hospital site. I believe in my proof I said that it was approximately 30 dwellings to the hectare. Again, I received that information from the urban design consultant, but I've got no reason to doubt his figures on that. I think perhaps more importantly, though, is the density along Brain Valley Avenue itself, and going by the appellant's figures, the northern section, which is generally bungalows overlooking the horse paddocks, which is the area that's bounded by the chain link fence that's been referred to in the landscape evidence that was given, is 17.9 dwellings per hectare, and the southern section is higher, admittedly, at 27.3. But in essence, the proposed development at pushing 40 dwellings to the hectare would be significantly higher than the immediate context. And even if the inspector was to go with the appellant's figure of 36.6 dwellings per hectare for the Mary Ruck Way development, I think she'll note, and I must admit I did send an email first thing this morning asking that Mary Ruck Way be included within the inspector's site visit schedule, because she'll note, particularly depending on the time of day that she visits, that it is very urban in its appearance. I mean, it was built in accordance with the design guide back in the 90s. There's a lot of continuous frontages there. Lots of people park their cars on the footways. The roads are quite narrow. Rear parking courts often aren't used if they are in place, and it's a very, say, urban character. And obviously, as we heard, the landscape evidence, particularly from Mr. Brown, that the appeal site is very much within the countryside on the slopes of the River Brain Valley, and any density that would result, from up to 80 dwellings would provide a very sort of hard urban edge to that side of the village.
Mr. Tilley, can I just ask you a question about Brain Valley Avenue? And you've explained by reference to this CD 812 that you consider that to be of a different character to what likely would be on the appeal site if permission were to be granted and the scheme built out at this scale.
Yes.
Mr. Holliday, in his evidence, as I understand it, appeared to accept that there might be a difference in the appearance and layout of Brain Valley Avenue versus what might be on the appeal site. But he said, well, different times, got to make good use of land, to be expected that there'd be a difference. What do you have to say about that in terms of balancing these different policy objectives of good design, character, making best use of land?
Well, I mean, I realise it's the draft local plan, and forgive me, I can't remember the actual policy number, but I mean, the council's stance is that developments should provide, around or at least 30 dwellings per hectare in most situations. Yeah, and quite clearly there is, an emphasis on making efficient use of land, but nonetheless, the council has standards in place for a reason, and the Essex Design Guide, has gone through a number of iterations. Notwithstanding the fact that the latest iteration hasn't been adopted by the council, nonetheless, I think it's on its 4th iteration now. But the Essex Design Guide is, a well-used document that's been adopted by the majority of Essex local authorities, and garden sizes, for example, is a good example of providing, a good standard of amenity for future occupants. Notwithstanding that, I accept that many gardens of older properties, including those in Black Notley, may well have larger gardens that the Essex Design Guide advocates.
Thank you very much. Next, please, next topic. You identify a number of conflicts with the development plan based on your own observations and the evidence, and you summarise those at 32 to 38 in your written evidence. I wonder if you could already summarise in short form what those conflicts are and the weight that you attach to them.
Well, with regards to, sorry, you referred to page 33, was that right?
I think 32, sorry if I've sent you...
the main issues in my proof starts on page 32, yeah. Yeah. I mean, policy, if I just locate my print off the policies, that'd be easier, so thumbing through the documents online. I mean, the first two policies, I would say, which tend to be those that are applied in these sorts of circumstances where you have a site outside a defined settlement boundary, are policies RLP2 of the local plan review and policy CS5 of the core strategy, which was adopted in 2011. I mean, they very much do seek to protect the countryside, which is I think generally identified as that land outside defined settlement boundaries, which in the case of Black Notley is a village envelope. Now it's quite clear that the National Planning Policy Framework seeks to, let me just go to the exact page, page 50 of the 2021 version of the NPPF, paragraph 174, B requires planning policies and decisions to recognise the intrinsic character and beauty of the countryside.
Yeah.
So, I mean, whilst I acknowledge that those two policies obviously require development to be within the settlement boundary, and I'm mindful, and I'm sure I'll be cross-examined on the fact that the council has granted planning permission on sites outside of settlement boundaries in recent years. Nonetheless, that is it's first base, I guess. You know, it's looking at whether or not the principle of a development is acceptable. With the other policies,
just before you move off those, Mr. Tippy, what's the weight you're inviting the inspector to attach to the conflict with RLP2 and CS5?
I'm suggesting moderate weight, or I think in my proof I might have said at least moderate weight within CS5. I know that hasn't been completely consistent with all recent planning inquiry appeal decisions. The Gilder Terrace, Rain Road and Bartwood Road, Finchinfield spring to mind, but nonetheless, many inspectors have given those policies moderate weight, particularly CS5, and that was certainly the case for the Brook Green inquiry, of which the Gilder Terrace site formed part, and that was called in by the Secretary of State. So I think in that respect, you know, attributing the moderate weight is you know, fairly in tune with what other inspectors have on other sites, what inspectors on other sites have surmised.
Okay, thank you. Moving on, you summarised some conflicts arising from the character and appearance evidence of Mr. Brown. Do you want to summarise what those are and the weight you attach to them?
Sorry, can you refer to me where within my proof?
Yep, so page 36 and 37, you set out the weight you attach to the policies you've identified a conflict with.
Sorry, I'd closed my proof had closed. Right, so sorry, can you say that again, please?
Yeah, so if you turn to page 36 in your proof, Mr. Tibby.
Yes.
You have a title, weight attributed to adopted and emerging development plan policies.
I do, yes.
Yeah, and you set out there the weight that you say should be attached to the conflict of the policies you've identified.
Yes.
And you've told us about RLP2 and CS5 because the site's outside the settlement boundary or the village envelope, and you've said moderate weight.
Yes.
And then you've identified some further conflicts because of the impact on the character and appearance of the area Mr. Brown has told the inquiry about.
Yes.
And I'd like you to summarise, please, those conflicts and what weight you say the inspector should attach to them.
Those policies, particularly RLP 80, RLP 86 and CS8 are, I suppose I deem them more sort of specialist countryside policies, I guess. CS8 is entitled Natural Environment and Biodiversity and refers in its third paragraph with regards to development having regard to the character of the landscape and its sensitivity to change. And the other policies, I mean, our RLP 86 is quite specific in terms of, in this case, making reference to the River Brain corridor, whereas policy RLP 80, again, more like policy CS8, refers to landscape features and habitats. I mean, ultimately, and I think that this was considered in the 1990 appeal decision that was for 17 bungalows, I believe, on the area of land opposite the northern stretch of Brain Valley Avenue. A development, a major development such as this, quite clearly will significantly and permanently alter the character and appearance of the area. And whilst I don't profess to be a landscape expert, obviously Mr. Brown has provided, in my mind, excellent evidence in that respect. The overall impact, would be permanent and significant. So ultimately, I would give those policies RLP 80, 86, and CS8 significant weight in the planning balance.
Great, thank you. And then what are the other headings that you identify a conflict with, Mr. Tibby, and the weight you attach to them?
The other policies.
Also, they're grouped into headings. You set them out, don't you, at page 36 and 37. So you've dealt with settlement boundaries, you've dealt with character and appearance. 820, you tell us about CS7. You want to explain?
Yeah, I mean, in terms of CS7, that's I mean, more akin, obviously, or related to yesterday's roundtable discussion on highways and accessibility. Nonetheless, there's a general theme within the National Planning Policy Framework, of course, to plan developments in a manner that are sustainable in terms of their accessibility, to provide developments in, I would suggest, highly accessible locations that give future occupants a choice means of transportation as an alternative to the private motor car. Again, at the very least, I would give that policy significant weight.
Okay, thank you.
And RLP 90.
Yeah.
In terms of RLP 90, admittedly that does tend to sort of drill down into the detail, to use a sort of a dragon's den phrase, with regards to sort of the layout and detailed design of developments. So normally I would probably suggest that it wouldn't be one of the most important policies, but I think, bearing in mind what I've said and the council's position with the potential density of development with up to 80 dwellings, I do think it is important to have regard to that policy, because ultimately RLP 90 requires a high standard of design and layout, and certainly in my mind, as it stands, the illustrative layout wouldn't constitute that. So again, I would give that policy significant weight.
Okay, thank you very much. Now, and you go on to identify a conflict with the development plan overall, as does Mr. Carville, for slightly different reasons. But Mr. Carville says that the tilted balance at paragraph 11D is engaged and should be applied in this case. He's got a number of reasons for saying that. Could I get your view on whether the tilted balance is engaged in this case, and what you make of the reasons Mr. Carville has given?
Well, I think Mr. Carville's potentially just looked at two policies really, RLP2 and CS5, and honed in on those. In his view, those policies are out of date, and therefore paragraph 11D of the framework is triggered. However, in terms of the actual wording of paragraph 11D, it stipulates where the policies are most important for determining the application are out of date, granting permission unless, and obviously with regards to sort of criterion 2 of that, it's where any adverse impacts of doing so would significantly and demonstrably outweigh the benefits. Now, I realise that that RLP2 and CS5 aren't wholly consistent with the framework, but I don't consider that they're out of date. And taking the basket of policies as a whole, which relates to those policies that we've just been through, RLP2, etc. In addition to those policies within the Section 1 local plan, which are policies SP1 and SP3, I would say that the basket of policies as a whole are not out of date, and therefore, looking at that alone, the tilted balance isn't engaged. Now, obviously, the inspector will draw her own conclusions from yesterday's housing land roundtable as well. But obviously the outcome of her assessment on that would determine whether or not the tilted balance would be engaged in respect of housing land supply. But notwithstanding that, I would say that the shortfall is, even if the inspector went with the appellant's figure, the shortfall is very slight, and the council has a good track record of delivering planning permissions and boosting housing land supply within the district.
Thank you very much. So, if your or Mrs. Carpenter's evidence isn't accepted on housing land supply and the tilted balance were to be engaged on that basis, 4.96 years supply at most, says Mr. Carville. What would your assessment be of the outcome of the appeal applying the tilted balance if it were to be applied in those circumstances?
Well, I consider the two main issues here really are with regards to the impact of the proposal upon the character and appearance of the area, and also the accessibility of the site, i.e., the level of car dependency that future occupants would have. And I consider from yesterday's roundtable that I demonstrated, notwithstanding the fact that the census data is 10 years old, that the vast majority of working individuals within the ward of Black Notley and Great Notley do use the private motor car. I consider we demonstrated that, notwithstanding the fact that the footway improvements advanced by the appellant would certainly be enhancement, but nonetheless, due to the distance and the level of services and facilities available within Black Notley, which is a designated an other village or third tier village within the draft local plan, I consider that the adverse impacts in respect of landscape and accessibility would significantly and demonstrably outweigh the benefits.
Thank you. And then finally, Mr. Tivy, summarising your view of the benefits of the scheme, which you acknowledge at page 40 and 41 of your proof, I wonder, just in summary terms, if you could headline what the benefits are, you say, and what weight you would invite the inspector to place on them.
Of course, yeah.
Thanks.
I mean, in terms of delivery of housing, I acknowledge that if 80 units were to be constructed on the site, 54 market dwellings would clearly add to the housing land supply within the district. And I think, well, bearing in mind in terms of the council's position that it can demonstrate a 5-year supply, I think probably moderate weighting would be fair on that. There are other sites that are being planned within the Section 2 local plan, which are in better locations in terms of accessibility. And so I would give the market dwellings moderate. I do afford affordable dwellings more weight, and I've said significant in my paragraph 8.32. Economic benefits. The appellant lists a whole range of economic benefits, and I'm not in a position to dispute the actual figures that they cite, but I think again, the majority of those benefits could be accrued from a site elsewhere. It's not specific to this particular site, so I've afforded that moderate weight as a benefit. And then in terms of the community park, obviously I've already covered that with what I said about the open space, and therefore I give that limited weight. And whilst I realise that planning obligations will be covered tomorrow, again, as a general rule, developments are, to use a term, expected to wash their own face in terms of mitigating the impacts on, for example, the need for additional school places, GP surgery places, that sort of thing. So I consider that the sort of the planning obligations, the community benefits or wider community benefits, as I refer to in paragraph 8.35, would be limited.
Mr. Carville mentions biodiversity, ecological benefits of net gain. Have you seen any evidence as to what the net gain for this site would be?
I haven't. No, I mean, it may be that I've missed it, but I'm not aware of it, and I don't think Mr. Carville makes reference to a specific percentage. I mean, no doubt that the site could be enhanced, from a biodiversity point of view, but in the absence of specific information, and also bearing in mind that landscaping is a reserved matter, I think that could only be afforded limited weight. And I believe, if I can, would you be able to remind me which page Mr. Carville refers to that in his proof, please?
Yeah, page 58, Mr. Carville's proof. He says at para 9.3.22, overall, the additional landscaping ecological enhancements proposed will lead to a net gain in biodiversity.
Sorry, I've got 2 pages stuck together.
Gives that moderate weight in the planning balance.
22, you said?
58, page 58. Paragraph
9.3.22. 22, yeah.
That's it.
I mean, he refers to it being a positive factor, but he doesn't. Well, I don't know. In his following paragraph, he does say that ecological benefits which have social value with increased access to green space would be moderate. But looking at 9.3.22 on its own, I mean, he states it would be a positive factor, but he doesn't actually attribute any weight to that. So, I mean, I would say, in my mind, that probably tallies with my with my conclusion of limited weight.
Thank you very much. And then, just for completeness, he page 63 summarises ecology, including a net gain in biodiversity, moderate weight. So you've got that reference, Mr. Tibby.
Oh, yes. Sorry, you're right.
Yeah. All right. So limited weight to that, given the absence of evidence on what the net gain would be. Is there anything else you'd like to say in chief, Mr. Tibby?
I don't think so at the moment. Thank you very much. So obviously I'll deal with Mr. Robson.
Yes, if you could just wait there for a moment, there'll be some questions for you. Thank you, madam.
Yes.
Morning, Mr. Tibby. Oh, we're just going to.
Morning.
See, so I'm not just a blurred between me and a pot plant in the background.
do you mind it?
Chairs.
Sorry, do you mind if I just close my window because I'm feeling?
No, of course, please do. No, I want you to feel.
Just have a quick slurp
Well,
of
I want
tea
you to feel uncomfortable, but at least uncomfortable because of the questions rather than the temperature in the room.
Sorry, just to start on a lighter note, I realised I got confused yesterday about dusk and dawn because there's a film called From Dusk Till Dawn.
There is a film called From Dusk Till Dawn.
Hence me getting muddled up when I meant to say dusk.
Well, that's the first time vampires have ever been brought up in my experience of an inquiry, so at least there's that. Right, before we get into the specifics of the policies and the benefits, etc., I want to agree some of the general principles because that will obviously set the framework for our discussion later. So we can agree that the starting point is the development plan.
Yes.
And the development plan in Braintree is the Braintree District Local Plan Review, adopted in 2005, the core strategy adopted in 2011, and then the North Essex Authority Strategic Section 1 plan adopted February this year.
Yes, that's correct.
Good. And the inspector needs to determine whether the application is in accordance with the development plan, unless material considerations indicate otherwise.
Yes.
Good. Emerging policies you've got in the Statement of Common Ground, paragraph 3.5.2. It's agreed that only limited weight can be given to those policies.
Sorry, can I just open?
Yeah, of course. So Statement of Common Ground, page 10. Are you there, Mr. Tivick?
Yeah, sorry, I'm just I've got a long list here, but what core document number is it, please? Is it down as a core document?
I don't think it is.
No. Okay, I'll have to
It's obviously an appeal document because it's
use the web,
submitted
yeah.
as part of the appeal.
Yeah, I must admit,
Should I read it out to you?
I haven't got a print off of it, but yeah, you read it out to me.
So, well, it's first of all, it was signed by you on the 15th of November 2021.
Yeah.
And then at 3.5.2, it says, as Braintree District Council is in the process of preparing main modifications following the local plan part 2 examination, at this stage, only limited weight can be given to its policies.
Yes.
So you're not diverting from that, are you?
No.
Good. Right. The NPPF is a material consideration for the inspector.
It is.
And we're going to look first at paragraph 11 of the framework, please. Could you get that in front of you?
Yes.
And it's the section on decision taking, so at the bottom of the box. Do you have that?
I do, yes.
Good. And there are a number of keys into that tilted balance, aren't there? Now,
yeah.
One of them, sorry, are you with
yes.
me?
Yeah.
One of the keys is if the inspector concludes there's no 5-year supply.
Yeah.
So no 5-year supply, tilted balance applies.
Yeah, by virtue of footnote 8, yeah.
By virtue of footnote 8, that's it. And the second key is where the policies most important for determining the application are out of date.
Yeah.
And when we're looking at which are the most important policies, as you point out, and as I think Mr. Carville also points out, and as is established in case law, it is now, we refer to the basket of policies, don't we?
Yeah, it's a colloquial term, I believe.
I wouldn't tell Mr. Justice Dove it's a colloquial term.
I did see that in some case law that another judge referred to it as that, but yeah.
The basket of policies, that's right.
It's what we refer to it as, yes.
And when we're looking at which policies go into the basket, it's the policies that you're in conflict with, isn't it?
Well, yeah, generally, but not necessarily, but yeah, generally.
Well, I mean, it's going to have to be a yes or no, I think, because if you're in compliance with a policy, then that policy doesn't prevent development, does it? That doesn't count as a cross against your application. It's only where you conflict with it that it would direct you to do something other than grant.
I mean, obviously, the nature of planning policies is such that, you know, some elements of a proposal may comply with certain policies, and certain other elements don't comply with other policies within the development plan. So it's not necessarily the case that those most important ones are conflicted. Quite clearly, in this case, being an appeal And as you're aware of the policies that are cited within the putative reasons for refusal, that they are all policies that are conflicted against in this case.
Well, we're going to get to which policies are conflicted against. I just want to talk in general terms, in principle.
Yeah.
I don't fully understand, and you'll have to explain to me, how a policy which this application complies with would be considered to be a most important policy for the determination of the appeal. Because if we comply, then as the section 38.6 duty tells us, we're in accordance with the development plan and we should be approved.
Yes.
So it's only the policies we conflict with that go into that basket, isn't it?
Yes, okay, in this case, yes.
Now, out of datedness, which we see in policy 11, where the most important policy, so we know what the most important policies are now, it's the ones we conflict with, and then where those policies are out of date. A policy can be out of date for a few reasons, can't it? One is that it's out of date because it's been overtaken by events. So, for example, the evidence base has moved on.
Yeah, certainly in terms of policies that specify housing delivery numbers, for example.
And housing delivery numbers are a product of an evidence base, aren't they?
They are, yes.
And the housing delivery numbers then inform subsequent policies, because you establish your requirement and then you move on to look at how you can sustainably deliver it.
You do, but I mean, obviously the council hasn't cited housing delivery policies within the putative reasons for refusal.
No, but it does cite policies that rely upon housing requirement numbers, isn't it? Thinking specifically about RLP2.
Can you be more specific, please?
Well, RLP2 was drawn to deliver a housing requirement in 2000, and as set in 2005.
Yeah.
And that housing requirement has moved on now, hasn't it? So the evidence base has moved on.
The evidence base has moved on, but nonetheless, obviously, it's common ground that RLP2 forms part of the adopted development plan.
Not saying it's not part of the adopted development plan. Just we're going to get onto RLP2, don't worry. Just then, as a point of principle, we can agree that where a policy is overtaken by events, which can include the evidence base moving on or the housing requirement changing, that can be a way in which you conclude a policy is out of date.
Well, I think there's case law to say to the contrary on that. I know. I mean, I don't profess to be a lawyer, and I don't know the cases inside and out. But I'm aware that there are policies that there's DLA delivery, for example, refers to restricting uses beyond settlement limits to countryside uses. Does not mean a policy is out of date merely because the NPPF directs, well, in that case, specific protection to valued landscapes, and also. The Daventry case, so I don't have the call document number in front of me, but simply because the settlement boundary and countryside policies have been breached in order to deliver a 5-year supply does not mean that those policies must be afforded little weight when a 5-year supply is demonstrable.
I'm assuming you're reading from a document that I'm also going to assume was prepared by Dr. Bowes.
It was, yeah.
Your rebuttals, the additional legal propositions and materials.
That's correct, yeah.
Don't worry, the inspector will get submissions on the case law.
Yeah.
And I think with all due respect to you, it's probably best to leave that to Dr. Bowes and to me to deal with.
I think, to be honest, I wasn't going to go any deeper than that, but I just wanted to draw it, obviously, to the inspector's attention.
We can do.
Attention.
But I, and maybe we will do in due course, but I don't think it's necessarily fair to you. I don't think it necessarily will greatly assist the inspector. I think if we're going to interpret case law, let's perhaps leave it to Dr. Bowes and to me.
Yes. Okay.
So just to go on to out of datedness, I think we've agreed. I think we've got there. The policy can be out of date because it has been overtaken by events, because the evidence base has moved on.
Well, like I say, I agree in terms of housing delivery policies, such as, sorry, let me just get my copy of the Braintree Local Plan Review. I didn't want to presume, but yeah, for example, I mean, RLP1 has been superseded anyway, but that was based on an evidence base period between 96 and 2011. And quite clearly, that policy, is out of date. I don't believe that the policies that restrict development to within settlement boundaries are out of date per se. They may be slightly inconsistent, perhaps, and quite clearly with all planning decisions, there is a weighing up of material considerations having regard to Section 38(6) of the Planning Compulsory Purchase Act. But I don't believe it, a slight inconsistency, for example, necessarily renders the policies as out of date. Right.
So the housing requirement, do you agree that the housing requirement figure can become out of date because the requirement will change over time? I think was your answer before.
Yes.
Now, the housing requirement figure is the number that the local authority needs to deliver over a set period of time.
It is, yeah.
And then how that number will be delivered is determined by the policies that follow.
Yeah.
Because the policies direct where you build those houses.
Yes, yeah, exactly.
So if the housing requirement figure is out of date because the requirement has moved on, the policies which were directing where you deliver an out of date requirement must therefore obviously also be out of date.
Well, I don't think so necessarily, because RLP2 is essentially a countryside protection policy, and whilst if I just go to the precise wording of it. I mean, there's obviously reasoning behind that. I mean, the text that supports policy RLP2, in a nutshell, it intends to protect the countryside surrounding settlements, prevent extension of urban development and sporadic development, protect non-renewable natural resources in accordance with national policy. So that's that paragraph 3.14 of the adopted local plan that precedes policy RLP2. Yeah, I mean, as I said in my examination in chief, I don't profess to state that RLP2 should be given full weight. But I mean, the other thing to bear in mind is, going back to what I said earlier, that the basket of policies for this scheme, I don't consider in any case solely constitutes RLP2 or RLP2 and CS5. There's a wider range of policies that sit within that basket.
We need to make sure that we're trying to stay within the boundaries of what we're discussing. We will get onto all of those topics in terms of which policies go into the basket once we've agreed the principle and whether we conclude that basket is out of date. But I just let's stay with RLP2, which, Ma'am, is CD 7.2, page 3. Are you there, Ma'am?
Getting there. 1, 2. Yes, sorry. Yeah.
Thank you. No problem at all. So when we look at RLP2, it is a boundary policy which applies to all settlements within the district.
Yes.
It doesn't distinguish, the policy itself doesn't distinguish between different tiers of settlements, does it?
It doesn't, no.
and we're agreed that this scheme is outside the RLP2 2005 settlement boundary.
It is, yes.
So this inspector will need to determine whether or not this policy is out of date.
Yes, she will, yes.
Now, we say that at the moment, I don't think you agree with me, but we might get.
I don't.
Don't know what you're not agreeing with yet. I mean, that's amazing. You've got to give me a chance to put it to you. If you're going to start from that position, this could take forever. The position that the appellant's taken is that the RLP2 is based on a housing requirement which has been replaced now by a significantly greater housing requirement, and therefore this settlement boundary does not support the delivery of that requirement, has been overtaken by events and is out of date.
Yeah, that's the appellant's position, certainly.
Now, if the inspector were to conclude that the housing, because the housing requirements has changed, this policy has become redundant, that would make it out of date, wouldn't it?
Well, I mean, obviously it's not for me to surmise what the inspector may conclude on this, but I mean, clearly RLP2, you know, is imposed to protect the countryside from sporadic development, and we're not, you know, the council, of course, you know, applies this policy district wide. And to say that it's out of date and should effectively be struck out, in essence, then renders it a free-for-all for all development within the countryside, unless it's in an isolated location. So, no, I mean, I obviously don't agree that that this policy is out of date.
Let's just be clear about what this policy is for. New development will be confined to the areas within the settlement boundaries and the village envelopes, and outside these areas, countryside policies will apply. So the countryside policies that will apply are CS5. They're the policies which are protecting the countryside. RLP2 is directing where you put your development, isn't it? You put your development inside these town development boundaries and village envelopes.
Yeah, that's what it's saying.
So it's not a countryside protection policy, it's a directing development policy.
Well, I mean, you could look at it both ways, really, couldn't you? Because the second sentence states that outside those areas policies will apply, and as I said, it's the intention behind that policy in the supporting text. Yeah, I mean, I can't dispute the fact that, you know, the local plan review was, you know, was constructed, if you like, on a earlier evidence base in terms of housing land supply, and it's quite clear that, you know, both decisions, you know, past decisions from the council and on appeal have allowed planning permission for residential development adjoining existing settlements, but outside town development boundaries and village envelopes. But I mean, essentially, that's part of the weighing up exercise in any planning decision.
Can I just get a yes or no? RLP2 is a policy that directs development to deliver the housing requirement, doesn't it?
So it's again, please.
Policy. The purpose of policy RLP2 is to direct where you deliver the housing requirement.
Yes.
Within the town development boundaries and villages, yes?
Yes.
The countryside policies that apply outside the boundaries are other policies. They are not RLP2. It's CS5.
CS5 amongst others, yes.
Amongst others. Good. So if we go to CD 7.2, we're in it, and the crossed out section. So if we scroll up to page 1,
Sorry, I did download the documents, but the PC's still playing up. Well, I say playing up, it's still slow, so you have to bear with me.
Well, you might just, you've done a lot of work in this borough, you might just know it anyway. If the inspector has the page.
Okay, can you tell me what core document 7.2 is, please? Because
7.2 is the local plan review. So it's where we were looking at RLP2. We're going up, scrolling up the document to page 1.
Oh, I've got a hard copy of the.
And it's paragraph 3.5, which is a crossed out section.
Paragraph 3.5. Yes, I've got the electronic version in front of you.
Do you have that, Matt?
My hard copy is the original, so there's no crossing out.
Vintage.
It is.
Maybe you should get one that does cross it out, then you'll know which policies to apply and which ones are out of date, Mr. Tivy.
Well, yeah, I do normally use the online system.
Paragraph 3.5. Are you there? So
that's been struck
policy
out.
Background.
Yeah.
Good. So that tells us that's crossed out because that is no longer part of the development plan, is it?
Yes.
It's superseded. And it tells us, the superseded part tells us that it provides for a dwelling stock increase in the district of 10,300 dwellings over a period of 15 years. Do you see that?
Yes.
And that amounts to 687 DPA, dwellings per annum. If you want to trust my maths.
Okay, I'll have to trust your maths there. Yep. I couldn't see the figure.
And the housing requirement now, you'll remember from the discussions yesterday, is 5,352 over 5 years, which is 1,070 DPA.
Yeah.
Yes. So nearly 400 more units per year are required now than were required at the time of the local plan review.
Yes.
And so when we talk about RLP2, directing development, it was directing the delivery of 687 dwellings per annum, and therefore is not suitable for directing the delivery of 1,070 dwellings per annum.
No.
And if it's not suitable for directing 1,070 dwellings per annum, do you agree it is out of date?
Let me just take a moment to think about that. I mean, like I said before, it's certainly inconsistent, but debatable whether it's out of date, because it hasn't hindered development from coming forward. You know,
right.
Within the last few years.
Let's answer the questions, please, rather than trying to avoid them. So, it is not suitable for directing 1,070 DPA. If it is not suitable for delivering your housing requirement, it is an out-of-date policy, isn't it, Mr. Tivy?
Yeah, purely looking at that, yes, it is.
Thank you. And it remains an out-of-date policy, irrespective of whether or not you have a 5-year supply.
Well, I mean, you need to look at the development plan as a whole.
No, you need to look at this policy. This policy is out of date because it isn't suitable for directing 1,070 DPA. That doesn't change, does it, whether or not you've got a 5-year supply?
No, it doesn't. No.
Thank you. And so thank you. I would like then, bear with me a second. Just then for completeness, Mr. Tibby, could you get CD 6.4 up, please, which is the Rain Road decision?
Yeah, I'm just opening it. Well, I do have some extracts from it here in hard copy. Which paragraph
Sorry,
you refer me
if
to?
you just get the document up first, Mr. Tibby, and then I'll take you to the relevant paragraphs.
Okay,
Do you have it?
just bear with me. Yes, it's open.
Thank you. So we see from the top, this is a relatively recent decision, 27th of July 2021.
It
2
is.
days after my birthday, Mr. Tibby, if you want to remember for next year.
Okay, I'll note that.
If we go down to the appearances, please, on page 13.
Yes,
You appeared in this
I did.
inquiry, didn't you?
I did.
Good. And then if we go back to paragraphs 53 and 55.
Yeah.
On page 10.
Yes. I've obviously preempted that because they're pages I printed off.
Oh, good. So where on paragraph 54, or 53, the inspector deals with CS5 and RLP2.
Yeah.
And the more recent policy, SP3. Decisions over any changes to these boundaries depend on the eventual adoption of S2LP, which of course we don't have. Policy SP3 does not provide a free rein to all proposals adjoining settlement boundaries. The appeal site falls outside the currently adopted development boundary, where policies prioritise the protection and enhancement of rural landscape character, whilst other policies might weigh in favour. The proposal remains in conflict with the development plan when taken as a whole. So that's where we are,
Yes.
outside a settlement boundary.
We are. Yeah.
The inspector then goes on at 54. The revised housing land supply position has relied upon the contributions made by a number of sites outside the development boundaries. That's still the same, isn't it? We know that we've agreed. I think the council has granted a number of permissions outside settlement boundaries to get to what you say is a 5-year supply.
Yes.
And you've acknowledged in your evidence today that policies RLP2 and CS5 are not in full accordance with the framework.
Yes.
She then goes on to say the development boundaries were evidently predicated upon much earlier levels of housing need dating back to 2001. That's what we've been through, and conceived many years prior to the publication of the 2012 framework. We haven't dealt with that, but you're not going to disagree that it's pre-framework policy.
No.
The conflict with policies RLP2 and CS5 over the site falling outside the settlement boundary is therefore given limited weight, with a finding of a corresponding degree of limited harm. Given your answers to me now about RLP2 being out of date with or without a 5-year supply, and given that CS5 is dependent upon RLP2, you now, I'm assuming, because I can't see how you wouldn't, but I'm assuming you now are completely in agreement with Inspector Price that RLP2 and CS5 should be given limited weight and a corresponding degree of limited harm?
I agree in terms of RLP2, and indeed, I think at the time of that inquiry, the council's position that a 5-year supply couldn't be demonstrated. It was only after the inquiry had closed that the housing land supply figures had been updated. So I do believe, I haven't got my proof in front of me, but I do believe at the time I did afford RLP2 limited weight on the basis that no 5-year supply was demonstrable. Obviously, things moved on, and you know, yeah. In terms of RLP2, I accept that probably moderate is a bit on the generous side. CS5 though is a wider policy as far as I'm concerned. You know, it's not quite as I think a term I used in my proof, not quite as black or white as RLP2 is.
Right, just to be clear, let's go back to paragraph 7 of the appeal decision.
Paragraph 7. Yeah.
Paragraph 7. On 19th of May 21, after the inquiry and prior to the decision, the council advised of the imminent publication of a report setting out the 5-year supply up to 2026, and this shows a 5.34 years supply.
Yes.
You see that? And then
yeah.
Scrolling down to the overall planning balance section, paragraph 47.
Paragraph 47, yeah.
Council has confirmed that it can now demonstrate a 5-year supply. I have no reason
Yes.
to take an alternative view, and furthermore, the appellant has not disputed this matter.
Yep, that's what it says.
So we then go down to paragraph 53 and 54. So the conclusions Inspector Price reaches about RLP2 and CS5 are in the context of accepting the council has a 5-year supply, aren't they?
They are, yes.
Now you therefore are agreeing with Mr. Carville and Inspector Price that RLP2 is out of date, whether or not you have a supply. Are you now going to agree that CS5 is also out of date, whether or not you have a 5-year supply, or do we need to go through some questions to get there?
Well, I certainly think you need to, put some questions my way.
Okie dokie. Let's go to CS5 then, please. CD 7.1. So would you just bear with me, Mr. Tivy? My computers have all just gone offline, which is presenting me with a difficulty. Just give me 1 second to connect. If you could find...
No, yeah, that's absolutely fine. Mine's trying
CD
to...
7.1, page 65.
Page 65. Yeah, I've got a paper copy of that. I just want to... the supporting text is on the page before, I believe.
Back online, right, good. Are you there?
Yes.
So CS5, page 65 of the core strategy.
Yeah.
Opening sentence. Development outside town development boundaries, village and village envelopes will be strictly controlled to uses appropriate to the countryside.
Yes.
So that policy is dependent upon where you draw the town development boundaries and the village envelopes, isn't it?
It is, but having said that, you know, it says strictly controlled. As I say, it's not as black or white as RLP2, which literally says that development will be confined to the areas within town development boundaries and village envelopes. CS5 says that development outside those areas will be strictly controlled. Admittedly, it then goes on to say strictly controlled to uses appropriate to the countryside, but I don't think it's quite as clear cut as RLP2.
Right. So the bit about strictly controlled to uses appropriate to the countryside is telling you what the policy wants you to do. But before you do what the policy wants you to do, you have to know where to apply it, don't you?
You do, yeah.
Right. And in order to find out where you apply it, you have to look at where the town development boundaries, village envelopes are drawn.
You do.
And you've just agreed with me and Mr. Carville and Inspector Price that where the village boundaries are drawn is now out of date.
Well, in the local plan review, yeah. Obviously, this core strategy was meant to be an overarching document for the site allocations document that I think was abandoned in 2014.
Right. Sorry, that may be my fault, but I thought it was fairly straightforward. When it talks about the town development boundaries and the village envelopes, that's a direct reference back to RLP2, isn't it?
Well, it doesn't specifically say that.
Which other policy other than RLP2 draws village development boundaries and village envelopes, Mr. Tivy?
In the local plan review, yeah, RLP does, RLP2 does, but
so it is a reference back to RLP2.
Well, it's not explicit. And if we look at the supporting text, obviously it makes reference to so that's paragraph 6.24 on the preceding page. I mean that's the first sentence refers to economic development.
Yeah, which isn't what this is.
Farm diversification, etc.
Sorry, I don't mean to interrupt. I'm trying to save time. Could we go back to page 39 of the core strategy, please?
Page 39. Yes. Oh, yes. Sorry.
So page 39 is the key insets and the key for the policy map.
Yeah.
See the fourth one down, town development boundary village envelope.
Yeah.
What's the policy that's referred to?
RLP2.
Good. So let's go back to CS5.
Yeah.
You there?
I am, yes.
Good. So where CS5 refers to town development boundaries and village envelopes, it's referring to RLP2, isn't it?
Yes.
So RLP2 is out of date. And so we don't know, do we, where town development boundaries and village envelopes are to be drawn?
No, well, like I said, the site allocations document was meant to identify lines on maps.
Well, I know, Mr. Tivy, I was meant to buy my Christmas presents in November, but I didn't. So we are where we are. And RLP2 is out of date. We don't know where to apply CS5. CS5 is also out of date, isn't it?
No, I would say it's inconsistent with the framework, but like I say, it's a wider policy than RLP2.
Inconsistency with the framework is not what I'm talking about here. I'm talking about it's out of date because, as you agreed with me about RLP2, it has been overtaken by events. I'll ask one more time, Mr. Tivy, and then I'm just going to make submissions on it because we can move on to the point. And I think the inspector has the point. It's just a lot easier if we could get agreement. RLP2 is agreed to be out of date. RLP2 sets as town development boundaries and village envelopes. RLP2 is the basis on which we know where to apply CS5. If we don't know where the town development boundaries and village envelopes are, we don't know where to apply CS5. It is out of date, isn't it, Mr. Tivy?
No, I'd say it's not. I mean, as I say, there's previous appeal decisions, including the Secretary of State's decision on the large green development, of which the Rain Road decision formed part, attributing moderate weight to CS5. No, I don't agree I don't agree.
But the Secretary of State decision you keep referring to, which core document number is that, please?
Whilst Mr. Tierney,
it's not listed there.
Right. So on the basis of something that's sorry, Mal.
yeah, sorry. Whilst Mr. Tibby was looking, I was just going to suggest that if we have a break about 11 o'clock, so if you can just bear that in mind. Thanks.
Ma'am, I think we're nearly done with CS5. Would it suit to have a break after CS5 rather than start on?
Yeah, if that suits you, then we'll do that. That's fine. Thank you.
I have a few more questions on CS5, ma'am, but then that would certainly suit me if it suits you, ma'am.
Yes, that would suit me too. Thanks. Thank you.
So on the basis of a document that's not before the inspector, you want the inspector to conclude that CS5 is not out of date, so we're clear.
Well, clearly the document's not in front of the inspector, so I can't refer to that, obviously.
Your paragraph 8.17, please, Mr. Tibby.
8.17, did you say?
Mm-hmm.
Yes.
That a policy that is up to date gets its full weight, doesn't it?
Yes.
And weight is reduced because of inconsistency with the framework.
Yes.
One way, and inconsistency with the framework can be a reason why a policy is out of date.
It can be, but not in all situations.
And another reason why a policy gets reduced weight is because it is out of date, because it has been overtaken by events.
Yes, that can be the case.
So in 8.17, you give CS5 moderate weight.
Yeah.
And yet you conclude it's not out of date. But if you're reducing the weight, then it's not up to date, is it? So it must be out of date. You must accept that it's out of date because you've reduced the weight you give to it.
Well, I think the very fact of when a policy was adopted, say, doesn't necessarily mean that it's out of date. In relation to the relevant version of the MPPF. So no, just because you give something reduced weight doesn't mean it's out of date. There might be a tension, which I think the Gilder Terrace inspector referred to, because of the fact that obviously housing land requirements have moved on. But as I say, CS5 is a wider countryside policy. It's not just, in my mind, it's not just about whether something's in or out of a settlement boundary.
Okay, I'm not sure what your answer was there, but I think we've got enough for submissions. I think the lack of clarity is probably clarity in itself in some ways. Just go back to CS5 briefly, and then it's time for tea and biscuits, I think. Page 65 of CD 7.1.
Page 65, yep. Sorry, that's the core strategy.
Core strategy, CS5, page 7.
Yeah.
CD 7.1. Outside the settlement boundaries that we don't know where they are, you must strictly control development to use appropriate in the countryside in order to protect and enhance the landscape character and biodiversity. There's no requirement in the framework, is there, to protect and enhance general countryside?
Well,
yes or no. Yes or no, please, Mr. Tivy, and then qualify, and then.
Okay. Yes, there is. Sorry, just say the question again. Just make sure I'm saying the right answer.
There's no requirement in the framework to protect and enhance general countryside, is there?
Yes, there is.
Where? Can you show me, please?
Well, the first line of paragraph 174 on page 50 of the MPPF says that planning decisions should contribute to and enhance the natural and local environment by, and then going on to B, recognising the intrinsic character and beauty of the countryside. So I think in essence it's quite clearly states enhance in that first sentence.
Does it require you to protect general countryside?
Well, it requires you to recognise the intrinsic character and beauty, but by default, to it may not explicitly use those words, but I'm sure that is the intention when it says to contribute to and enhance. I mean, it's not just talking about protection; it's talking about actually enhancing, which is obviously like a higher bar, if you like.
You've told us, and you say in your proof that CS, and it's this 8.17 again, you don't give it its full weight because it goes beyond the framework in referring to an enhancement of the landscape and amenity of the countryside, as opposed to simply preservation and protection. So you're making an admission there in 8.17, aren't you, that it is not
I'm making an admission there, but I realise in hindsight I'm incorrect there in my proof.
Okay. Do you realise you're incorrect because you've already agreed that it's out of date because of its link to RLP2, and you're just trying to find something, or do you generally think that you were
No. I mean, it wasn't just this morning that I suddenly realised that.
It wasn't just in the last 10 minutes either, was it?
It wasn't. No, hand on heart, you may not believe me, but it was a few days ago.
I don't have a view on whether I believe you or not. Trust me, Mr. Timmins, it's not for me.
Okay.
Ma'am, I think that's probably a convenient time to break. Take a cup of tea. Thank you.
Thank you.
Okay, thank you very much. So we'll adjourn now until 11:15. Okay, thanks.
Thank you.
Sorry, I was muted. If you're both ready, we'll resume now. Thank you.
Thank you, ma'am. By my count, I think I've been 45 minutes, so I think we should still get this done well within time. Mr. Tivy, you'll be pleased to know we're going to move on from RLP2 and CS5 and have a look at CS8, please.
Okay, yep.
Which is CD 7.1, page 80.
Yes.
So that's page 80 as marked on the page. I don't know if it's the same electronically. Page 82 electronically. Are you there, Mr. Tivy?
I am. Yes, I am.
Right.
Thank you.
So let's just go through it. Hopefully we can go through it quite quickly. The first part, all development proposals take account of the potential impacts of climate change and ensure the protection and enhancement of the natural environment, habitats and biodiversity and geodiversity of the district. There's no reason for refusal on ecology or habitats, is there?
There's not.
No issues with biodiversity and geodiversity?
No.
The natural environment we will come to. I'm assuming you're taking landscape to be as part of the natural environment.
Yes, of course. Yeah.
Yeah. Looking at the bullet points, air, noise, light and other types of pollution and excessive use of water and other resources, there's no issue between us on those.
There's not, no.
No issue between us on BMV. That's the most versatile.
No.
Now this paragraph, next paragraph that starts, development must have regard to.
Yes.
I think that's where we've got our issue, isn't it?
It is, yeah.
Because when we go skip over that paragraph, the natural environment of the district and in particular designated sites and locally designated sites, we're not a designated site of national importance or a locally designated site, are we?
We're not.
And then it goes on to say that criteria-based policies will be set out in the development management document. There is no development management document, is there?
There's not, no.
So we don't know what criteria an impact on the natural environment is to be assessed. So there where it says the natural environment, you go back to paragraph 1 to the reference to natural environment, which you're taking to include landscape and visual.
Yes.
And we should assess the impact on natural environment, read landscape and visual, in accordance with the development management document, which doesn't exist.
Well, I mean, it exists, but it's not an adopted development plan document, no.
Yeah, it's not an adopted document. I just want to be clear, you know, I'm not saying what I'm looking at is how the policy operates. We've had evidence on whether or not there's landscape effects, and we say there is to a degree, and you say to a higher degree. I'm not rowing back from that. I'm just looking at how the policies operate.
Of course.
Then it goes on to the restoration and enhancement of the natural environment will be encouraged through a variety of measures. You see that?
Yes.
Maximising opportunities for the creation of new infrastructure and networks in sites allocated for development. We're not allocated for development, are we?
You're not, no.
So that bullet point doesn't apply.
It doesn't apply, no.
Creating green networks to link urban areas to the countryside. So there is the access off Brain Valley Avenue, taking you down into the country park, to the community park. That is a green network linking the urban area to the countryside, isn't it?
Yeah, if you want to refer to the village as an urban area, it certainly links the built-up element of the village to the countryside.
I think we agree that we're complying with that, or we're delivering on that bullet point, aren't we?
Yes, yeah. I mean, clearly, it would provide additional access to the countryside than is currently the case.
Creating and enhancing So creating and enhancing the biodiversity value of wildlife corridors. We'll get onto biodiversity, no doubt, but obviously there's the reserve matters stage options to include biodiversity enhancements as part of the community park. So we comply with that bullet point.
Well, I mean, you can't say that it complies with that, but I'm not saying it conflicts with it either. As you say,
Okay,
it's more detail to follow, isn't it?
Yeah, good. The next 2 bullet points: local nature reserves, local wildlife sites, and triple SIs. We're not in any of those, are we? We're not a nature reserve, a wildlife site, or a triple SI.
No.
The final bullet point: development will promote wildlife enhancements, which will contribute to the habitat and species restoration targets set out in the Essex Biodiversity Action Plan. Same point as before. You're not saying we don't. You're not saying that we don't comply, but it's something that can be dealt with in any event at the reserve matters.
It could, yeah.
Right. Sorry, it's a long old policy, this one. Next paragraph: flooding. There's no objection from the lead local flood authority, is there?
There's not, no.
And SUDS is provided.
Yeah, well, that's shown on the illustrative layout. I haven't seen any actual sort of detailed designs, but again, I assume they'd come at the reserve matters stage. They
would, and you're not saying that we don't comply with this part of CS8, are you?
No.
There's no issues with wastewater treatment and sewerage.
No.
No issues with, and I think what next paragraph: water and sewage providers. Well, discussions can go on for reserve matters stage, can't they?
They can, yeah.
And no issues about the use of water efficiency measures.
No issues there.
So we are solely focused, and let's scroll back up on CS8 on the section, the paragraph that starts: development must have regard to the character of the landscape.
Yes.
Okay, that's the only bit we're looking at.
It is.
And let's take that in chunks. Development must have regard to the character of the landscape and its sensitivity to change. So let's pause there. Development must have regard to the character of the landscape and its sensitivity to change. So the word "must have regard to" is about ensuring applications come forward with appropriate assessments, landscape and visual assessments, LVIAs, etc.
Yes, and yeah, appropriate landscaping at reserve matters in this case.
Well, that's right. And so you're not saying that we haven't had regard to landscape and its sensitivity to change. You've just come to a different conclusion to us.
Yeah, exactly. Yeah,
so we comply with that part. So we comply with it up to sensitivity to change, and then it says, where development is permitted, it will need to enhance the locally distinctive character of the landscape in accordance with the landscape character assessment.
Yeah.
Now, we've had evidence on this already. The inspector has it clearly that Mr. Holliday says we do comply with the guidelines in the LCA. Mr. Brown said that we didn't. But I want to look at where those landscape character assessments come from and how they're written into policy. And it's this next sentence. Landscape character areas will be defined in the site allocations development plan document, and further guidance will be set out in a supplementary planning document. You see that?
I do, yes.
There is no site allocations development plan document, is there?
As I say, there was a draft one in 2014.
There's no adopted site allocations DPD?
No.
And there's no supplementary planning, further guidance set out in a supplementary planning document, is there?
No, not to my knowledge.
Okay. So what we've got is policy directing us to test whether development enhances the locally distinctive character of the landscape in accordance with the landscape character assessment and the landscape character areas in documents which don't exist.
Well, the landscape character assessment documents exist.
But the landscape character areas come are to be set out in the DPD, which isn't there, is it?
The DPD isn't there. No, not as an adopted document. No.
And so we've got a DPD, if it's to be become part of the development plan, has a statutory process to go through, doesn't it?
It does, yeah.
And that's extensive consultation and responses.
Yes.
And then it becomes an official development plan document. The landscape and character assessments that we've been through on Tuesday, they're not development plan documents, are they?
They're not, no, but they form the evidence base to the local plan, both the emerging local plan and the adopted Section 1 local plan.
But they're not development plan documents, are they?
They're not development plan documents, no.
Can you go to Mr. Carville's brief, please, at page 27?
Yes, I'm there.
Which quotes from the Rain Road
sorry, page 27, did you say?
sorry, that's electronic page 27, printed page 19.
Oh, okay.
Sorry, my fault misdirecting you, Mr. Tim.
No worries. Yes, so page 19.
So printed page 19, bottom centre, electronic page 27.
Yeah.
Quoting from the Rain Road Inspector, which is a decision we've been to already, the one you appeared at.
Yeah.
CS8 requires development to have regard to the character of the landscape and its sensitivity to change,
Yeah.
of which I found limited harm.
Yeah.
This further requires schemes to enhance the locally distinctive character of the landscape in accordance with the LCA. This is more onerous than paragraph 174B, which seeks only that the intrinsic character and beauty of the countryside is recognised. Due to this inconsistency with the framework, reduced weight is attached to the conflict found with policy CS8.
Yeah.
Do you agree with that statement? Do you agree with the inspector at Rain Road?
I mean, obviously the specifics of the case are different, but in terms of what he's saying with regards to CS8, no, in terms of CS8 with the framework, as I identified and incorrectly put in my proof or missed out, if you like, is that word enhanced from the first sentence of paragraph 174 of the framework. So, you know, in my mind, you know, the framework does require the landscape to be enhanced. So I'll just read it again. But planning decisions should contribute to and enhance the natural and local environment by B, recognising the intrinsic character and beauty of the countryside. So no, I don't agree with the inspector on that.
Okay, I understand why
for the Rain Road appeal.
I understand why you don't agree with the Rain Road inspector. I don't agree with you, and neither does Mr. Carville.
No, of course not.
But we've got your evidence, such as it is. But just to be absolutely clear, that paragraph is about the interpretation of CS8, isn't it? From Rain Road. It's not linked to the location of the site or anything specific about the Rain Road site. It is about how you interpret CS8.
Well, I don't know. The first sentence there, he says, obviously says CS8 requires development to have regard to the character of the landscape and its sensitivity to change, comma, over which I've found limited harm. So by reading that, I take that he refers to, and indeed, because that was the main issue with that appeal, that he found limited harm in respect to the landscape and its sensitivity to change.
Right.
At that point there, I don't think he's saying limited harm in respect to CS8. Further down at the bottom, obviously, he talks about reduced weight.
And when talking about, sorry,
I'll let you you speak.
No, it's me misjudging your gaps. I will be patient.
Okay. What do you mean by misjudging gaps?
But every time I think you've stopped talking, I jump in, and it turns out.
Yeah, yeah, I guess that's part of this virtual deal, isn't it?
Probably just me not doing my job properly, Mr. Tibby. Are you ready now? Are you done?
Yes, thank you.
Good. So where the inspector goes on to look at and talk about the policy, CS8, being more onerous than the framework, paragraph 171B, and explains his view, and then says, due to this inconsistency with the framework, reduced weight is attached to the conflict with CS8. So due to this inconsistency with the framework, that is about the interpretation of the policy, and it is not linked to the specifics of that site, is it?
It's not. No, not that sentence. No.
So the Main Road Inspector's interpretation can equally apply then to the application of CS8 to this site.
Yeah, I mean, it's quite possible that if that same inspector was overseeing this appeal, then yes, they may well, Mr. Price, I believe it was, may well come to the same conclusion. It'd be quite surprising if he didn't.
So, Madam Inspector Watson can conclude, or could conclude, that there is limited harm, as Mr. Holliday has set out, and reduce the weight to that conflict with CS8 because of inconsistency. That would be a conclusion open to her.
It would be a conclusion open to her, of course, yeah.
I know you don't say she should conclude that, I understand that, but...
No. That's what I was hoping you were. Hoping you understood it along those lines.
Thank you. RLP 80.
Okay.
So CD 7.5.
Yeah, I've got a paper copy.
Page 2.
Yes. Okay.
Now, I know we've got different views about integration into the landscape. I know we've got different evidence about whether or not this scheme is detrimental to landscape features, if there are any landscape features about the site. But just to be clear about the level, the issues between us, there is nothing in between us about having a detrimental effect on trees, hedges, woodlands, grasslands, ponds or rivers, is there?
There's not, no.
And the references to species and habitats and the biodiversity action plans there's no issue between us on that. We've spoken about it already in the context of CS8.
We have.
It goes on, where development is proposed close to existing features, should be designed and located to ensure that the condition of future retention will not be prejudiced. So existing features on this site include the dense hedgerow, the boundary trees, the riverine vegetation. There's no proposal here, is there, to that would prejudice their future retention?
No, not those features such as the aforementioned hedgerows or trees, no.
And landscape and planting of native trees is a reserve matters issue.
It is, yeah.
Detail.
Yeah.
So really, the only issue between us in RLP 80 terms, and the inspector has evidence on it, is about whether or not this scheme integrates within the landscape.
Correct.
Right, good. Staying in CD 7.5.
Local plan, yeah.
Yes, sorry, still in the local plan review.
Yes.
This is about the river corridors.
Yeah.
development will not be permitted which would harm the open character, nature conservation importance or recreational importance of the floodplains of the rivers, including the River Brain. So the policy is limited to the floodplains, isn't it?
Well, it refers to open character of the floodplains, which I suggest, involves its sort of overall setting. Much like for a conservation area, for example, developments can affect the setting of conservation area. I accept that there's no conservation area here, but that's just an analogy that I used. There's no development. There's no development proposed on the actual floodplain, though. I can confirm.
So just to be clear, as a point of principle, when we look at policies, we have to take them as they're written, don't we? We don't imply terms into them. We
don't. No. We have to read the words that are in front of us. Precisely.
And it talks about the importance of the floodplains. Does it talk about the importance of the setting of the floodplains?
Well, it doesn't specifically say settings. No. Of course it doesn't. But it does refer to harm to the open character. And my suggestion being, or my view being, that if there is development sort of looming over the hedge, then that would harm its open character. Currently, I realise it's not. On the western side of the river, I realise that's not public land currently, and there's no public rights of way along there. However, if one was to stand in that field currently and look west, obviously you'd see the bungalows fronting Brain Valley Avenue in the distance. But well, you may do where there's a gap in the hedge, but built form would of course be brought that much closer to that river corridor.
So your reference to the setting of the floodplains is, let's be clear, is your implication into that policy, isn't it?
Well, like I say, I'm referring to...
Yes or no, Mr. Tibby? Yes or no? It's your implication into the policy, isn't it? Because the word isn't.
It's my interpretation.
Well, there's a difference between interpretation and implication, and I'm sure Dr. Bowes is going to the case law now. But implying a term into this policy is something that we're directed not to do, because we are told to read policies on the basis of the words in front of us, aren't we?
We are, yes.
And you are implying that we look at the setting of the floodplains because the words are not in the policy, are they?
Setting is not in the policy wording, no.
So you are implying that it is there?
Yes, I suppose I was.
Yeah. Which, as a point of principle, is not something you should do.
Noted.
Well, yes or no?
Yes.
Thank you. And actually, when you look at that policy in terms of this development, as I think you said earlier, the recreational importance of the floodplains, the development will give access to parts of the floodplain to the public that currently they don't have access to.
Yep, that's correct.
So it will increase the recreational importance of this part of the floodplain of the River Brain, won't it?
Yeah, it would enhance the recreational importance in that it facilitates access, for members of the public.
And that's a benefit, isn't it?
It is a benefit, yeah. Yeah.
And we'll talk about weight in a moment. Thank you. So, given everything that we've just discussed, there's no conflict, is there, with RLP 86?
Well, I still say, notwithstanding what I've just agreed in terms of setting, in that the word setting's not there, I still believe that the proposed development would harm the open character of that floodplain, because as I said before, built development will be that much closer to the to the floodplain than's currently the case.
So just to be clear, you accept that you shouldn't imply the word setting into it. You accept. Yes, that you've accepted that you shouldn't imply setting into the policy. Yes.
Yes.
You've accepted that there's no built development in the floodplain.
Yes.
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 You've accepted that there is an increase in the recreational importance of the floodplain brought by this development.
Well, there'll certainly be a recreational enhancement.
So that's a yes, I think, isn't it?
Yes.
But nonetheless, you say that there will still be harm to the open character of the river corridor. That's your position, is it?
Well, it doesn't say openness, does it? It's not like Greenbelt, for example, where any sort of built development, has a sort of a 2 or 3 dimensional impact upon it. I think character is something that's broader. And like I say, I mean, I'm repeating myself, but I think the open character of that floodplain would be harmed. Whilst I accept that there's no public access currently, if one were to stand in sort of the main area of the proposed community park, particularly looking west, that the presence of built form would detract from its open character.
Understood. Thank you, Mr. Tivy. We've got your position. We don't agree, but we'll deal with it in submissions now, and Mr. Carville can deal with it in his evidence.
Thank you.
Sustainability.
Yes.
And CS7, which is at CD 7.1.
Yes, have it in front of me.
Which is printed page 72, electronic page 74 of that document.
Yes.
And I'd like you then to scroll back to the start of the section, which is page 69, electronic page 71, start of the transport section.
Sorry, I need to just go to the electronic copy of that because I only got the policy itself. Right, yeah. So chapter 7, transport.
Have you read the justifying text, Mr. Tibby?
I have some time ago.
Justifying text isn't policy, we know that, but justifying text does aid with the interpretation of policy, doesn't it?
It does, yeah.
Good. So it doesn't have the weight of policy, but it assists with interpretation. It's
it
a
does,
point
yes.
of principle.
Yes, yeah.
Good. Right. I'd like to look at paragraph 7.1.
Okay.
First sentence, core planning policy in relation to the aims of promoting accessibility for all. It also takes account of the other aims, including addressing climate change. And then it says, and this is where you might you highlight a pen out, accessibility means how people access their needs, including employment, shopping, and community services. And then the next sentence, accessible locations will be defined as within 30 minutes walking or cycling distance of a retail centre, a primary school, a secondary school, and GP surgery.
Yes.
So provided that you can walk or cycle to all of those 4 facilities, the local plan says you're in an accessible location.
That's what it says.
Right. Now, just so that we can agree walking speeds, I think we went there yesterday, but let's go there again very quickly. CD 9.3.
So I've got to reopen that because I closed it down on the cessation of that roundtable discussion. Sorry, did you give me a page number?
CD 9.3, paragraph 3.30, which is page 48, printed number 11 of 25 electronically.
Acceptable walking distances.
Yeah, and then in 3.30,
Yeah.
the penultimate sentence, an average walking speed of approximately 1.4 meters per second can be assumed, which equates to approximately 400 meters in 5 minutes.
Yes. Or
So,
3 miles per hour.
Or 3 miles per hour. So
Yeah.
400 meters times by 6 is 2.4 kilometers in 30 minutes.
Yes.
Can we go to Mr. Carville's proof of evidence, please?
Okay.
And his Appendix 6, which I've no idea what page that is on paper, but electronically.
Is that the accessibility?
It is the accessibility statement. Yeah, that's right.
Okay. Yeah.
And then in the accessibility statement, I'd like you to go, please, to in the figures, figure 3.1, which is the walking isochrones and amenities.
Sorry, figure 3. Which page is that on?
Electronically, I'm on page 129, and paper copy. I'd have no idea.
Sorry. Which are we still in Appendix 6 of Mr.
Appendix 6? Yeah. So it's in the figures, which is starts on page 16 of the accessibility statement.
Oh yes, yeah. Sorry, it was at the back. Yeah.
Thank you. And then figure 3.1 is the walking isochrones and amenities.
Yes. Okay.
Are you there, Mum? So what we see there in the different colours is that the isochrones at 400 meters in yellow, 800 meters red, 1200 meters sky blue, 1600 meters green, 2000 meters 2 kilometers. So what colour do you call that? Like a heathery sort of colour, isn't it?
It is, yeah.
And you just agreed earlier that for the purposes of your definition of an accessible location in the local plan, we're looking at being able to walk 2.4 kilometres on foot.
Well, if you work that out from those walking speeds that that you drew my attention to in CD 9.3, then
which
yes,
you agreed, didn't you, Mr. Tivy?
Well, I agreed in terms of walking speeds.
Yes.
I can't disagree with walking speeds.
So the primary school and the secondary school, are within a 30-minute walk, aren't
they? Yes. But that's obviously purely by virtue of the distance.
Now, one would hope that the walk would be safe, and you said yesterday in the round table on accessibility that you have no issue with the safety of the walk to the primary or secondary schools once the works have been completed.
Not from a highway point of view, no. It was primarily to do with the attractiveness and the convenience or otherwise, for prospective users, particularly those with young children.
Yeah. And I think you also said that actually there's no issue, or you made no issue about the 1.2 metre sections currently being unsafe from a highways perspective.
I didn't. I mean, as you'd be aware, there's no objection from the local highway authority on the footway widths. I did question whether 1.2 metres was achievable, though. Certainly in certain places, I believe it was from 36 to 54. I think it was Witham Road, where there are clear narrow sections, and the extent of the highway boundary is limited to that of the back edge of the footway. And as I accepted in the round table that, I know certainly the further north you go towards the flyover, there is encroachment onto the footway, but that section I've just referred to, the front garden or front verge within private ownership is hard up against those, and I could see no on site. I could see no evidence that there had been encroachment on the footway.
Now, when it comes to an experienced planner, when it comes to drafting and applying policies, it has to be done in general terms, and policy is cast in general terms because you can't account for all individuals and individual circumstances, can you?
You can't, no.
So when we look at the definition of accessible location, so let's see if we have you still got CS7 open? Well,
I've got so I've got a paper copy of the policy itself in front of me.
And the definition of an accessible location.
The definition in paragraph 7.1.
Yeah,
that's on my screen.
So we accept that it's within 30 minutes walking distance of a primary school and a secondary school.
Yes.
There's no issue with the safety of that walk. For the purpose of that definition, we've met it, haven't we, with regards to primary school and secondary school?
In purely sort of quantitative terms, then yes.
So that's where one looks at compliance with policy and what the terms of the policy are in general terms. And outside of policy compliance, we have material considerations, don't we?
We do.
Other material considerations.
We do, although as you just highlighted, obviously the supporting text isn't development plan policy.
Absolutely,
itself.
We're getting there. I just want to make sure we're putting evidence into the right box.
Okay.
So when we come to the desirability of the walk, that is not an issue of policy compliance, is it? Just looking at this definition of accessible locations, justifying text, I know, looking at the definition in that justifying text, that's not an issue of policy compliance, is it? It's an issue of another material consideration.
Yes. Yeah, but you're taking that supporting text in theory as policy.
Not yet. And I don't intend to either.
Well, I was going to say you can't do that.
I'm absolutely not going to. No, don't worry, because I know what Dr. Bowes will say in re-examination, and I know what Dr. Bowes would put in his submissions if I did. It's justifying text. I'm not giving it the weight of policy. I just want to put evidence into the right boxes.
Okay.
And for the purposes just looking at that justifying text, the desirability is something that is a material consideration rather than something that falls within that definition or prevents us from falling in that definition.
Sorry, desirability doesn't prevent us from falling, or prevent.
Yes, so we can't say that we're not an accessible location because despite being within 30 minutes walk of a primary school and a secondary school, on your evidence, it's not a desirable route.
Exactly, yeah. And I would hasten to add as well that perhaps the very fact that the appellants have kept in that blue pencil clause in the unilateral undertaking to provide a primary school transport contribution does signify perhaps that they're not quite so confident that it's an accessible route either by way of footway to the John Ray primary schools.
So for definitional purposes, we are within 30 minutes walk of a primary or secondary school.
We are.
Retail centre, we're going to have to go back to those isochrones.
Okay. Still
Just
open on that.
remember, just recall that it's walking or cycling.
Yes.
Doesn't have to be walking and cycling, or if you can't, it can be either or. If we go down to figure 4.1, the cycle isochrones.
Sorry, just looking at this diagram though, it doesn't, the isochrones, like Ty Green is probably within 2 kilometres, but that's not shown on this isochrone. It's only focused obviously around Black Notley itself and the schools. Well, having said that, the schools are slightly out of the 2,000 metre isochrone, but I won't hold the opponents against that. But like I say, obviously there are facilities within Ty Green, which is shown to the east on that figure 3.1, and for some reason or other they're not included within the isochrones. I assume it's because there's no footway whatsoever to Ty Green, notwithstanding the fact there is a footpath that goes across the fields and over the railway line. But it doesn't appear to me to be a complete diagram to me.
Sorry, no, just I think I take your point. Just to be clear, so the reason that it's the shape that it is, and it takes the wiggly line, is that it's following the walking routes. It's not as the crow flies distances. And then the reason that it goes up towards Braintree and the primary or secondary schools is because those are the primary and secondary schools that the residents of the development would use. And as we discussed yesterday, the walking route up Bufford Lane, Newford Lane, Bofford Lane, Bulford Lane. Mr. You probably pick it up. Mr. Carville is frantically trying to mouth at me what the name of the lane is, and I'm still getting it wrong. It's not one where there's a footway provided. You're in the carriageway.
No, but nonetheless, the appellants do cite Cressing railway station as a means of public transport from the site, and I mean, it was impressed by Mr. Carville yesterday that when I highlighted the lack of connectiveness between many of the bus services and the trains from Braintree railway station, he did specifically state that Cressing railway station was within, I believe it's 1.2 kilometres from something I've read. But all I'm trying to say is that this diagram isn't complete, and the wiggly line you refer to along the right hand side is I don't know what that is actually, whether it's the parish boundary. I'm not entirely sure, but
Right.
I mean it doesn't matter necessarily, but so I don't feel that I'm looking at a complete diagram here.
It also doesn't matter when we're looking at the definition of accessible locations in the terms of CS7, doesn't it? Does it? Because we're looking for 30 minutes walk or cycle to primary or secondary schools, retail centres and GP surgeries. It
does, but that text in 7.1 doesn't. I mean, it just talks about, as I said earlier on, purely in quantitative terms, that those John Ray primary schools are within, approximately a 30 minutes walk.
Yes.
However, that doesn't discriminate, if you like, against routes that are perhaps impractical. And I think by implication, I think the appellants accept that the walking route, and I think you've just intimated it, the walking route to Ty Green wouldn't be safe.
Right.
So quite clearly,
I'm sorry, I shouldn't interrupt your evidence, but I really want to focus on what we're talking about, which is the definition of acceptable location for the purposes of CS7. What you're talking about now is, let me finish. What you're talking about now, sorry, I know I've cut across you. What you're talking about now is the accessibility evidence we heard yesterday. I want to focus on, within that definition given in the justifying text of an accessible location in the adopted development plan, do we fall within that definition? You've agreed that we are within a 30-minute walk of a primary and a secondary school in definitional sense. That one's dealt with. Let's look at the cycling now, the cycling isochrones in 4.1, figure 4.1.
Bear with me. Yes.
And the 5 5,000 metre isochrone is taken as a 30-minute cycle. Would you agree with that?
Well, what's 5 kilometres in miles?
3.1.
Sorry, did you say 3.1?
3.1.
Okay. I mean, say, well, it depends who's cycling, doesn't it? But 15 miles an hour, perhaps.
But yes, but as policy has to be in general terms, doesn't it? I mean, I'm assuming that Chris Boardman would be able to do it a bit quickly. He might get to Colchester. If I was doing it, I'd be probably a bit slower. But as an average, the 5,000 metres is a 30-minute cycle, right?
Yep. Okay. Not disputing that.
And so within 30 minutes, we've got the vast majority of Braintree and all of Great Notley. So we're within a 30-minute cycle ride of a retail centre, Great Notley or the ones in Braintree, and a GP surgery, being either Great Notley or the one you mentioned yesterday in Braintree.
Yep, certainly if you're brave enough to do it, yeah.
So if we go back then to CS7 and paragraph 7.1.
Yeah.
For that definition of accessible locations will be defined as within 30 minutes walking or cycling distance of a retail centre, yes. A primary school, yes. Secondary school, yes. And GP surgery, yes. So for the purpose of that definition in the development plan, this is an accessible location.
Yeah, going by that. Yeah. 30-minute threshold. Yeah.
The bus service yesterday, I think you said that you make no issue about the quality of the bus service being that every 30 minutes.
No, I obviously accepted that it's reasonably frequent. It was just how usable it was for future occupants to, for example, access the primary schools or indeed the railway station in Braintree if people chose to use Braintree railway station as opposed to Cressing.
Okay.
Or Whittam, as we discussed yesterday as well.
If we go to paragraph 7.9 of the justifying text.
Yeah.
Black Notley is in the village, or categorised as a village in the settlement hierarchy, isn't it?
Sorry, say that again.
Black Notley is categorised as a village in the settlement hierarchy.
It is, yeah.
7.9, almost 30 villages. The core strategy applies the same definitions as the local plan review in the settlement hierarchy, doesn't it?
Yeah.
So when it talks about almost 30 villages, that would include potentially Black Notley.
It would, yeah.
Almost 30 villages have less than one bus per week to their local centre. So many people rely on community transport or family and friends to get about in order to access the services they need.
Yes.
Public transport is to be improved, it goes on.
Yes.
So compared to the provision in almost 30 of the villages of the district, Black Notley has a very high standard of bus service, doesn't it? Every half an hour.
Oh, I mean, it's a lot better, certainly. Yeah, it is a lot better. I'm sure people who live in London would balk at the idea of a half-hourly service, but compared to those 30 villages, or almost 30 villages, yeah, it's as I say, I didn't dispute yesterday the fact that it is a fairly frequent service.
We're not comparing Black Notley with Camden, are we, Mr. Tivy? We're looking at how sustainable Black Notley is by comparison to some of the other villages and settlements.
Yeah.
So that's not a fair comparison at all, is it?
Well, no, but all I'm trying to say, I think, I can't remember what term you use now, but
it's a very high standard of bus service in comparison to one a week.
Yeah, I mean, it's certainly high in comparison, definitely.
The terms of CS7, accessibility for all is in part about ensuring that it is accessible by car, that there were no issues with congestion and traffic. And there is no highways reasons for refusal here on that basis, is there?
So, sorry, where did you? Can you just repeat yourself? Because
I'm trying to go through a bit quickly, but I can take it in chunks and take it in stages. Promoting accessibility for all.
Yeah.
Within promoting accessibility for all, that obviously includes encouraging the use of sustainable transport.
Yes.
But it also includes dealing with car traffic, doesn't it? And we see that in the penultimate sentence. Traffic will be carefully managed to encourage sustainable travel.
Well, I mean, it's slightly vague, isn't it? But I mean, when this was written, you know, there was a situation of it's got maximum parking standards for residential development, and see, the perception at the time was that you know, that would dissuade people from owning cars and therefore use alternative means of transport. I mean, it says traffic and car parking will be carefully managed, but I mean, I think as a general rule, sustainable travel means means of transport other than the car. I mean, if you look at the last sentence of CS1, it talks about the promotion of community-based initiatives such as carpools, car share, and voluntary minibus services will be encouraged. So, I mean, quite clearly, if one was to car share, then that would be better from an environmental point of view than two individuals driving separately. But as we saw from the census data, the actual proportion of people who car share is very small in comparison to those that drive themselves to work.
Are you saying, Mr. Tivy, that this policy doesn't comply with the framework?
Well, I don't think.
Yes or no? Are you saying that it doesn't comply with the framework?
No, it does. It does comply with the framework. It talks about traffic and car parking being carefully managed to encourage sustainable travel. It doesn't say that. I mean, actually, you referred to congestion. Where's the reference? Oh, in the first sentence, it refers to congestion, but it talks about reducing congestion. I don't think encouraging people to use the car is going to reduce congestion.
It's not about encouraging. It's not about that, Mr.
Well, I think
perhaps I've introduced some confusion, which I hope to clarify now.
Okay, thank you.
Accessibility for all must include, mustn't it, those who, for whatever reason, can't take a sustainable mode and need to use the private car. Accessibility for all is a broad term which encompasses those circumstances too.
Yeah, I mean, certainly if you just take that heading, if you like, then yeah.
And there's no objection from the local highways authority on highways grounds to this scheme, is there?
Not on highway safety grounds, no. And
there's no objection to them on the basis of congestion, increased traffic?
There's not, no.
And there's no objection from the local highways authority in terms of sustainable transport either?
Well, Essex County Council's highway authority don't get involved in sustainability arguments. They tend to leave that to the local authority, particularly in Braintree.
Now, when we look at the policy itself, the term that's used, which is in accordance with the framework, is to encourage sustainable transport. You see that?
Sorry, can you just direct me again?
Sustainable travel will be encouraged through the requirements for travel plans, development, employers and institutions.
Yes.
So a travel plan is to be provided by this development, isn't it?
It is.
And that's part of the conditions.
Yes.
And so that part of this policy is complied with.
Yes.
So that the sentence up, future development will be provided in accessible locations to reduce the need to travel. We've agreed that this is an accessible location as defined in the justifying text. So,
well, purely in terms of the 30-minute walk or cycle.
Well,
yes.
No, we need to be clear here because accessible locations is defined in the justifying text, and then the same phrase, accessible locations, is used in policy, isn't it? Just there.
It is.
So when we look to understand what accessible locations means, we look to that part of the justifying text, don't we?
We do.
And you've agreed with me that this is an accessible location in accordance with that definition.
In accordance with that definition, without introducing material considerations, yes.
Yes. So we comply with that sentence, don't we, of the policy?
The strict letter, yes, you do.
Well, okay. We comply with the next section about travel plans. The next sentence: sustainable transport links will be improved, including contributions for cycling and walking and quality bus partnerships. There's proposals to improve the walk into the primary and secondary schools, aren't there?
There are.
So that sentence is complied with. We are improving the walking.
Yeah, I mean, you're certainly improving, but as I said yesterday, I think more. Well, I say more can be done. I don't think more can be done because of the limitations of the public highway, but there will certainly be an improvement.
There will be an improvement. Yeah, thank you. Traffic and car parking will be carefully managed to encourage sustainable travel. So car parking is a matter for reserve matters on this development, isn't it?
It is, yeah.
So there's currently no conflict with that part of CS7?
No.
The promotion of community-based initiatives such as carpools, car sharing and voluntary minibus services will be encouraged. Again, that may form part of a travel plan, so there's no conflict with that part of CS7 either.
No.
So when we go back through all of those parts of CS7, there is no conflict with the policy at all, is there?
Let me just read through the policy one more time.
Well, there's no conflict with CS7. Thank you. Very quickly, CD 7.8, please. Which is policy, and I want to look at policies SP1 and SP3.
Okay.
And SP1 seeks to apply the presumption in favour of sustainable development, which of course we've discussed to some extent when we look at the tilted balance. That's right, isn't it?
Yes.
And then SP3, which is on page 21.
Yes.
Development will be accommodated within or adjoining settlements according to their scale, sustainability and existing role. So that's the scale, sustainability and existing role of the settlement, isn't it, that we're looking at there? It is.
Yes, yeah.
Now, the scale of Black Notley has not prevented this council approving development coming forward within it, has it?
Well, I as far as I'm aware,
consent's been granted.
First for what's it been granted for?
If we go to page 26 of Mr. Carville's proof, please.
26. Yes. Sorry, is that paper page 26?
Paper page 26, electronic page 34.
Okay, and which paragraph?
So Black Notley's in tier 3, isn't it?
Well, it is in the draft local plan.
Black Notley's a village within the local plan review.
It is, yeah.
And the table at table 1.
So you're referring to the local plan review as opposed to the...
No, I'm referring to table 1 in Mr. Carville's proof.
Oh, table 1 is proof, right.
Which is on paper page 26, electronic page 34.
I don't have a table on Oh, sorry, I'm looking at the wrong. Apologies. I was looking at my proof. Right, I've got a table now. Table 1, approvals in small villages. Apologies for that. Right, so yeah, there's a list of settlements there.
So Cressing, when those consents were granted in 2018, 2017 and 2020, and in the adopted development plan, Cressing is a village, isn't it?
It is.
225 units and 118 units and 78 in a village.
Yes.
Earls Colne is a key service village.
Yes.
Finchingfield village.
Yeah.
Gosfield village. Great Bardfield's a village. Great Yeldham's a village, and so is Ridgewell. Yeah.
Yes. Yeah.
So this council grants consent in villages, and it grants consents, big ones.
It has done, particularly in many cases where there hasn't been a 5-year housing land supply.
Well, so that the scale of the settlement, so but the scale being it as a village, isn't preventing this council granting consent, is it?
Not in some other villages, no.
No. So as a point of principle, scale isn't preventing consents coming forward in villages.
No.
Sustainability. You've just agreed with me that in accordance with the plan, this is a accessible location. So sustainability in terms of accessibility is not an issue here, is it?
Like I say, I don't agree that it's a particularly accessible location, but purely in terms of the application of that policy and its supporting text in terms of the 30-minute walk or cycle, it complies. But as I say, clearly there are other material considerations which we discussed yesterday.
Okay, I've got your point, and we can make submissions on it. An existing role. You're not saying, are you, that if this consent is granted, Black Notley would no longer be a village?
It would remain a village.
Yeah. So in terms of SP3, development will be accommodated within or adjoining settlements. So adjoining Black Notley, according to Black Notley's scale, sustainability and existing role. There is nothing within that part of SP3 which would prevent this site coming forward.
Well, like I say, in terms of material considerations, sustainability, I don't want to keep going over old ground, but
understand that. But in terms of the policy, rather than other material considerations.
Yeah. But from the sustainability, purely looking at the supporting text to CS7, it would be deemed sustainable from an accessibility point of view, notwithstanding, say, the material considerations.
So, therefore, it complies, doesn't it, with this part of SP3? Let's put it the other way. There's no conflict with this part of SP3.
Well, I mean, I think ultimately, each case has to be assessed on its own merits.
Yes or no, Mr. Tivy? There's no conflict with this part of SP3, is there?
Well, I mean, like I say, that many of those other decisions were made within the context of a lack of 5
last
years
chance, Mr. Tivy. There's no conflict with this first paragraph of SP3, is there?
I'd say yes, there is.
You say yes, there is. Right. Okay. Well, we'll deal with whatever those conflicts may be when we get to submissions. Future growth will be planned to ensure existing settlements maintain their distinctive character and role, to avoid coalescence between them and to conserve their setting. I think we've got your points on that, and we can deal with it in submissions. But there is no issue with coalescence here, is there?
There's not, no.
And again, you're not saying that it wouldn't be a village if this is built out.
I'm not.
So the only issue between us is about conserving the setting of Black Notley.
In terms of that paragraph, yeah.
Yeah. And then the remaining paragraphs talk about the Section 2 local plan, which has been consulted upon, and the main what will be supported outside. So those final 3 paragraphs are really of no assistance to the inspector.
No, I mean, that sets the framework, obviously, for the Section 2 local plan for Braintree as well as Tendring and Colchester.
Yeah.
planning authorities.
So when it comes to SP3, the inspector just is looking at whether or not we are impacting on the setting of Black Notley.
Well, as well as the sustainability.
No, because you've agreed that it's sustainable. We've complied with the policy. There's another material consideration outside of the policy, isn't there?
There are other material considerations outside of that policy. Yeah.
So the only issue with SP3 is whether or not we conserve the setting of.
Well, I can't. Like I say, I don't consider the location to be sustainable in accessible terms, so I can't agree that it complies with that first paragraph of SP3.
Yeah. Okay. We've got your.
I've already said that. I've already said
that.
Yeah.
Density quickly. Layout is a reserved matter, isn't it?
It is. Yep.
So the indicative layout is an indication, isn't it? It's not saying that it will come forward in that form.
I agree.
And the layout will include consideration of density at the reserved matter stage.
Yes.
Just to clarify a point about calculating density, are you including green space when you calculate density? You seem to be when you looked at Mary Rook Way.
Yeah, I'm not including the community park, but the developable area that's cited by.
You did when you did Mary Rook Way. Should we do the same for our site?
Well, I believe. I mean, I worked out the density for your site based on the developable area, as was reduced following the Environment Agency objection. So I worked out density for the appeal site on a calculation of developable area and 80 dwellings. Obviously, I realise it says up to 80, but as I said in my examination, Chief, that can give rise to future problems. I accept they're future problems and not problems before us right now or issues necessary for the inspector to take into account. But my concern is the fact that the only reason that the description or the quantum of development was reduced from up to 90 to up to 80 was the fact that the developable area was reduced as a result of the increased flood risk zone from taking into account climate change that the Environment Agency highlighted. So
just on the answer you just gave then, the issue of, I think you said, the issue of density is not something that the inspector needs to take into account at this stage. Is that right?
Well, no, I think because I mean I can't remember the exact figure.
Yes or no, Mr. Tivy, and then go on to qualify. You just said density is not for the inspector to take into account at this stage.
I don't recall saying that. If I did, I apologise. I do think the inspector needs to take it into account because of the fact that it says up to 80 dwellings.
Right, and the reason that you say I think that it should be taken into account is because it leads to a reduction in garden size, so that it's an amenity issue, isn't it?
Well, amenity and character and appearance. As I say, that could be a more. And I know, from Mr. Holliday's evidence that density, the figure of density can be a slightly crude measure. Accept that. And obviously,
I'm going to pause you there, Mr. Tivy, because I want to move on, and I'm conscious of time. Okay. Your landscape evidence from Mr. Brown was that density is not a landscape issue. Are you now giving landscape evidence to the inspector and saying that it is a landscape issue?
Well, it certainly has an impact on the character and appearance of the area.
Not the question I answered. Your landscape witness said it is not density is not a landscape issue. Are you now giving landscape evidence and saying that it is?
Well, let me just give you an example before I answer.
Yes or no? Are you giving landscape evidence and saying that density is a landscape issue?
Yeah, I think density is a landscape issue. If there's one dwelling there,
stop there. Are you a qualified landscape expert?
I am not. No.
Is Mr. Brown?
Yes.
Did your landscape? So when the inspector comes to look at the view of the experts, Mr. Holliday and Mr. Brown, who say density is not a landscape issue, should she prefer the landscape experts or your unexpert view that it is now a landscape issue?
Well, I would urge her to follow the landscape witness, the council's landscape witnesses.
Right.
view, but from a planning point of view, as a chartered town plan, say character and appearance isn't necessarily. Let's put it another way: the impact upon landscape isn't necessarily limited. Now, what am I trying to say?
I think you got yourself confused. I think you're better off sticking to planning, Mr. Tivy, if I'm honest.
Okay. We'll move on from that then, if that's okay.
Quickly then, 7.21, the Essex Design Guide and garden size, just so that the inspector's got the correct reference. Page 75, electronic page 39.
Sorry, which document are you looking at? Because I've got the.
So 7.21, the Essex Design Guide.
Which year is that?
That's the 2005.
Okay, so I've got the hard copy in front of me. So which paper page did you say?
Paper page 75.
75, yeah.
Electronic page 39.
Okay.
Now, you've agreed that that layout is a matter for reserved matters, and that will also include the housing mix, won't it, and the size of the housing and where they go.
It will.
So we look at garden size, third paragraph says that 100 square metre garden.
Page 76.
Sorry, second paragraph. 100 square metre minimum garden size is easily achievable for 3 or more bedroom houses.
Yes.
And then there are circumstances under which the insistence on a minimum 100 square metres of garden size is not appropriate. See that?
Yes.
And that includes houses of 1 or 2 bedroom size where it's 50 square metres. You see that?
Yes.
Over the page. Houses backing onto or adjacent to a substantial area of well landscaped and properly maintained communal open space. You may have a reduction there. Of course, Coca space will be accessible, as will the community park. Yes.
Sorry, whereabouts is that? Which
headline? That's headed in grey blue. Houses backing onto or adjacent.
Oh, sorry.
To a substantial area.
Yes. Yeah. Sorry.
That may lead to a reduction. Yes.
Yes.
Houses performing a particular role in the layout.
Yeah, I mean that's talking about sort of corner turners, isn't it? I think.
Which may be an issue for reserved matters.
Yeah.
Flats, 2 or more bedroom flats, communal residence gardens must be provided on the basis of a minimum area of 25 square metre per flat. So again, further reduction.
Well, what do you mean reduction? I mean that's setting the standard, isn't it?
Your issue with gardens was that not everyone on your plan that you attached is getting 100 square metres. And the point I'm making is that's not the way you look at it. The Essex Design Guide gives numerous examples of where you don't need to give 100 square metres.
Yeah, I don't believe I ever said that every single unit should have 100 square metres.
Ah, good.
It was just highlighting the fact that those units that and it was taken that those with dormer windows would be 2.5-storey dwellings, and therefore 3+ bedrooms would have sub 100. I think on that, within my appendix, I believe it did highlight. It was slightly confusing, I have to say, but it did highlight where there were flats. It actually highlighted the flat buildings themselves in orange. Yeah, I mean, like I said, I accept that not every unit has to provide, even going by the letter of the design guide, not every unit has to provide 100 square metres. Depends on its size and typology.
And the reality of this is it can all be worked out in reserved matters anyway, can't it?
Yes, yeah, that's when the detailed layout would obviously be worked out.
So it's not an issue for this inspector determining the outline application.
No, not in terms of drilling down to the detail, but like I say, bearing in mind that the appellant has already changed the density limit sorry, the quantum of development. I think it does need to be taken into account when, I believe, and I can't remember the exact figure, but I think the local plan panel cited the site as taking 45 units. Obviously, that would be considerably less than 80.
Thank you. I want to move on just very quickly to deal with the benefits. Now, Mr. Carville is going to have a mea culpa moment and fall on his sword when he gets to giving his evidence, and agree with your calculations on affordable housing in your rebuttal statement.
Okay.
So the calculations you've put forward are, I think we are now saying, correct, in that there will be, on those calculations, 1771 affordable housing is provided in the next 5 years in your supply calculation, against a requirement of 1722
Okay.
for affordable housing. But that is dependent, isn't it, on everything in your supply coming forward?
It is, yeah.
And that is dependent upon everything in your supply delivering the number of affordable houses at a policy compliant rate.
Yes.
And they are two factors which may change over the course of the next 5 years. Some sites might not come forward fully, some sites cannot come forward at all, and the affordable housing commitments may evolve for viability reasons.
It may do, yeah. I mean, I have to say that as a general rule in Braintree District, viability doesn't tend to be an issue for affordable housing. But yeah, I haven't got a crystal ball, so I can't tell you what may happen in the future. So,
given those two potential variables, which you accept are variables, 1771 for a requirement of 1722 doesn't leave a great deal of wriggle room, does it?
Sorry, are you referring to a particular paragraph within my rebuttal?
So your supply is 1771 in your rebuttal.
Yes, yep.
And the requirement over the 5 years is 1722.
Um, 1772.
Bringing forward the undersupply.
Sorry, can you say where you're getting the 1772 from?
So a shortfall so there's affordable housing requirements of 218 per annum.
Yeah.
Times that by 5 gives you 1090.
Okay.
Yeah, you with me so far?
Yeah.
Plus the shortfall of 632, although you say 602.
Yeah. Yeah, I mean, I was just basing that on the freedom of information that was appended to Mr. Carville's proof.
So
Yeah.
let's be generous and take your 602.
Okay.
Add it to the 1090, gives you 1692 as a requirement.
Okay, I'll have to take your word for that because I haven't carried out those calculations.
And 1771 in your supply.
Yeah.
But that supply, of course, as with all housing supply, isn't guaranteed, is it? There are variables which we've agreed.
Yeah, yeah.
And so there's not a great deal of wriggle room within your supply to meet your requirement.
No, but I mean, it's a significant increase, all being well, of course. You know, it's a significant increase in supply over the the previous few years.
And in any event, the difference between you and Mr. Carville was, you say significant weight to affordable, and Mr. Carville said very significant.
He did, but I wonder whether he'll change that after he's fallen on his proverbial sword. But obviously, we'll find that out later.
Well, could have it's like EastEnders. We'll have it as a cliffhanger over the lunch break. Market housing, you give moderate weight to, because you say you've got a supply.
Yes.
If the inspector concludes you don't have a supply, then the weight must go up to significant, mustn't it?
Yeah, certainly more than moderate. Yes.
Well, it goes up to significant with no supply on your evidence.
Yeah. I'd accept that.
When you come to, if you go to your evidence, please, at 8.32.
Yeah. Yeah, highlight obviously that the amount of affordable housing would reduce due to the fact that the overall total number of units proposed is also reduced from the original the original proposal.
The moderate is where you say you've got a 5-year supply. It would be significant, you say, if you don't have a 5-year supply. Of course, your supply is only just over 5 years, isn't it? And that influences the weight that can be given to market housing.
It can, yeah.
And in order to maintain your supply, you need to grant more permissions.
Well, you do, but I mean, the Section 2 local plan should be adopted sort of in March or thereabouts, and then that will significantly the supply, because at the moment sites allocated within that but without permission aren't counted in the supply. But I have to say that's probably the extent of my knowledge on housing land supply, and I don't profess to be an expert like Ms. Carpenter is.
You're not relying on the LP2, are you, that is given limited weight?
No, all I'm doing is stating fact that in sort of 3 months' time or so there should be an adopted Section 2 local plan.
Right.
So
given that's got agreed limited weight. Open space.
Well, it won't have limited weight come March. Once it's adopted, it'll have full weight.
Well,
I realise at this point in time, at this point in time, it's limited weight. Yeah.
Yes. For this inspector, it's got limited weight. Open space, very quickly. You reduce the weight given to the community garden, community park because of, in part, a lack of surveillance, but I think mainly because of the flooding issue. Is that right?
Yeah. I think uncertainty over, whether it will be usable all year round. It could well be, and I can't say this obviously categorically, but bearing in mind that it also has a high risk of surface water flooding, that if it was used as well used as the appellants are, I think probably hoping it would be, then it could easily soon become a quagmire.
It's flood zone 3, isn't it? Which is 1 in 100 years. It is,
yeah. It's floodplain, yeah.
Yeah. Can you go to the framework, please? Page 75. Well, actually, starting on page 74, Annex 3.
74. Yep. Flood risk vulnerability.
Flood risk vulnerability classification. Essential infrastructure, highly vulnerable, more vulnerable, less vulnerable.
Yep.
Over the page, water compatible development.
Yep.
See that? Penultimate bullet point. Amenity, open space, nature conservation and biodiversity is a water compatible development. Framework tells us.
It does, doesn't it?
It does, doesn't it?
Mm.
So that doesn't reduce the weight that can be given to the community park, does it?
No, it doesn't. But yeah, I mean, the bottom line is, if the field's underwater, it's not going to give rise to any harm. I mean, that's the idea of the flood risk vulnerability classification, isn't it? Because you've got highly vulnerable, like caravans, mobile homes, police and ambulance stations, etc. Then you've got more vulnerable hospitals, dwellings, etc. I mean, it comes down to the risk. If the site was flooded for 6 months of the year, it's not going to be a significant risk. Well, unless it was like extremely deep, it's not going to be a significant risk to the future occupants, either of the development or the wider community. So no, I mean, like I say, due to the uncertainty, I would still give it limited weight.
Okay. Economic benefits, finally. Your point on economic benefits at your 8.33 is that less harmful sites can deliver these benefits. That's what you seem to say.
It is, yeah. Like I say, I'm not disputing the actual figures themselves. You know, I've got no reason to doubt that they're inaccurate. But yeah. Simply put, as well, you've put it. Simply put it for me. Put it simply.
So if
for
the
me.
inspector concludes no harms, then the weight will go, or more limited harms than you set out in your proof, then the weight would go up, wouldn't it?
Well, I don't know. How do you get to that conclusion?
Because you use harm to reduce weight, so if there's less harm, the weight goes up. Logic, I think.
Yeah, possibly.
Okay. Right, then finally,
I mean, I'm saying moderate. I'm saying moderate. It's not like I'm saying limited to it. So, you know, and it's perhaps sitting on the fence slightly, but I think that's reasonable.
Just to go back then to our basket of policies for completeness.
Yeah.
We only take the ones we conflict with. So RLP2 we conflict with, but you accept is out of date.
Well, like I said at the start.
No. We're going to be quick here, so it's going to just be yes or no. You've already given answers. You accepted RLP2 is out of date.
I've accepted that.
So that goes into the basket because we do conflict with RLP2. CS5, you maintain is not out of date.
I do.
We'll make submissions on it, but that goes into the basket because we don't comply with CS5. CS8 was the limited conflict, wasn't it, Jemba? Because we complied with the vast majority, and it was just about the issue of landscaping. So that goes in.
Yeah. Although you highlighted earlier on that the basket should only have policies that are conflicted against. So
well, if the inspector concludes the conflict, it goes in.
Yeah, well, I certainly think it should go in the basket. Yeah.
RLP 80. Again, is a limited conflict, and the question for the inspector is about integration with the landscape.
Yeah, it's a most important policy.
RLP 86, no conflicts now.
Well, we disagree on that.
CS7, no conflict with the policy, but you say there's a material consideration being the desirability.
Yes.
SP3, again, no conflict with the first paragraph of SP3. And the only issue for the inspector is whether the setting is conserved. And if she concludes it's not conserved, the development does conserve the setting of Black Notley, then there's no conflict with SP3, is there?
Well, if that's how the inspector concludes,
yeah.
But obviously we've already had a discussion about sustainability, haven't we?
Yeah. So in circumstances where we're dealing with a basket of RLP2 out of date, CS5.
Well, there's one policy out of that, one policy out of date in that basket. So I don't conclude that means that the development plan as a whole is out of date.
Okay, I thought you'd say that, and I'm conscious of time, so we've got enough for submissions, I think. So I will leave it there, Mr. Tibby.
Thank you very much.
Thank you.
Thank you, Mr. Robson. Thank you, Dr. Bowes. If you want to re-examine now, please.
Thank you, Madam. Yes, I should be able to complete this before lunch. There was just one topic, one question I wanted to give you an opportunity to deal with, Mr. Tibby. Right back at the beginning, you were being asked some questions about the concept of policies being out of date. Do you remember that?
Yes, I do, yeah.
In the context of the trigger and the framework for the tilted balance about the most important policies being out of date.
Yes.
And specifically, you were being asked questions about whether a policy was out of date because it was adopted against a housing requirement which is now defunct or withdrawn or not relied on anymore. Do you remember that line of question?
Yes, I do.
And in the context of that, you were being asked questions about RLP2 and whether that policy was out of date because it was adopted against a structure plan derived housing requirement which has now been withdrawn.
That's correct.
And you said along the line of answering those questions.
I don't want to interrupt my learned friend. Well, I wonder if we might be able to avoid it. There was a very specific answer from Mr. Tivy that RLP2 is out of date.
Yes.
I hope my learned friend's not going to go behind that.
Well, I certainly am.
About it being out of date.
With great respect to Mr. Robson, Mr. Tivy said before he made that concession, which Mr. Robson's right to record he did, he said, I'd like to refer to Daventry, and which is a document before you, madam, in the core documents, and is a court judgment on that point. And Mr. Robson said, no, in effect, that's a matter for submissions. Now, I can deal with this in one of two ways, madam. I can either deal with it in submissions, which I'm perfectly happy to do, but what I don't want to happen is when I make that submission, Mr. Robson says, oh, well, that's not fair, because you didn't go back to Mr. Tivy, and I'll have to recall him and put that point to him. So it's entirely in your hands, and to an extent Mr. Robson's, whether he's content for me to make that submission, which I will do, which is that that's not right, or whether he wants as a matter of form, as he's entitled to insist upon, that I put that to my witness and ask him to deal with it in re-examination and then cross-examine Mr. Carville on that point. Entirely up to you and him, really, how it wants to be dealt with. But it has to be dealt with one way or the other. I'm not going to let it lie, with great respect.
If that's how you, just looking at your additional legal propositions document that you put forward to the inspector, point 3 in Daventry, which is the correct understanding of Daventry, simply because settlement boundary and countryside policies have been breached in order to deliver a 5-year supply does not mean that those policies must be afforded little weight when a 5-year supply is demonstrable, is with respect, not the point that was agreed to by Mr. Tivy and not the questions which were put to him. It was that it has been overtaken by events and the settlement boundary delivers an old requirement. It wasn't about whether or not you're granting outside settlement boundaries or not.
No, I don't dispute that, and that's not the point that was put to Mr. Tivy, and that's not the proposition for which I'm reaching into Daventry. Simply that Daventry dealt with a number of things. It dealt with that, and it also dealt with the point that's put to Mr. Tivy. As I said, I'm happy to deal with it in a submission because that issue was canvassed in that case. Or I'm happy if Mr. Robson wants me to, as a matter of form, to go back to Mr. Tivy and give him the opportunity to deal with it. Simply one or the other. I'm not going to not deal with the point because I can't agree with it. I'm sorry.
I think it is a matter for submissions, ma'am. Mr. Tivy has given answers to questions on the basis on which I put them. Dr. Bowes is now seeking to give him questions to his witness on different propositions which I never put to the witness, which is not the purpose of re-examination. So he's seeking to both go behind a concession and to expand the remit of his re-examination to something not put.
No, not at all, madam. I'm simply going to put exactly the same question, and I'm perfectly entitled to re-examine on a point, even if a concession is reached. If a witness says I'd like to go to a document, he's not taken to it. I mean, that's par excellence the purpose of re-examination. So I don't accept that criticism at all. But really, it's up to you, madam, how you wish me to deal with that point. And what I don't want, as I said, is a complaint by Mr. Robson when I make the submission that I didn't deal with it.
So you're re-examining on the same point?
It was exactly the same question I was going to put to him. Yes, the concession was extracted. No, I don't think it was appropriate to say he couldn't look at the court document. Yes, I wanted to take him to that document, give him the opportunity to look at it and put that question again. That is precisely the purpose of re-examination, with great respect. It's not inappropriate in any way whatsoever.
Hopefully this is the last thing I'll say on it. Mr. Tivy went to the document. He started reading from the document that I'm assuming Dr. Bowes prepared for submission. Mr. Tivy then said he's not seeking to be a lawyer and interpret case law. And now it seems like we are going to go through a series of questions asking him to interpret case law and apply it to answers he's already given, which is a matter for submissions if that's the way Dr. Bowes wants to go. Mr. Tivy has agreed RLP2 is out of date.
And
that's the end of the matter.
But I do not accept that concession was properly obtained, because the document that Mr. Tivy wanted to go to, he wasn't given the opportunity to look at it. He said he wanted to look at it, and he wasn't. I appreciate my learned friend rattled him through the questions. I know these things happen, but that's the function of re-examination or a submission. So, with great respect, I have to deal with that point. And by the sounds of it, Mr. Robson would not object if I deal with that purely by way of a submission. I've understood him correctly.
If you want to deal with it in submissions, of course, that's a matter for you. What you can't do is seek to go behind concessions which your witness has given.
Well, I can if they've not been fairly obtained, with great respect.
Mr. Tivy went to the document. He had time to look at the document. He said he's not a lawyer, and he said he's not seeking to interpret case law. So he gave me planning evidence in response to planning questions put to him.
Right. Okay. I can remember the line of questioning. It's correct that Mr. Tivy is not a lawyer, but as a planner, he does also have to interpret case law, and I think perhaps he didn't really get a proper opportunity to answer those questions. So I'm going to let Dr. Bowes to go back on, ask his questions in re-examination.
Thank you very much. Thank you.
Thank you, Madam. One of the sad consequences of what the Supreme Court did in Tesco and Dundee is to make all planners into lawyers and all lawyers into planners, unfortunately. But if you could, Mr. Tivy, turn up document 516, please. 516.
Okay, it's just opening.
Thank you. This is the, should be the Gladman Developments Limited and Daventry District Council Court of Appeal judgment.
Sorry, can you just pause one moment? For some reason, I must have accidentally closed my core documents, and I'm just trying to find them again. Sorry, it won't take long. Okay, just remind me of the number again, please.
516, please.
Okay, thank you.
516, one of the issues in this case was considering some local plan policies, and they are recorded in the judgment at para 9 and 11. So if you would first look at those just to see what we're talking about. Para 9 first is HS 22, which was the local policy on restricted infill villages.
Yes.
Just cast your eye down there. And then paragraph 11 saved local plan policy HS 24.
Yes.
Yeah. And then with those in mind, if we could zoom down the document, what's then said about them, to paragraph 41, please.
Okay, yes.
And here, the argument for, as it happens, Gladman's advocate is recorded. It says, are you there, Mr. Tivy?
I am, yes, thank you. I've got a paper copy of those pages.
And it's the first bit of 41. I just want to draw to your attention, in particular circumstances case, Mr. Kimberlin submitted one, that the facts that policies HS 22 and HS 24 appeared in a local plan for the period 91 to 06, long in the past, and were tied into the structure plan, in particular in relation to HS 24, as set out in the explanatory text of 4.97 of the local plan, which is now defunct, meant that very reduced weight should be accorded to them. And then I do not accept these submissions. And what I want to do with you, Mr. Tivy, is just invite you to read paragraph 42. where the court gives its opinion about that argument.
Okay, all of paragraph 42?
If you were just yourself, and then I just have a question for you at the end.
Oh, just to myself, sorry.
Yeah, that's not allowed.
Okay.
Thank you. Now, the question for you, Mr. Tivy, is now you've had an opportunity to look at Daventry, do you remain of the opinion that RLP2 is out of date because it was adopted against a housing requirement in the structure plan that's now been withdrawn?
I do not consider that it's out of date based on that case law, which is the point, obviously, I was trying to make in cross-examination.
Thank you, Mr. Tivy. That was my only question. Thank you very much, madam, for allowing me to do that.
Thank you very much. Thanks, Mr. Tivy. You've been on the stand a while.
Thank you.
I hope you managed to get some rest over lunch.
Thank you.
Okay, so it's coming up to 1 o'clock. I'd say that we if we adjourn now and resume at 2. But beforehand, are there any procedural matters that you need to ask me about?
No, thank you,
ma'am.
Okay then. All right. Thanks very much. We'll go to the appellants this afternoon at 2 o'clock. Thank you.
Thank you very much.
Well, yeah, I've given up that as well. But again, that was just I just stopped.
Should we put the biscuits?
Yeah. You can't see the mince pies as long as they're out of view. So we
Good afternoon. It's 2 o'clock, so we'll resume the inquiry now with the appellant's planning evidence. I hope you all managed to have a good lunch, and I'm hoping that we won't go for any more than an hour and a half before we take a break. Okay, so thank you, Mr. Robson. Over to you, please. Are you mute, Mr. Robson?
but sorry, Matt, we were having some technology problems then.
Okay, no worries.
Right, Mr. Carville, if I could introduce you, please, from your proof of evidence, your Section 1 preamble.
Yes.
You are Stuart Carville. You've got a master's degree in Town and Country Planning from the University of Manchester, and you're a chartered member of the RTPI.
That's correct.
Yeah. And then you tell us that you're employed as a planning director by Gladman. Prior to that, you worked at Manchester City Council, having therefore experience in the public and private sector.
Correct.
And that you're responsible for seeing strategic housing development sites through the development plan and planning application process for Gladman developments.
That's right.
Thank you. And you tell us in your statement of truth the proof has been prepared and is given in accordance with the guidance of the RTPI, and that you confirm the opinions expressed are your true and professional opinions. And I would hope that that is still will remain the case.
It will.
Good. Right. I'd like to deal first with the tilted balance in paragraph 11 of the framework. And it's your evidence that the tilted balance is engaged. Why do you say the tilted balance is engaged in this case?
The tilted balance is engaged for the reasons we discussed in the housing land supply roundtable, that if there is no 5-year housing land supply, the framework dictates that the most important policies for determining the application are out of date through paragraph 11. Paragraph 11 also tells us that where the most important policies for determining application are out of date, you should grant planning permission unless adverse impacts outweigh the benefits. And in this case, I say CS5 and RLP2 are out of date. And I don't say they are in the case of RLP2, I don't say it is out of date simply because it is time expired. The reason that I say that it is out of date is that it has been overtaken by events in terms of RLP2 was drawn to accommodate the housing need of the structure plan. The plan has moved on and the housing requirements have moved on. And in order to accommodate the housing requirement now, that cannot be accommodated within the boundaries of RLP2. As a consequence of RLP2 being out of date for that reason, the council has itself allowed planning permissions outside the boundary. But that is not why I say it is out of date. I say it is out of date because it relates to a housing requirement that's no longer applicable and has been superseded, and events have moved on since that policy was adopted as part of the development plan. And so within my overall planning balance that we'll come to later, I imagine, I give that policy limited weight because it does remain part of the development plan. I don't simply disregard it because it's at time expired. I give it limited weight for those reasons I've just explained.
Thank you. I mean, you gave a very full answer there, and the question was about why the tilted balance was engaged. You said no 5-year supply. Was there a second? Was there a second gateway or second key?
So as part of are the most important policies for doing application out of date, and in my view, CS5 and RLP2 are the most important policies and go into the basket of the most important policies. And in my view, they are out of date for the reasons I've explained.
Thank you. What about the other policies we've been discussing? So, first of all, CS7, does that go into your basket of policies?
The development complies with policy CS7, so no, because where there's accordance with a development plan policy, you grant planning permission.
Thank you. CS8, does that go into your basket of policies?
No, because I think the issue between myself and Mr. Tivy and the council's case is that that's one about integration, and in my view, and supported by the evidence of Mr. Holliday, that there is no conflict in that regard. So in my view, there is no conflict, or there's compliance to that policy, and therefore it's not one of the most important policies for determining the application at this appeal.
And then RLP 80.
I think that the effect similar is about integration and setting. So again, I see no issue with that one. With noting that policy, RLP 80 is from the time expired, if you like, plan. But as I say, I don't disregard it because it's time expired. Sorry, I don't disregard that policy at all. I say that we are compliant with it. Even though it is a time expired policy, it remains part of the development plan and can be consistent with the framework. So there is no conflict with it, but I haven't given it any less weight due to its age.
Thank you. And finally, SP3, is that in your basket?
No, again, I think the difference between us, as agreed by Mr. Tivy, was again one about integration and setting of the settlement.
Thank you. Now you've explained to us why RLP2 is out of date. The only other policy that you say is within the basket of policies most important to this application is CS5, and you've said that you consider that to be out of date. Why do you consider CS5 to be out of date, please?
CS5 is relying on those town development and village boundary and envelopes, which is the basis of RLP2. And as Mr. Tivy was taken to in his cross-examination earlier, the core strategy relies upon those exact policies in order to determine where those boundaries are. And then that policy talks about protecting and enhancing landscape character, which is a different wording from that is taken now in the MPPF with about recognising the intrinsic beauty of the character of the countryside rather than a straight up protect.
You said that CS5 is out of date because it is dependent upon RLP2, and also that it's out of date because it's not consistent with the terms of the framework. Are those two reasons independent of each other? So in other words, could it be out of date for one, or can it only be out of date if both are correct? Shall I rephrase that question?
If you like.
Well, no, if you'd understood it, then carry on. I just thought it might have been not phrased very well.
You have to read the policy as a whole, but if the policy is out of date, I guess there's only one test about the dateness. If it's out of date for one, it is out of date. If the policy is out of date to start with.
Okay. And finally, just on CS5 and RLP2, Mr. Tivy agreed on RLP2 that it was out of date whether or not the council demonstrated a 5-year supply. Would you agree or disagree with that statement, from that agreement from Mr. Tivy?
I would agree they're out of date on either scenario, yes.
Thank you. I'd like to move on to sustainability. Now, I think following Mr. Tivy's evidence, there is agreement that the scheme complies with the policy on accessibility in CS7, and that the issue between us is about the desirability of the walking route from the development to the primary school. So only that journey, development, primary school, issues with walking that route with small children, I think was Mr. Tivy's concern. So it's not about policy compliance, but about desirability, and desirability only in the context of that journey to the primary school with children. How do you respond to that, please?
First and foremost, the starting point is the development plan. And when we read the development plan and when you assess the appeal proposals and the appeal site against the policies, and in particular policy CS7, I think Mr. Tivy agreed that we comply with all of those 6 or 7, 6 elements of that policy. So I think Mr. Tivy was inviting the inspector to consider the policy and then and go through a material consideration as to why the site didn't comply with the policies. Sort of my understanding, but he obviously agreed that we did comply with the policy. So the starting point is the development plan. We comply with the policy as agreed by Mr. Tivy, and that is about promoting accessibility for all. And it doesn't say people who may perceive a route not to be appropriate for them and therefore development should be refused. It says it's about promoting accessibility for all, and how people choose to do that is up to them. And whether they from the appeal site, there was a range of options available to them within the parameters expected of the supporting text about with those access to it within 30 minutes by walking or cycling to those 4 key facilities. So I consider that as Mr. Tivy did, that the development complies with the policy as it does promote accessibility for all. And I think he raised concerns about congestion. There are no severe highway impacts or any issues that the local highway authority has identified with any key junctions as a result of this development. So that piece of the policy is complied with. And then it also goes on to talk about reducing carbon emissions and congestion regarding climate change as part of the conditions proposed, and it also comes into law next year, is regarding providing electric vehicle charging points that will be provided by the appeal site. And so in terms of climate change objectives, everyone who lives on this site will be able to have an electric car hooked up to their house and be able to commute emission-free at point. So if it's regarding climate change, that issue is therefore satisfied.
Thank you. I just briefly want to consider the walking route to the primary school. And Mr. Cronshaw's evidence yesterday was that with the works being provided, that walking route complies with the manual for streets. If the inspector agrees with Mr. Cronshaw, that the walking route does comply with the manual for streets, what does that say about desirability?
It says that there is an appropriate route that can be taken, and there is a desirable route that can be travelled from the appeal site to the schools.
Thank you. And CD 4.1, please, at page 10.
Page 10, did you say?
Yes. Of CD 4.1, which is the consultation responses for document.
Yes, I have that.
You have that, ma'am. Thank you. We see this as a consultation response. Essex County Council, who are the local highways authority, 23rd of June 2021. The final sentence of that first paragraph, look at that paragraph as a whole. Application is accompanied by a TA. That's been considered. The Highways Authority's overall assessment, the planning application, the accompanying transport assessment was undertaken with reference to the MPPF. Then it's this section. As its remit, the Highway Authority has considered the likely impact of the proposal on the local highway network in terms of safety and capacity, as well as whether it would be accessible by more sustainable modes of transport, such as public transport, cycling and walking. Now you recall that Mr. Tivy in his cross-examination said that he didn't think the local highways authority considered sustainable modes of transport. Given what's said in that paragraph, what do you say in response to that?
It's quite clear that the local highway authority have considered all forms of movement from the site, be that vehicular, cycling, walking and public transport. It's quite clearly considered that in their consultation response, and they have no objections to the scheme, and they are satisfied that all the site can be accessed by all sustainable modes.
And if we go over the page, the second paragraph, subject to the below requirements, the Highways Authority is also content there are opportunities for those travelling to and from the proposal site to do so by more sustainable modes, such as public transport, cycling or walking. The requirements below are the conditions. Are they all being provided or not?
They are.
Thank you. Your proof of evidence, please. And I'd like to go to the section where you consider the RLP suite of policies. Which start, we've dealt with RLP2, RLP 80 and 86. I think we've dealt with Mr. Tivy. Forgive me, actually, it's not within. You'll have to bear with me. The other policies within that, the local plan review, so 49, 52, 53 and 55 relating to sustainability. How does the appeal site stack up against those?
Sorry, I'm a bit lost. Which policies are we looking at?
There's some other sustainability policies which have probably relevant only tangentially, and I don't think there's issues of dispute between us. But RLP 49, 52, 53, and 55.
Okay, which do you know which CD document that's in?
That is in CD 7 point. Bear with me. 7.3, I think it is.
Thank you.
Sorry about that, ma'am. Which is Chapter 5, Transport. And RLP 49, Pedestrian Networks. Mr. Carvel, any issue with RLP 49?
No, I think it's an outline scheme, and then so the details of design and layout, I think we've agreed form part of the reserve matters. The access point has been designed to incorporate pedestrian networks, and that's an approved drawing before this inquiry, which the local highway authority and the local planning authorities raised no issue with. The policy goes on to say this will include provide appropriate links to other land uses and developments by securing safe, direct, convenient and fully accessible pedestrian networks. Improvements to existing pedestrian routes will be sought through planning obligations where appropriate. And in my view, the appeal scheme is doing all of that. It is improving links by making them safe, secure, direct and convenient by upgrading them with access to the edge of Braintree and primarily the schools.
And then RLP 50, slightly further down, the District Council will support and encourage measures aimed at improving public transport and providing new public transport routes, including improved waiting facilities.
You said 50 there, do you mean 52?
52, I said. Did I say 50? 50?
I had 50, sorry. Just to clarify which policy you were looking at.
Yeah, RLP 52.
Yes, so again, with that, as part of the appeal scheme, we are providing and upgrading the waiting facilities and shelters at the bus stops nearest to the site, which we agreed yesterday were 265 metres from the site's centroid. We are providing, so we would comply with that policy in that regard, yes.
And then RLP 53 is about major development only being permitted where direct public transport services exist.
Yes, the thing agreed with Mr. Tivy, and in discussing the round table, there's a good bus service from this site, and it asks that normally a maximum of 400 metres in the second bullet point, normally a maximum of 400 metres from the centre of development. As I just explained there, we are 265 metres from the centre of development, so we're actually, doing better than the policy expects in that regard with regard to RLP 53. So, I mean, there's positive compliance in that regard.
Thank you. And then finally, RLP 55 about expecting travel plans, and that's something that's secured, I think, by condition.
54 is talking about transport assessments.
55, I said. I definitely said 55 that time.
Sorry.
Mr. Carl.
Sorry.
Yes,
agreed. Yes, agreed. One will be produced as there's a framework travel plan submitted with the planning application with the objectives to be secured, and a detailed one will be submitted, and that is also secured through condition.
Good, thank you. So in terms of policy on transport and accessibility, what conflict, if any, do you say there is with any of those? There's
no conflict, and I apologise, Ma'am, that they aren't referenced within my proof of evidence, but it's because none of them feature in the council's reasons for refusal. So I took them as to be not in conflict, and therefore, as I just explained there are no conflicts with them, and I think the local authority takes the same view as me there, given they've not referenced them in the reasons for refusal.
Thank you. Now I'd just like to look at the development plan and Black Notley and villages. Now we accept that obviously it's clear that Black Notley is within the villages category of the adopted development plan. Does Black Notley being in a village or prevent development from coming forward, or has it prevented development in other villages coming forward?
It's not prevented development coming forward in other villages. The council itself and planning inspectors have granted development outside the town and village boundaries.
Thank you. And that's for reference, ma'am, page 26 of Mr. Carvel's proof. I think that's right, isn't it, Mr. Carvel? There's a table.
Yes, and as I think I explained yesterday in the round table, that Earl's Colne reference, Earl's Colne appears twice, and that is a key service. It is a village, but it's a key service village. But Cressing, Finchingfield, Gosfield, Great Bardfield, Great Yeldon, Ridgewell are certainly in the lowest tier where development has been granted. And in the case of some of those settlements, particularly Ridgewell, which I reference on the next page at 537, is that the council has gone on to propose allocations within tier 3 settlements. So in its own view, they cannot be unacceptable locations for development. And as I expand on on page the internal pagination 27, Ridgewell has much more limited services than or access to services than that of Black Notley. There is only one bus a day, and that purely is a school service. So in terms of accessing top tier settlements by sustainable modes, there is simply no prospect of that, given its distance to other settlements and its public transport offering at the moment. There is no prospect of that from Ridgewell. However, the council deems that it's an appropriate location for an allocation and permitting development itself, as I explained in table 1, which doesn't chime with what their view of the appeal site is.
Thank you. Looking at the harms then of the appeal scheme, what do you say are the harms that the inspector should take into account?
Changing of a site from that of a greenfield to that of built development is a harm. I accept that's a harm. There's a landscape change. There's an urbanisation of those fields. I don't obviously agree that it's a valued landscape. I do consider there'll be environmental improvement on the site, given that currently it's given over to horticulture, and the quality and condition of that isn't brilliant. And therefore there'll be an improvement in appearance of the site. But with included in that, we can come on to is about net gains in biodiversity and landscaping. With other harms that are considered within the framework, there are things such as impacts on heritage assets. There are no heritage assets within the vicinity of the site that are impacted, and that's a point that's agreed with the council. So the harms relate primarily to the development of basically two small field parcels. But the greenfield sites are an inevitability, as the council have accepted by inspectors, by developing outside the town boundaries, and those development boundaries need to be revised to accommodate the growth of the Part 1 local plan as well. And for the council to maintain it, simply for the council to maintain or even have a 5-year housing land supply, it has to deliver sites on green fields.
Thank you. Benefits of the scheme. So I'm looking at your summary on page Roman numeral 4 of your proof of evidence.
Is this in the executive summary you're going to?
In the executive summary, yeah. And I'm looking at Roman numeral 24. It said, I consider the following weight should be given to matters in this appeal.
I have that, yeah.
Taking those in turn, what weight do you give to affordable housing?
With regards to the conversation we had with Mr. Tivy earlier, I accept that there's significant weight. Sorry, I've listed there very significant weight. Given the evidence that Mr. Tivy has given regarding the backlog and the future supply, I can agree with him that there is at least significant weight that should be done it rather than very significant weight. But that is reliant upon every single site coming forward in the council supply at the rate they expected. And obviously I have some doubts as to whether that is going to happen based upon the evidence that they have provided and we discussed in the round table. But within that, I included the Freedom of Information Request Appendix 2 to my evidence, which demonstrates that there is a high level of need for affordable housing across the whole district, including 12 households. That's not just 12 people, that's 12 households looking for an affordable property within Black Notley. And that's somewhere that they want to live and create a home for someone who is in housing need. It's not just someone on the housing register. For clarity, it is someone in defined housing need. And I go on to talk about the weight to be given to public open space through the community park. The site, the site's going to provide, I think it's agreed with Mr. Tivy, in excess of the requirement of the local plan policies. There is adequate provision on kind of in the built development for children's play area, and that's agreed. And then anything through the country park community park, is in excess of that requirement, and I consider that's a benefit should we give significant weight. Access and leisure opportunities are kind of key in terms of mental health and well-being. So for that reason, and also in accordance with policy RLP 86, which seeks to promote recreational activities on the river floodplain, I consider that's a significant benefit of the scheme.
Thank you. And weight to market housing.
Yeah.
Is that you give it their significant weight?
Yes.
Is the weight you give to market housing dependent upon whether or not there is a 5-year housing land supply?
In this situation, no, I would still retain its significant weight. The council has acknowledged that I discussed it with reference to Hatfield Peveril further later in my evidence at section 5, from 5.3.10, and the council talks about maintaining a throughput of a throughput of housing sites to maintain a 5-year housing land supply. And in that decision that it granted locally at Planning Committee on the 3rd of August 2021, when it considered it had a 5-year supply, it still gave weight to the housing in order to maintain that throughput of sites. And I think, well, in my view, that is with regard to the fact that not all sites in the council supply are going to come forward, and therefore it needs to continue to top up that supply. Market housing is the lead event, if you like, the leader for affordable housing to come forward. So the council isn't going to be able to deliver its affordable housing need or its backlog simply through delivering affordable housing schemes. There are no plans for masses of affordable housing rural exception sites, and by the nature of rural exception sites, they are small and limited generally to about 10 dwellings. So the market housing is required to deliver that affordable housing. So the market housing, I maintain, should be significant weight because it is delivering a key attainment of the NPPF, but also enabling the delivery of affordable housing.
Thank you. The final one there is biodiversity net gain, and Mr. Tivvy's evidence was that, well, we don't know whether or not this is going to happen. Could I take you please to CD 2.1?
Yes.
And let's introduce the document. So it's page 1 of that. We see this is from FPCR, the ecological consultants, and it deals with, see from the opening paragraph, below information provides the results of additional riparian mammal surveys, the biodiversity net gain exercise, and details regarding the reptile mitigation strategy. That tells us what's in this letter.
It does, yes.
Page 2 at the bottom, you see a subheading biodiversity net gain.
I see that.
Sorry, Marmy, you have the document?
Yes, I do. Yes, thank you.
Thank you. And then paragraph 3 over the page on page 3 gives the conclusions of FPCR. The results of the initial BNG assessment demonstrates the scheme in its current outline form will lead to a total net gain of 3 units, brackets plus 10.54%.
I see that.
See that?
Yes.
So that's the consultants to Gladman saying we can deliver just over 10% BNG. If you go next, please, to CD 4.1.
Yeah.
And page 25 electronically.
I have that. Yeah.
Thank you, ma'am. And that we see is a letter from Place Services. You see it says, Dear Matt, thank you for consulting Place Services on the above application.
Yeah.
Scroll down to the 3rd page of the letter, to electronic page 27. There's a subheading in bold: soft landscaping and measurable net gains for biodiversity. Second paragraph, we also note the ecological statement, FPCR 2021, that's the letter we've just been to, includes a biodiversity net gain assessment, which is supported by the DEFRA metric. It is indicated that we support the details contained within, which demonstrates that there will be a percentage increase for habitats of 10.54%, and a percentage increase of linear features of 30%. This demonstrates that measurable net gains for biodiversity will be delivered, as outlined under paragraph 170D of the NPPF. In addition, it is indicated that development will be in line with the emerging, which is now the Environment Act, not in force, which may require a mandatory 10% BNG in new developments.
I see that, yes.
So taking those points, what to you appears to be the council's position with regard to the provision of biodiversity net gain?
My understanding is the council accepts that the site can deliver a biodiversity net gain on the site, as supported by its consultee.
And what weight do you give to that?
As per my evidence, I give it moderate weight.
Thank you. Now, taking all of those, so one final point on deliverability of the site. You provide evidence of Gladman's track record in bringing sites forward to consent and then to being built out.
Mm-hmm.
How do you say the inspector should take that into account?
Gladman has a track record of delivering sites in Braintree itself. Gladman is not a house builder, but we bring sites to the market that can deliver quickly through the parameters that we've secured at outline stage. And as you'll see, that I think is demonstrated by these reports and consultation responses, that an awful lot of detail is provided to enable the house builder to be able to submit a reserve matters application and get on site quickly. So even though Gladman's not a house builder, we bring sites to the market quickly, and in the conditions we have suggested that there is a rather than a standard 3+2 condition, 3 years the outline and 2 years the reserve matters to be submitted. We say it should be a 2+1 to ensure that the site comes forward quickly, and a scheme of 80 dwellings can come forward quickly, given that those 80 units can be delivered within the next 5 years in its entirety.
Thank you. So taking all of those benefits you outlined and the limited harm, if the tilted balance is applied, either because of no 5-year supply or because the basket of policies is out of date, where do you say the balance falls?
Squarely on the grant of planning permission.
And if the tilted balance, I know you don't agree with this, but if the inspector were to conclude the tilted balance does not apply, how does the balance fall?
In my view, you can undertake a flat balance, which the council does with reference to that Hatfield-Peveril decision, and that is included in the core docs, the council's committee report. Even in the council's case, and I undertake a similar balance, is that when you do a flat balance, the benefits outweigh the harms within the development plan, and therefore I still say grant planning permission as a result.
Thank you. Thank you very much, Mr. Carville. If you wait there, there'll be questions from Dr. Bowes.
Yeah, I've just got a question about the biodiversity net gain, please. So I can see that that you did a biometric calculation. I've not looked at that in detail. But in terms of planning policy, is biodiversity net gain, is that a benefit or is it simply a requirement for policy? If you could just answer that in terms of the policies that exist.
In terms of my understanding, in terms of policies within the development plan that are referred to, net gain primarily comes in through the Environment Bill. So on the what's considered the most important policies, or the relevant ones that are agreed as relevant within the Statement of Common Ground, I can't see that precise wording of net gain is written. As I say, it comes through. It will become a requirement through the Environment Bill when that's enacted.
And how about the framework?
I believe the framework seeks gains in biodiversity.
Okay. It does, yeah.
I don't have this. I don't have it in front of me.
Okay, yeah, it does in paragraph 174. So my question really was about benefits, or because you want to, you're asking me to attach weight to certain things, including biodiversity.
Yeah, I think I can address that. Yes. In terms of an overall package, if you like, when we're looking at everything that the development provides, if it is a policy requirement, it doesn't necessarily mean that it's not a benefit. I can deal with that in two ways. One being, I'm taking this as a consideration of your question, Ma'am, about benefits, rather than, I'm going to address it sort of in two parts. Is in terms of one, for example, of affordable housing, that's addressing a pre-identified need and people. So it's not, it's addressing a pre-identified need. For example, us providing improvements to the walking infrastructure, policies seek that, and it is a benefit that is only realised as a result of development. And I think that is the same with the net gain in biodiversity. You can only have a net gain by enabling something to happen.
Okay, all right, thank you.
All right for me to start, madam? Yeah, thank you very much. Good afternoon,
yes.
Good afternoon, Mr. Carville.
Good afternoon.
Would you have the framework to hand? Because I think you said you didn't have it to hand. We are going to go to it in a few places this afternoon. So if it's not with you, would you mind?
I have it now. Yeah.
Oh, fantastic. Very good. I wanted to start though with the development plan, if I may, and just to check where you stand with your written evidence. Because in your evidence just now, as I understand it, you were saying there was no conflict with policy CS8. Is that right?
Yes, because the policy CS8, let me get the copy of CS8 before me. So I think it was agreed with Mr. Tivy and his evidence that the only thing essentially between us, I think, is the fourth paragraph, which starts in terms of policy CS8, which is developments must have regard to the character of the landscape and its sensitivity to change. The application was accompanied by a landscape and visual assessment. Within that, it considered the landscape character sensitivity, and Mr. Holliday has given further evidence on that. And so I think that the only issue was between myself and Mr. Tivy and the council was therefore whether whether we accorded with that, and in my view that we do.
All right, so are you changing what you've written at 7.3.18 in your proof then, page 47? I therefore accept some conflict with policy CS8, but consider this very limited harm is more than outweighed by the benefits of the scheme in other instances. You're now saying there's no breach of that policy.
Sorry, where did you refer to my evidence?
Sure. So page 47 in your proof, Paris 7.3.18. I accept some conflict with policy CSA. Is that a change?
No, I think that's in reference to given the site is greenfield, in the round considering that to be natural environment, excluding any points about what's currently on the site, there is, except a sort of a very minor conflict within that regard, and I think that's a fair characterisation of that. And Mr. Tivy accepted compliance, although save for that one point we've just discussed. Whereas I'm fairly happy to accept that there is a minor conflict within regard to that point. Right.
So what you say at 7.3.18, and then you summarise in the next paragraph, I accept conflict with the location policies of the development contrary to CS5 and policy CS8 of the core strategy. You're sticking with that. It's still your evidence, is it, Mr. Carville? No change to those paras.
Yeah, no, I think that's fair, because you have to, as I described earlier, you have to read the development plan as a whole, and the policies that you read CS8 alongside CS5, which refers to all the other policies that we've discussed earlier. So I consider that policy as part of the development plan. I haven't disregarded any of those policies, and I've explained why I give things less weight.
Sure.
And so that's why I consider that if there's any harm arising, its relation to the countryside part of that and the natural environment, which, as I was explained with policy CS5 and RLP2, I don't consider to be up to date.
Okay, sure. Let's just take it in stages then, Mr. Carville, because step one is to look at which policies are relevant. Agreed? First process?
Yes.
Yeah. Step two is to see which of those policies are accorded with and which of them are breached. Agreed? Next step.
Yes.
Yeah.
Yeah.
Step after that is to decide what weight to attach to any conflicts. Yeah.
Yeah.
And then carrying on, the next step is to come to an overall judgment about compliance with the development plan as a whole. Yeah.
Yeah.
And then if there's not accordance with the development plan as a whole, you ask yourself whether other material considerations justify deciding the scheme otherwise, such as the application of the tilted balance, for example. Yeah.
You can do that, yes.
Well, that's what the law says, isn't it? Yeah. Okay.
I'm not a lawyer, but yes, I'm have to agree with you on that.
I appreciate you're not a lawyer. No one's perfect, Mr. Carville, but you do know what Section 38(6) of the Planning and Forestry Purchase Act says, I certainly hope.
I do.
Good. There we are. Now, I'm starting right at the beginning, because I'm a very simple person. I'm not a clever person like planners. And the first step in the exercise is to decide if a policy that's engaged and relevant, and we both agree that CS8 is engaged and relevant, don't think that's in dispute, is breached or accorded with. Then we get on to weight and other things afterwards. And I just wanted to pin down whether you're saying it's breached or you're saying it's accorded with.
I think the Rain Road inspector is useful in this regard.
How on earth is another inspector's judgment about a proposal on another site relevant as to whether it's breached in this regard? Maybe relevant about weight, maybe relevant about consistency, but I mean, I'm not going to stop you if you want to take me to that decision, Mr. Carville, but I can't see how, with great respect, what that inspector thought about compliance with that scheme and that policy really helps this inspector with this scheme and this policy. Just dealing with breach or conflict.
Because the policies,
Mm.
the policies are the policies of the development plan.
Yes.
You have to read the development plan as to where they apply.
Sure.
And so the council's evidence is, and my understanding of the development plan is, that when you were, if you like, stood inside the envelope of a settlement, you're within the town and village boundary, and when you're outside of that, certain policies apply, which is policy RLP2, for example. So if one imagines oneself either on the appeal site or within the existing development of Black Notley, or be that on the Rain Road appeal site, or on the main road, or whatever it may be, one considers where that policy applies.
Okay, sure, but can you just answer the very simple question? In your professional opinion, is policy CSA breached or accorded with by this project?
So I'm just going to find. At my 7380, I accept there is again some harm, but that's the change. That's the change in the site. So I accept there is some breach of that policy with regards to CSA. Yes.
Lovely. Okay, take it in steps. So you accept there's breach of the policy, but we're going to come on to what you make of that in the overall planning balance. Okay, but just taking it step by step, your judgment is there's a breach of CSA. Tick. You then explain, because of the location of the scheme outside the settlement boundary, and it's not a countryside use, there is a breach of CS5. Understand that's still your evidence.
Mm-hmm.
Yeah. You also say 7312, there's a breach of policy RLP 80. Yeah. Page 46 in your proof.
Yeah, I see that.
Yeah, that's still your evidence.
I just read RLP 80 again.
Sure.
With reading the supporting text, read development plan as a whole. Don't take supporting text as policy. But I read that policy RLP 80. It says above it, policy RLP 80 is simply designed to protect and enhance individual landscape features. And so my understanding of that policy in terms of seeking to protect, I accept that there is a change to the landscape feature of the site by development of the site. However, as Mrs. Tivy accepted, the site can be successfully integrated into the landscape of Black Notley, as evidenced by the evidence. Sorry, as given by the evidence of Mr. Holliday.
So are you changing what you've written at 7312? You now no longer think there's a conflict with RLP 80, or are you sticking with what you wrote 4 weeks ago? I don't want to rush you, Mr. Culver, but we have got quite a lot to get through. I thought these were going to be fairly uncontroversial points, but you obviously take your time about them. I mean, anyway.
No, I accept that I've written my evidence there, but I think, as I say, it's extremely limited. given as I have accepted, the landscape character of that site will change by given the fact that those two small field parcels will change from built development to a greenfield to urban form.
Yeah, and you considered all of that, and you wrote, bearing that in mind, that there was a breach of RLP 80. It's not met, is it? It's conflicted with.
Yes, when I've read that in the round with the supporting text, I read that, made my evidence, yes.
Yeah, and that's still your evidence, isn't it? You haven't changed that.
No, but but supported by the evidence of Mr. Holliday, and he obviously set out how that can be successfully integrated into the landscape context of Black Notley.
Yeah, but you had Mr. Holliday's evidence, presumably when you produced your proof of evidence, you had that available to you in draft. Otherwise, how on earth were you striking the planning judgments within it? Yeah, understandable. And given what he wrote in that proof, and he said the same orally, you said there was a conflict with RLP 80, and that's still your evidence, isn't it?
Yeah, an extremely limited harm in respect of what I just discussed about that change of form.
Fine. Okay. You don't, however, say in your proof of evidence that there's any breach of RLP2, but I infer that from the detail you go into about how much weight one should attach to conflicts with RLP2 and your oral evidence about it being a most important policy that's out of date and breached. So am I correct in inferring that your judgment is there's also a breach of RLP2 by definition of the site being outside the settlement boundary?
Yes, my evidence very much is that there is an acknowledged conflict with RLP2. Thank
you. You say then, as a consequence of that, that your 922 you come to the judgment that there is a conflict with the development plan overall, is that right?
That's right.
Yeah, thank you. And so what follows from that is that the starting point is there's a conflict with the development plan overall, so you must refuse permission unless there are other material considerations which justify granting permission otherwise in accordance with the plan. That's all agreed, isn't it?
I don't have 38.6 in front of me, but I'm sure you'll correct me, and I'm sure you can very much give me the precise wording. It talks about
if regard is to be had to the development plan, and it must be in accordance with the development plan unless material considerations indicate otherwise.
Yes.
It's interesting, Mr. Carver, are you not familiar with what that requirement?
No, and so I think with regard to what you said just then, I think you put it a slightly different way than what that says. As I don't have it before me, and so I think you grant permission where it's in accordance with, unless material indications indicate otherwise. And I don't believe that is what you said. I think you said the converse of that, which was refuse unless.
Well, the converse of a situation where you're supposed to decide something in accordance with the development plan, unless the material considerations otherwise, is if you're not in accordance with the development plan, that's your evidence, you're the expert, you've told us we're not in accordance with the development plan, you're supposed to refuse permission unless material considerations indicate that you should grant it. That's how section 38.6 works, or do you understand it to work differently, Mr. Carville? You tell us how you understand section 38.6 works.
So I think the framework's very clear that in accordance with the 38.6 test that you start at the development plan.
Oh yes.
You don't finish it, and then you go on to do material considerations.
Yeah, well, I just want to make a very careful note of how you understand that legal test to work. So can you explain to me what happens, what the inspector should do if she agrees with you and Mr. Tivvy's evidence that there's a conflict with the development plan overall? What's the legal approach she should follow, you as a planning expert? What do you understand it to mean? Off you go, Mr. Carville.
Sorry, can you repeat that last bit?
Of course, off you go, Mr. Carville. You explain to us how you understand that legal test to work.
I can do it from my planning perspective. As I outlined in my proof, I have no legal expertise or qualification.
Mr. Cole, this
So
is
I say my understanding is of that test is you start at the development plan, and then you go on to consider material considerations, of which the framework is one. Yes, I'm very much agreed that the starting point is the development plan.
good. And if, having started at the beginning with the development plan, we come to the judgment that this particular proposal is not in accordance with the development plan, which is your evidence, what's the position then?
Yeah, we live in we're in a plan-led system. So yes, you start at the plan, and then you go on to consider material considerations.
Yeah. Do you understand that there's a presumption in favour of the development plan? Or do you not accept that? You accept that, yeah. Thank you. And so if there is a situation where there's a conflict with the development plan in a given situation, the presumption is that it should be refused unless there are material considerations of sufficient importance which justify taking a decision otherwise in accordance with the development plan. That's right, isn't it?
And that's right. And I think and then the paragraph 11 of the framework, which is obviously a significant material consideration before the inspector and incorporated into national policy, it says for decision taking, this means approving where in accordance with an up-to-date plan without delay, or where there are no relevant development plan policies, or the policies which most important determining application are out of date. Granted planning permission unless, and then it gives its reasons not to do so. And in my view, as I explained in my evidence in chief, I consider the policies in the basket to be out of date, the ones that are most important for determining the planning application.
Yeah. Thank you. Can I ask you about RLP 86? Because your evidence is on this that this policy isn't breached and cannot be breached, as I understand it, because you're not proposing development within this shaded area on the proposals map. And RLP 86 is in 7.5, or Doc 7.5. Just let me know when you get there, Mr. Carville, or you've got it in front of you.
Sorry, can you repeat the core documents reference?
Yeah, it's 7.5, I think. 7.5.
Policy 86.
I
have that, yeah.
Yeah, and reading it together, river corridors development will not be permitted which would harm the open character, nature conservation importance or recreation importance of the floodplains of the river, including River Brain and their tributaries and the Chelmer and Blackwater navigation. It's perfectly possible, isn't it, that a development that's not within the river or the floodplain could harm its open character.
When reading the policy, and that policy is shown to us on the proposals map, as I think you told us. So that policy applies where it is shown on the proposals map.
Sure, but that's directing us to what the river corridor is, and it's telling us, isn't it, that you're not supposed to grant permission for something that would have the effect of, and then it lists a number of things, including harming the open character of the shaded area. Yeah.
Okay.
Well, that's what it says, isn't it? Don't grant permission if it would harm the open character of what the river corridor is as defined on the proposals map.
I see it says that.
Yeah, and so you could harm the. Sorry, Mr. Carville, was there something else you wanted to say?
Yes. So if you're developing, so it's a policy that in effect it doesn't say no development within the river corridor, does it? It says development not be permitted that would harm the open character. So it doesn't say no development. If you developed in the river corridor, yes, you would obviously harm that open character, but we are not within that river corridor. We are there is no built development proposed in the river corridor as per policy RLP 86.
Sure. Is it your understanding then that you could never harm the open character of the river corridor, provided you develop outside it? Is that how you read that policy?
Yeah, yes, I do.
Right, thank you. Thanks very much. So on your case, to take it to an absurd extreme, sometimes testing propositions to absurd extremes reveals their accuracy. If you built a 30-storey tower scheme on the appeal site, you could never be in conflict with this policy because you'd be outside the shaded area, even if demonstrably you'd be harming its open character. Can't be right, can it, Mr. Carville?
I think I'm happy to stick by my point. I'd maybe characterise it in another example about openness of the green belt. If a site's either in the green belt or it's not. So quite commonly around the edge of towns, particularly in the southeast areas and Manchester, Stoke, etc. Development is if you like. Development surrounds, or the development is surrounded by the green belt, and one doesn't apply a test the other side of the line to say, well, you're near the green belt, therefore refuse planning permission. The test is one of green belt itself.
All right, Mr. Carr, it's an interesting distinction because, of course, the policy test for green belt is openness of the green belt, isn't it? Whereas this is the open character of this particular landscape feature of the river and its immediate valley bottom. They're slightly subtly different things, surely, aren't they?
Openness and open character, I think, take to be broadly similar concepts.
All right. So just so I understand it, you're saying that however dominant a theoretical scheme might be, if it were the right side of the line, it could never breach this policy, even if it demonstrably affected the open characteristic of the river corridor, because it's outside of the shaded area on the proposals map.
Yes, because you're not changing the character of that site.
No,
the policy applies. The policy applies where the policy applies, which is denoted by the proposals map. And so by there being no development on the river corridor, you have not harmed the open character of that area referred to in the policy.
All right, thank you very much. I understand where you're coming from on that. Onto the tilted balance, which is the material consideration upon which you say justifies the departure from the development plan, or the application of the tilted balance is the consideration that justifies the departure, as I understand it.
Could you repeat the very first part? I didn't.
Yeah. So onto the tilted balance, that was the next line of questions I wanted to ask you about. And as I understand your case, you're saying that the application of the tilted balance in this case is a material consideration which justifies departure from the development plan. That's how I've understood your case.
That's correct.
Yeah, lovely. A number of bases on which you say it was engaged in your proof, but not all of those were replicated orally, and I just want to check whether some of that was deliberate or whether actually you were just giving a swifter summary, and in fairness you're sticking with some of the points in here. So let's just check. 4.4 4.7 in your proof, please. This is going to be very interesting, Mr. Carwell, because here you've referred to a court case.
At 447.
I've given you.
I don't think I have.
Take you to the wrong place. I'm so sorry. 4.2.10. 4.2.10. Yeah. And here you're discussing the consistency of policy RLP2, and then you replicate that same discussion a little later on for CS5 with the framework. And you're dealing with a specific point at 4.2.7, which is a blanket protection of the whole countryside. Do you see that?
I do.
And you have cited the wit and wisdom of Mrs. Justice Lang in Telford and Wrekin, and derived from that that there is a inconsistency which at 4.4.7, which is where I took you first, you say leads to the policy being out of date. Now, you didn't say that orally, Mr. Carwell, but in fairness to you, I just wanted to check, are you still pursuing that argument?
Pursuing which argument?
The argument that policies RLP2 and CS5 are out of date because they apply a blanket protection of the countryside. As I say, you didn't say that orally, but in fairness, it is in your proof. And I wanted to check whether that's still a point.
If I said everything in my proof, we'd have been here for quite a long time. So, yes, obviously my evidence in chief I summarised just what my evidence was.
Perfectly legitimate, Mr. Carwell. No criticism at all intended.
It's very kind. So my evidence is I've explained my evidence as to why policy R2 and policy CS5 are out of date.
Yes, indeed. So as I take it from that, then you're sticking with what you've said here, that there's a separate and distinct basis on which RLP2 and CS5 are out of date to what you said already, and that's that they apply this blanket protection of the countryside. And that is in your proof, and you're sticking with it, and I need to ask you questions about it, otherwise I'll be taken to accept it. Is that right?
Yeah, no, I stand by my evidence on that.
Lovely. Okay, right, in we go then. So you've relied on Telford and Wrekin, and could you turn up, please, core document 517, which is the iteration further on in the case law from Telford and Wrekin.
Um, 517 Newark, it's called.
That's it. Should be in bold, Baroness Cumberledge of Newark and another, and Secretary of State for Communities and Local Government. Yeah. Lovely. And within that, could you turn to paragraph 116, please? That should be on the electronic page. Should be on 38 of the PDF.
I have that.
Lovely. And if we just consider it together, 116, the other argument that Mr. Young advanced for contending that the Ringmer decision was irrational was that the protection of the countryside from encroachment by inappropriate development in CT1 was not consistent with the MPPF. This argument, which appears to have found favour with the inspector at the Newark inquiry, is that the only protection of the countryside referred to in the MPPF relates to greenbelt and valued landscapes under para 109 of the MPPF and the relevant paragraphs of the inspector's report. Although Ms. Sargent sought to persuade me this argument has been rejected, the material on which she relies on appears to support that contention. But in any event, and this is what I want to draw your attention to, this argument does not show the Secretary of State's conclusion on the Ringmer appeal was irrational, and he quotes what the Secretary of State said. While policy CT1 gives blanket protection to the countryside, the NPPF directs specific protection to valued landscapes. Nevertheless, a core planning principle in the NPPF includes recognising the intrinsic character and beauty of the countryside. Policy CT1 is expressed as a key countryside policy in the local plan. The proposal would involve the incursion of development on a greenfield area of countryside, taking account also the finding above 5-year housing land supply has demonstrated. I consider that CT1 is not out of date for the purposes of the framework. And then we have this observation here from the judge. One way in which the intrinsic character and beauty of the countryside is thus recognised is the NPPF is the well-known advice given in para 55. Local authorities should avoid new isolated homes in the countryside unless there are special circumstances such as those listed in that paragraph. Accordingly, in my judgment, it cannot be considered irrational to regard a policy that was designed, as the explanatory text stated, to identify the area beyond boundaries where development would normally be unacceptable unless it is for uses compatible with the countryside as being out of date merely because the NPPF directs protection to greenbelts and valued landscapes and the planning boundary does not follow the boundaries of those areas. It's not right then to say, is it, Mr. Carpool, that simply because a policy seeks to protect the countryside, it is inconsistent to such a degree that it is out of date with the NPPF.
I obviously don't have the wording of what policy CT1 said before me because I don't have that before me, so I can't be versed to what that said or what this appeal decision said. Obviously, time has slightly moved on since this because this talks about the core planning principles of the NPPF, which the latest iteration doesn't have in it.
But 174B says the same thing as the old core planning principle, doesn't it? That you should recognise intrinsic character and beauty of the countryside.
Yes.
Yeah. So that distinction is a false one, isn't it? Mr. Cole. You do actually.
Can you repeat your question?
Of course, yes. You said that you made the fair observation that this was decided against the old 2012 framework, and it referred to the core planning principles, which I take it from your answer, the implicit point was that's no longer in the framework, yeah?
It's not, no.
No, and you're right about that. But the point that the intrinsic character and beauty of the countryside, which was an old core planning principle, that's still in the framework. It's just at 174B, isn't it? If you want to. Yeah. So the distinction that you're drawing between the old framework and that was considered in this case and what we've got now on that basis is a false distinction because the point is still in the framework. It's just in a different place.
Okay.
Yes. So
I'm not sure what the question. I'm not sure. I'm unclear what the question is. I think I've agreed with you that the core planning principles and the wording broadly is similar in 174B. Yes.
Lovely. So going back to my question, and which was, it follows, doesn't it, that simply because a policy seeks to protect the countryside does not render that so inconsistent with the framework as to be out of date, does it?
No, I think you need to look at what the policy does, and in this particular case in CS5, which is the policy that talks about the countryside, and it talks about development being strictly controlled, and refers to the town and village boundaries, that I think we heard from this Mr. Tivvy's evidence effectively don't exist in the core strategy. So we essentially go back to the local plan, and I think I've already explained as to why I consider those to be out of date.
No, sure, and we'll come on, I promise you, to the premise of that particular argument. But I just wanted to focus on this one that's in your proof, and you've told me is still very much an issue you're pursuing, which is that, as you say at 427, a blanket protection of the whole countryside is inconsistent with the framework, to such a degree that you tell us that 447 renders it out of date. And I just wanted to interrogate that point, and I've taken you to...
Yes, and so what the NPPF tells us when it's talking about policies referred to in the framework, where there could be a reason for refusing development, and that's I think in footnote 7 of the framework.
Yep.
It doesn't refer there to countryside, does it? So to enable development to come forward, as has happened in Braintree with regard to decisions by inspectors and the local planning authority, the NPPF doesn't tell us that we apply a blanket ban on development in the countryside. It does tell us there are specific policies where development should be restricted, and those are referred to there.
Thank you. You do have, because you pointed out you didn't have CT1 in front of you, and you do in fact have that in the same document of paragraph 16, electronic page 8. You have the policy quoted in full, so you might want to turn that up, in fairness, Mr. Carwell. Just let me know when you've had a good opportunity to read it.
You want me to read paragraph?
Well, just 16, because that's where the policy is quoted. And you said you didn't, in fairness, have it in front of you. And I've just drawn it to your attention and said that, as a matter of fairness to you, Mr. Carwell, you can look at it. Yeah, you see, it's quite similar, really, to RLP2 and CS5. It set a boundary and said beyond the boundary, development not accepted unless it fell within countryside uses, and the housing scheme, such as the one in that case and the one in your here, doesn't fall within them. Therefore, you're in conflict. So it's a similar situation, isn't it?
Yeah, and I've accepted there's a conflict with the policy.
Sure, but help me with this. The mere fact that a policy seeks to protect all the countryside, it doesn't mean that it's inconsistent with the framework so as to be out of date, does it? Because we've looked at what para 116 in that case said.
I mean, yeah, there's obviously a specific set of circumstances, again, which it talks about their local plan part 1 being adopted above.
Just to have 116 perhaps in front of you again, Mr. Carwell, when you answer my question, where it says, accordingly, in my judgment, it cannot be considered irrational to regard a policy that was designed, as the explanatory text stated, to identify the area beyond the boundaries where development would normally be unacceptable, unless it is for uses compatible with the countryside, as being out of date, merely because the NPPF directs specific protection to green belts and valley landscapes. That's not an endorsement of your argument, it's a rejection of your argument, isn't it?
That policy is obviously dealing with very specific things about heightened importance to separate settlements and prevent their coalescence. I think we've agreed that there is no issue in that regard with regard to this development proposal.
Can you? I understand that. Can you just turn up 116 again for me, just to make sure I've got your full answer on this? Page 39.
Yeah, sorry, I was typing 116. As you said.
Sorry, what am I looking at here?
Sorry, madam, it's paragraph 116 where I started, which is
right.
electronic page 39.
Thank you.
And you see, just next to the letter C on the left-hand side, the paragraph that says, accordingly, in my judgment, it cannot be considered rational to regard a policy, etc., etc.
Yeah.
Yeah. Therefore, it follows, doesn't it, that simply because the policy is seeking to protect the countryside, all countryside, doesn't render it out of date, does it?
Again, I don't know the specifics of this appeal decision, but obviously they were talking about green belts and valued landscapes. So,
well, that's your point, isn't it? At 4.2.7, that it's inconsistent with the framework, makes clear that accounts should be taken of different roles and character of areas protecting greenbelt land, whether in terms of character of the country. That's exactly your argument, isn't it, Scott? You're saying that that's inconsistent with the framework because the framework directs specific protection to greenbelts and valued landscapes. And therefore,
that's right. So yeah, that's why I took you to the footnote 7 of the MPPF.
Yeah, but that argument has been considered in this case and rejected, hasn't it? It's not an endorsement of that argument. It's saying it cannot be irrational to regard a policy that protects the countryside, all countryside, as being consistent with the framework and not out of date.
That's on the merits of that particular case. It appears that that's what the conclusions of that judge came to.
Yeah. And so that's not an endorsement of your argument, is it? It's a rejection of your argument in that case, isn't it?
It's a different policy in a different local planning authority with a different set of circumstances. So, in my view, that is what the policy CS5 does, is that it restricts that development in the countryside. And that is not what the framework tells us to do.
No. I mean, I could, if I were being flippant, and I suppose it's towards the end of the week and near Christmas, I could say that your 4210 is a different case with different circumstances involving a different local plan policy, and yet you've sought to involve that case in support of your argument, haven't you? Different case, different policy, different facts. Agreed?
That'd be a fair characterisation.
Yeah. So let's set aside that flippancy and go back to looking at what we could derive from the case. You can agree with me that what's said at 116 does not support your argument, does it? It rejects that argument.
But I think, yeah, but I'm supported by the argument of the one I've referred to, which clearly says MPF does not include a blanket protection of the countryside for its own sake.
Yeah, this case follows that one. Oh, Mr. Robson's popped up, so I'll
Hello, ma'am. Sorry to intervene on my learned friend's cross-examination. Of course, he is absolutely entitled to ask whatever questions he wants. But, ma'am, I'll give you advance notice now, and Dr. Bowes will understand it. He can ask whatever questions he wants about the law. I will make the submissions I want about how the law should be interpreted, whatever the answers that are given by Mr. Carville, as the law is not evidence. And of course, Dr. Bowes will understand that. He's more than he can ask questions and use his time however he wants to use his time. But if we're going to spend hours and hours looking at how one interprets judgments of the court, might not be the most efficient or the best use of the time allocated. It's entirely up to Dr. Bowes, but I'll give him notice that I will make my submissions on the case law, irrespective of how the answers are given here.
Well, that's fair enough, and I wouldn't prevent him from doing that. All I would say, Madam, is that Mr. Carville is the one who cited the case law in his evidence, and so it would be rather remiss of me if I didn't cross-examine him about what he'd written here. Sorry, can't quite have his cake and eat it, with great respect to Mr. Carville. I can't just take what he's written here at read and not challenge it, I'm afraid. Unless, of course, it's not assisting you, Madam. I obviously won't ask any more questions on it if it's not helpful to you, but it's a point he's put in issue and he's cited the cases, so I'm quite sure how I'm supposed to approach it otherwise.
I understand why you're asking about these case laws, and obviously the degree of conflict of any policy with the framework is something to be questioned on. I think really it's up to you how you use your time. I don't think your questions are unfair, so I'm not going to stop this line of questioning. But at the end of the day, obviously I can see the policies and I can see the framework, and I'll make my own judgment about the consistency for both parties.
I'm grateful, Madam. Thank you. Okay. So that's countryside. Then we have an argument which is very much in full throat, as it were, which is the fact that some of the policies were adopted against a housing requirement that has now been superseded or revoked, or there's a new one in place. That argument.
Yeah, I think all of those words apply.
Yeah. I was summarising, but I hope fairly that's the point that you're making. You're saying that some of the policies in the development plan, saved RLP policies and the core strategy policies, were all adopted against housing requirements that's now not the housing requirement, and therefore that should bear on whether they're up to date or out of date. Is that fair? That your argument?
Yeah, it was just one policy of the local plan review that was referred to in that regard.
Righto. Okay, that's helpful. I understood you were saying that CS5 as well was out of date for the same reason, because, as you say, that was derived from the regional strategy and that's now been revoked.
I was trying to clarify what you said. You said policies of the local plan review, and so I was clarifying it was a singular policy. So singular policy of the local plan review, RLP2, and policy of the core strategy, CS5.
Oh, I see. Thank you very much. That's very helpful. As you say, in fairness, at your 4.6.2. Yep, that's the argument as encapsulated. It's the fact that those two policies were adopted in development plan documents which had housing requirements in them, which have now been superseded or revoked. Yep.
Yeah, they've been overtaken by events. It's not, again, as I explained in my evidence, Chief, it's not simply to do with age. It is about accommodating the housing growth that's required by the development plan now.
Got you. Thank you very much. So the mere fact that the local plan review was intended to meet needs to 2011, and we're obviously past 2011, that simple fact of itself doesn't render the policies in the local plan review out of date that are saved, does it?
No, those policies were saved by the Secretary of State.
Indeed, and remain part of the development plan, but the mere fact that the initial operational period of the plan has gone past that end point, that doesn't automatically mean they're out of date, does it?
No, and I've said that lots of times.
Lovely. The development plan as now does in fact have an up-to-date housing requirement, doesn't it, in the local plan part 1 as it applies to Braintree?
Yes.
There's no dispute that that housing requirement is up to date. It's obviously recently been through examination and adopted this year.
Correct.
Lovely. And there was no, that local plan part 1 upon adoption did not supersede expressly or impliedly policies RLP2 or CS5, did it?
No.
Thank you. And the mere fact, though, that a policy has been adopted against a housing requirement that has been superseded doesn't render it out of date if there is in fact a 5-year supply against an up-to-date housing requirement, though, does it?
Sorry, can you repeat that?
Of course, yeah. The mere fact that a policy is contained within a plan that was adopted with a housing requirement that's now been revoked or superseded doesn't render that policy out of date if there is a 5-year land supply, does it?
Ma'am, I am sorry.
All right.
Dr. Bowes we had a disagreement about whether he was going behind a concession before. My notes on the answers from his witness were that it's out of date because the housing requirement for the local plan review has now been superseded and the boundaries are based upon that housing requirement. It's out of date on that basis. I then asked a question, would it be out of date if you did have a 5-year supply? And the answer Dr. Bowes' witness gave me was yes. He is now seeking to go behind a different way, and I admire his ingenuity, a different way behind the concession given by his witness, which he knows is inappropriate.
It's not inappropriate, with great respect, because as I made very clear, that concession wasn't fairly given because my witness said he wanted to go to the case which dealt with that argument. And when I took him back to that argument in re-examination, he withdrew that concession. Now, I'm very sorry, but he made it expressly clear he wanted to go to that case. In the excitement of the moment, he didn't go to it because my learned friend said that had to be dealt with in legal submissions. We had a dispute as to whether I was even entitled to re-examine him on that point, which surprised me slightly. He did go back to that, and when he was presented with that document that was in evidence, my learned friend knows about the case because I highlighted it in the agreed legal materials, he withdrew that concession. And that's, I'm afraid, how it works. You can't extract a concession. If a witness says, I'd like to go to a document, he's not allowed to go to it. And then when he goes back to it and reminds himself of it, he withdraws the concession. Completely unfair if he was held to that point otherwise.
Ma'am, you have my position. Obviously, I will be making submissions on it. I fundamentally disagree with the way that this case is now being put by Dr. Bowes. I will deal with it in submissions, but when concessions are given by a witness, the advocate cannot then seek to go behind them, either through re-examination or by putting a totally different case to what his witness is accepting to my witness. And ma'am, if it continues, I'm afraid I'll be making submissions on the point, but I will have to intervene to tell you the points where I will be making those submissions. And I hope Dr. Bowes limits the necessity for those interventions.
See, entirely up to you whether to proceed. You have the evidence that was given. I'm afraid you can't hold a witness to a concession that was given if it was obtained unfairly. However, unintentionally that was. It's not a suggestion my learned friend deliberately sought to be unfair, but it would be unfair if he wasn't able to look at a document he asked to look at. And when he looked at it, he withdrew the concession. I mean, I'm sorry, but that's the evidence.
Right. I've just come in here, going back to Mr. Tivy and how that happened. Yeah. At the time, he did mention Mr. Robson. You did dissuade him from going to that case. That's my memory of it. And I felt at the time perhaps I should have intervened then and let him answer the question in the way he wanted to. So, but I let it go. So, but then when Dr. Bowes came back with it, I remembered what had happened, and I thought it was right to give him the opportunity to answer the question the way he seemed to want to go down the route that he wanted to go, because he was told that law is not a matter for planners. Well, it clearly is a matter for planners because I'm a planner and I have to interpret the law. So I think it was fair. It is reasonable for a planner to want to refer to planning law when being asked a question. In terms of the latest objection that you've put, Mr. Robson, I'm afraid I'm a little muddled because I've actually forgotten what was going on. So I need to be reminded. So all this talk about policies. Yeah. Okay. So if can we just go back to that, and then I'll listen to what you've got to say about it.
So what question again? Mr. Robson could object. How would you like me to do it?
I have what you've said. You have the points I've made. I disagree on how the Daventry case is interpreted and how it was put to his witness, but I will deal with that in submissions as a matter of law, not as a matter of evidence. You have my position on what was given as a concession, and I'm glad that Dr. Bowes withdrew his idea that I unfairly tried to keep Mr. Tivy from a document, because that certainly did not happen. I will make submissions on all of the points that have been made, ma'am. I understand your position is given. Hopefully we can just move on and actually get to some evidence and get away from just reading case law out to witnesses, but we'll see where we go.
Right. Okay. Well, I'm losing concentration now, to be honest. So I think it is his time for a break. And so I think this is a good point to have a 15-minute break, and it's 20 to 4 now. Does that cause any problems to anybody?
Not to us, no, thank you.
Okay, so if we come back at 5 to 4. Thank you. Okay, so it's five to 4 now, so we will resume. I had to take a break then. I had my flu vaccination at lunchtime and I was starting to go a bit lightheaded, so I'm sorry, I did get confused towards the end about all of that. I don't know whether you need to go back on it or whether you've sorted it out during the break.
Well,
Which bit?
I don't think either Dr. Bowes or I are going to change our position. I suspect you're going to get submissions on it. I think the best way to spend inquiry time now is to let Dr. Bowes ask questions of my witness. Hopefully we'll finish with time to be able to write closings up this evening.
Okay, all right. Okay, thanks very much.
Now, can I just make one point clear I think is important, and that's the reflection of the virtual process. I can't have the informal conversation with Mr. Robson. I didn't wish to suggest that he had acted himself unfairly at any point, and I want to make that very clear. What I was suggesting is that there might have been an effect of unfairness as an unintended effect, which I sought to remedy through examination. I didn't for a moment suggest he had acted improperly or unfairly, and I want that to be very clearly understood by you, Madam, and Mr. Robson.
I appreciate that. Thank you very much, Dr. Bowes. We've worked together before. I wouldn't expect you to have said that unless I did something really wrong. Thank you, Dr. Bowes.
Yeah, and I understand that, and I don't think there was anything deliberate in any way whatsoever at all. Okay, my team are having their Christmas Zoom at the moment, although I'm quite glad to be missing that, to be honest.
Well, the planning inspectorate team.
Yeah. Well, we don't actually have teams, but we have little management groups. We're not allowed to have teams as such because we work independently. I'll just mention that. Right.
Well, it is the Gladman Christmas quiz as well, I've just been told. So we could all just down tools and join one quiz or the other, couldn't we?
Join them together, maybe that'll be fun.
Well, that's it, form a team.
Yeah.
Thank you. Sorry.
Or not. Yeah, okay. Thank you.
To really bring the mood down, Mr. Carville, back to 4.6.2 to 4.6.3 in your proof. Just where we were picking off, where we left off, policies, you say the policies for which the council seeks to refuse the development as part of the core strategy and the Braintree local plan review related to an out-of-date housing requirement, a view supported by the inspector in the Rain Road appeal. The local plan review is based upon the housing requirements set out in the Essex and Southend on Sea replacement structure plan, and core strategy is based upon the now revoked East of England plan. And I just wanted to put to you, though, Mr. Carville, that the mere fact that a policy was within a plan the housing requirement has been revoked or superseded, that by itself doesn't render the policy out of date, does it?
No.
No. And it may be that the housing requirement has changed and therefore there's not a 5-year supply against an updated housing requirement. But if that is the case, and a development plan, local planning authority can demonstrate a 5-year land supply, well, then the mere fact that the policies relied upon to resist the development were contained within a plan whose housing requirement has been revoked is a sort of a matter of academic interest only, isn't it, Mr. Carville?
A local planning authority can have a 5-year housing land supply, and the policies can still, and the locational policies can still be out of date.
So you're, for the reason you say that they were at the point they were adopted in a plan whose housing requirement has now been superseded. For that reason alone, you say they can be out of date. Is that right? Oh, you've gone.
Yeah,
Sorry. You froze. Sorry, Mr. Carville, you froze.
I'd like to take some time to consider your question.
No. On my screen, you froze. No, Chris, I couldn't hear you. That's all right. Please carry on. Take your time.
Sorry, can you now repeat the question?
Of course, yes. If a local planning authority, a long way away from Braintree, hypothetical local planning authority, had at a given point in time a 5-year land supply. So say that's agreed in that case. The mere fact that the policies it's seeking to rely on were adopted in a plan whose housing requirement has been superseded doesn't make those policies out of date, does it?
Not necessarily on your hypothetical example.
No. Because in a sense, the national policy is to boost significantly the supply of housing. And the way it does that is to say you've got to have a 5-year supply against an up-to-date local plan figure or the standard method. That's the national picture, isn't it?
Yeah.
Yeah. And if a local planning authority does that, so it complies with all of that, it has a 5-year land supply, the policies upon which it seeks to rely to refuse a planning application are not rendered out of date simply because when they happen to be adopted, the housing requirement figure was different. Surely.
I don't agree. I don't think necessarily having a 5-year housing land supply brings a policy up to date for that reason.
Right. So even if a local planning authority were complying with the national requirement to boost significantly the supply of housing through having a housing land supply in accordance with an up-to-date local plan or standard method, it still would have the tilted balance engaged on your case, because just as a matter of historic interest, when its policies were adopted, they were in a plan whose housing requirements been superseded.
Yeah, and in the example of Braintree, that is literally my case. But it isn't the case. It isn't the case that I'm saying because they are old and because the housing requirement has been superseded. I'm not saying that it's because they are old. I've given my reasons as to why they are out of date in accordance with the framework.
Yeah, and that's because, I mean, in a sense, though, in substance, you are saying it's because they're old or the date at which they're adopted, because you're saying, as I understand it, that irrespective of the land supply situation, they are out of date and the tilted balance is always engaged, just because when they were adopted, the housing requirement figure is different. That is an ageist approach to the policies, isn't it, Mr. Carville?
No, because the evidence base, using a sort of hypothetical example again, if you like, is situation moves on. So you can have a framework. I think that's applicable in what the framework does now, in that you could have you there referred to the standard method. You could have a post framework core strategy or local plan adopted in 2016, and this year it would have reached its 5th birthday, and therefore the standard method would apply. So that's post framework, 5 years old, standard method applies, and in a particular example, the tilted balance may apply.
But say in your example, you get to the 5th birthday, the standard method applies if it hasn't been reviewed, and they still have a 5-year land supply. Yeah. So imagine that situation.
Sorry, what I meant to go on to say was you can have a post framework, reach the 5th birthday, we can have a new plan from its 5th birthday. Yeah. So then the new evidence base has overtaken the previous one, which is what's happened in this case. But
it wouldn't, in that situation, make the policies out of date if there was a 5-year land supply, would it? Or in your case, does it?
If there in that situation, if, for example, it's very hard to deal in hypotheticals, isn't it? But well, I was just thinking my point here is about where I think it's by virtue of what happens I think it's happened. The situation in Braintree is obviously where we've got development plans that are supposed to be coming. So that was obviously supposed to happen with the core strategy. That should have produced a site allocations plan to allocate the growth of that plan. It didn't. We then have the part 1 plan. And to allocate the growth of that plan, we need the part 2.
But you've just raised a very interesting example, which I hadn't actually considered, Mr. Carville, that if you had, so I'm grateful to you, on your case, you could have a situation where a plan was adopted in 2016, it reaches its 5th birthday, and therefore you're right, it flips to the standard method, even if against the standard method that authority can demonstrate a 5-year land supply, you're still saying it's out of date and the tilted.
No, sorry, that was a mischaracterization. I was trying to break it down into where it may be a policy may be superseded by another.
But wouldn't that be?
But yeah, say dealing in hypotheticals isn't particularly helpful. If you focus on the Braintree situation, I can explain that. If you like.
But now you've raised it. I mean, why doesn't if you take your example to its actual conclusion, that would be right, wouldn't it? That if you adopted a plan in 2016, not that long ago, you flipped to the standard method, but you could still demonstrate a 5-year land supply because the housing requirement figure was out of date. All the policies would be out of date on your case, and the tilted balance would be engaged, even though the plan was only adopted in 202016 and there's a 5-year land supply.
No. So it was a misconstrued example. So sorry.
I was sorry, Mr.
The point I was trying to get to was if the housing number had changed, that's about the evidence base. We've got a large number, 5-year supply. That was that was the point. No 5-year housing land supply. The point I was trying to get to. That isn't the situation here. So I'm not trying to say that a development plan that's 5 years old would necessarily have the tilted balance engaged. I'm not trying to say that.
But that would be the natural conclusion of your argument, though, wouldn't it? As soon as the housing requirement figure is superseded by something, the standard method, then on your case, the policies are out of date, the tilted balance is engaged. That would be the natural conclusion of your argument, wouldn't it?
The government's in the NPPF, the government's view of assessing 5-year housing land supply and significantly boosting the supply of housing is about, and it tells you in the framework about applying the standard method for 5-year housing land supply calculations if it's on the situation of as you explained about
74.
That's right.
Yeah, spot on. But just so we understand the limits of your hypothesis, your thesis would run to that situation just as it runs to Braintree's, wouldn't it? There'd be no in-principle distinction because on your case, you're saying whenever the housing requirement is revoked or superseded, therefore all the policies adopted against that housing requirement are out of date.
No, it's about whether those policies can accommodate that growth. So you may have examples where on the hypothetical one I gave, the standard method goes down, and therefore those housing policies or locational policies can accommodate that growth.
So really, the question mark, really, what you're saying is you have to interrogate whether to get to a 5-year supply against the correct figure, whatever that happens to be, you've had to breach your settlement boundaries to get there. That's in substance what you're saying, isn't it?
It may be a consideration on the particular merits of that. Well, no. In terms of as you pointed out, the starting point is the development plan. So irrespective of whether there's a 5-year housing land supply, you consider the policies of the development plan first.
Sure.
So,
but having done that and concluded that a scheme is not in compliance with the development plan, you look at other material considerations. One of them is Para 11. You're spot on about that. Para 11 says where the policies most important are out of date, you engage the tilted balance. And your case is one of the reasons on which the tilted balance is engaged is where the relevant policies you're relying on were adopted against a housing requirement figure that's been superseded or revoked. That's your case. And I'm simply putting to you that the natural conclusion of that is that that would be the case for 2016 plan, wouldn't it?
It would completely depend how the number changed.
Yeah, but say it changed because it flipped from the local plan figure to the standard method, and say that the council were able to demonstrate a 5-year land supply. So assume that your case is the tilted balance would still be engaged because the housing requirement figure had been superseded. That must be the conclusion of where your thesis runs. It's
no,
isn't it?
No, because the evidence base that would underpin those settlement boundaries the plan would be time extant, and the housing growth required of that could be maybe accommodated within those settlement boundaries.
But we've agreed that the fact that a plan is time extant or time expired is not relevant to whether it's up to date or out of date. So that doesn't help you, does it?
You need to review whether, what can be accommodated within, if we're talking about settlement boundaries, what growth can be accommodated within those settlement boundaries. And in this particular case, the local plan review policies, they were drawn to accommodate that particular housing need.
So can we agree then that it's actually a more nuanced question on reflection than how you've put it in your proof, that it's not right to say that automatically, whenever the housing requirement figure is superseded, all the policies which are adopted against that housing requirement figure are out of date? That would be too blunt a way of putting it. Would that be fair, Mr. Carr?
Yes.
That would be fair. And so you have to look at it on a case-specific basis and come to a more nuanced judgment. Would that be a fair way of putting it?
You've got to come to a judgment, yes.
Yeah, thank you. Okay. And then we all agree that if there isn't a 5-year supply, well, that's an easy case because the framework tells us that you engage the tilted balance in that situation. So that all swings really on your evidence and Mrs. Carpenter's, and obviously the inspector heard all of that and will form her own judgment. And if the judgment is there isn't a 5-year supply, well then you haven't tilted balances engaged. Straightforward, all agreed. Just tell me one thing though. Para 11, or indeed the rest of the framework, where it says no relevant development plan policies or the policies which are most important are out of date, there's no reference there or anywhere else in the framework to your particular example of the housing policies being superseded, is there? Unless I missed it.
I think one's got to make an assessment of where the evidence base. Well, all local plans are underpinned by an evidence base.
Yes.
And so within that you can. So those policies rely upon an evidence base to justify their means, if you like. And so one can assess from that whether they are up to date or not up to date. Sure,
you might be right, but just help me with the very simple question. There's nowhere in the framework where it says a particular example of out of date for the purposes of Para 11D is where the housing requirement policies have been superseded, is there? That's something you've read into the framework. But it's not actually expressly in the framework anywhere, is it?
No, and well, I guess one has to interpret to what paragraph 219 says, and one doesn't simply say they're out of date because they were adopted, and I fully accept that. Do you wish to give them agreeing to their degree of consistency with this framework? And that goes on. Oh,
but that's a different point, though, isn't it, Mr. Cock? Well, that's your point about whether a policy says something that's just different from the framework policy. If a policy, that's not dealing with the situation, is it, where a policy is itself consistent with the framework, but because it's in a plan where the housing requirement figure has been superseded, is out of date? It's not saying that, is it?
219 isn't saying what?
So 219 is dealing with consistency of policies in development plans with the framework. Can we agree with that?
Yeah.
Yeah, and it's not dealing with a situation where a policy is itself consistent with the framework, but is deemed to be out of date simply because it's in a plan where the housing policies have been superseded. It's not dealing with that situation, is it? Doesn't say that.
No, but I think it's a planning judgment based upon what that says, isn't it?
Well, it says due weight should be given to them, so policies, according to their degree of consistency with this framework, not the degree of consistency with other policies in the plan that are not considering consistency with the framework. That's dealing with considering an individual policy against the framework, isn't it?
Yes.
And if you concluded, having done that exercise, which is a planning judgment, that an individual policy was on its own terms consistent with the framework, you should give it due weight. That's what 219 is saying, isn't it?
Yes.
It's not saying that if, having done that and concluded that it is consistent with the framework, it should be deemed to be out of date because it is in a plan with other policies which have been superseded. It doesn't say that, does it? That's an extra leap of logic that you read into that paragraph, isn't it?
I don't think it is, but that's about your. Sorry, you're referring to policies that have been superseded.
Yeah.
So in this particular example, RLP2 hasn't been superseded. So that's a policy. The policy hasn't been superseded.
No, agreed. So if the inspector looked at RLP2, for example, in pursuant to para 219 of the framework, and concluded that that policy was consistent with the framework, that's a planning judgment for her. So say that's what her conclusion is. You are saying that even if that were the conclusion, because it's in a plan, the Braintree Local Plan Review 2005, which the housing requirements of which have been superseded, that policy should be out of date, even if on its own terms it is consistent with the framework. That doesn't say that, does it?
I mean, the framework can't deal with every single local plan policy, and I don't think it's attempting to do that.
No, but it doesn't say anywhere in the framework that if a policy is consistent with the framework on its own terms, it should nevertheless be deemed to be out of date because it is in a plan whose housing requirement policies have been superseded. It doesn't say that anywhere in the framework, does it? That's something you've read into it as a planning expert, isn't it?
Yes, in some respects, because that's what paragraph 11 tells you to do.
Well, it's not in some respects, is it? That will point me to in the framework where it tells you to do that extra step.
Well, one must consider what are the relevant policies, and then we put those into the basket.
Yes. And then we consider which of those policies is up to date or out of date, don't we?
Yes.
Yes. And 219 tells us that how you do that is to consider the consistency of an individual policy with the framework. Yeah. So the inspector looks at RLP2 and CS5 and looks at all your arguments about blanket protection of the countryside and all of that. Yeah. That's the next step. That's what para 219 says, and you're quite right about that. But it doesn't say, does it, that after you've done that and concluded that a particular policy is consistent with the framework, you should then ask yourself whether that policy is within a plan whose housing requirement has been superseded and therefore is out of date. It doesn't anywhere tell you to do that, does it? That's something that's a Gladmanism, if I can put it that way, Mr. Carville.
I think I'd refute that as a Gladmanism. Obviously, I presented my evidence in my professional opinion. So
I saw that, Chris, as I was being flippant. I apologise, Mr. Carville. Of course you were. Just a lot of other witnesses from Gladman have made the same point, but I appreciate it's your professional opinion. I wasn't casting an aspersion on that for a second, so please put that to one side. I'm sorry.
Thank you.
But it still doesn't say.
Those specific words you have just said don't appear in the framework in the very form that you have said.
No, and nor does any other paragraph say them in a slightly different form or in a slightly different way in substance, does it? There's no paragraph that tells you you've got to go through some extra process.
No, because it's a planning judgment.
Yes, it's a Mr. Carvelism, perhaps I can put it that way. It's an extra thing that you, as a planning expert to this inquiry, have said should happen, but isn't, on the terms of the framework, something that it tells the inspector she has to do. Would that be fair?
My evidence is my professional opinion. I wouldn't call it a Carvelism, but that's very kind of you if you want to call it that.
Years to come, that's what we'd be calling it. But still, your professional opinion, Mr. Carvell, is what you're here to do. What you're paid to be here, to give your expert opinion to the inspector objectively, and that's, I'm sure, what you're doing. No criticism at all. But your suggestion to the inspector that what she should do is to, having considered consistency of individual policies against the framework, to then do an extra step to say, aha, but are these policies within a plan whose housing requirements have been superseded? That's not actually in the framework anywhere, and you and I can agree that, can't we?
The inspector has to consider the policies against the framework, as a material consideration as a whole.
Sure.
So it doesn't. So one doesn't. Obviously, paragraph 11 is in a neat box, and it says plans decision should apply a presumption of favour development, and it tells you how to apply that. It doesn't promote one particular paragraph over another. So one has to consider the framework as a whole.
Sure. Well, can you illuminate some lurking crevice in the framework that I have overlooked when I've been looking at it, which says that you're supposed to do this extra step? Point me to a paragraph or an appendix or a glossary or a footnote that tells you you've got to do this extra thing explicitly. Something you've read in, isn't it, Mr. Carvell?
One's making a planning assessment on the evidence base. Sure. And what those policies are drawn to do.
Yeah. But none of those policies tell you to do that expressly, do they? You've read that in. Is that fair?
I've made an assessment of those policies against the framework, yes.
Yes, indeed. I know you've done that. But then you've done something extra. You've said, even if those policies are consistent with the framework on their own terms, they're still out of date because they're in a plan or a core strategy whose housing requirement has been superseded. That's your evidence. And I'm just saying to you, there's nowhere in the framework that says that, is there? There's no paragraph or footnote or glossary. That's something you've read into it, isn't it?
I think I'd characterise it slightly differently in that
my
conclusion is they aren't in compliance with the framework.
Yes, I know that.
And not simply because of age, which is what I think you're trying to suggest to me.
No, I get that point. I know that's your evidence. I've asked you questions about it. We've been to the case law, and we'll go to it later on about countryside policies. And I've got that point. I understand that's your case. But I understand you to be saying at 4.6.2 and 4.6.3 in your proof that there's actually a separate passageway into the tilted balance, which is that even if a policy is consistent with the framework on its own terms, and even if there's a 5-year land supply, the tilted balance is still engaged if those policies were within a planning document whose housing requirements been superseded.
I don't think I don't think I am saying that in my evidence.
Right. So that's not, you're not pursuing that point then. So if the inspector were to find that the policies here are consistent with the framework, and she were to find there was a 5-year land supply, there's no separate basis on which the tilted balance is engaged, is there?
If the inspector were to find, if the inspector was to find all the policies were compliant with the framework, and there was a 5-year housing land supply, yes, the tilted balance wouldn't be engaged on that basis.
Okay. Yeah, thank you very much. Not surrendering your other arguments on that. I know we don't agree on consistency. I know we don't agree on land supply, but there isn't a third point, and you've helpfully explained that's right. Thank you. Right. Sustainability next. I can deal with this quicker. So within the framework, 105 and 112, I just want to have a quick conversation with you about what these bits of the framework require. 105, where are we? 105 and 112. So 105 says planning systems should actively manage patterns of growth in support of these objectives. Significant development should be focused on locations which are or can be made sustainable through limiting the need to travel and offering a genuine choice of transport modes. This can help to reduce congestion and emissions and improve air quality and public health. However, opportunities to maximise sustainable transport solutions will vary between urban and rural areas, and this should be taken into account in both plan making and decision taking. And then 112, under the decision taking heading, it says within this context, applications for development should give priority first to pedestrian cycle movements both within the scheme and with neighbouring areas, and second, so far as possible, to facilitating access to high quality public transport with layouts that maximise the catchment area for bus and other public transport services, and appropriate facilities that encourage public transport use. Help me with this. Those policies within section 9 of the framework, they are targeted at encouraging a shift towards sustainable transport. Would you not agree?
It talks about opportunities. It talks about promoting opportunities for a range of development types, and it says opportunities to promote walking and cycling public transport, for example. It doesn't say no car-based journeys should be allowed, for example.
Sure, and I didn't put that to you. What I put to you is that the thrust of section 9 of the framework is about encouraging a shift towards sustainable transport modes. That's what I derive from those paragraphs, and I'm seeing whether you, as the planning expert, get the same impression when you read them.
The section is called promoting sustainable transport. So
one might derive from that promoting sustainable transport was one of the policy aims, but
yes, the NPPF encourages sustainable transport. Yes.
Yeah, and what follows from that, and what I wanted to explore with you, is that an inspector considering a scheme or a planning authority considering a scheme has got to critically analyse the likelihood of sustainable transport modes being taken up in a given instance, haven't they, in order to see whether there's going to be that shift to sustainable transport modes in a given case.
Well, the starting point is the development plan, so it would look at that first.
Sure, but having looked at that, the framework's material consideration, I'm just asking about the framework. Can you just help me with what that means? So we've agreed that one of the thrust of the framework policy in section 9 is about encouraging, promoting a shift towards sustainable transport. I think that's fairly uncontroversial because that's what it says in the title, on the tin, as it were. What follows from that, so the next step in the chain I wanted to see whether you agree with, is that an inspector has got to critically analyse the likelihood of a sustainable transport modes being taken up in a given case, haven't they?
I think we have to read things as to how they're worded, and I think you input a word into the heading that I can't see there.
What's that word?
You said shift, and I can't see the word shift.
Okay, right. So you don't think that section 9 of the framework is encouraging a shift towards sustainable transport modes? Do you want the inspector to record that in her decision letter?
No, what I'm saying is it's about promoting sustainable transport, and it encourages a range of, and within that range of measures, it's about promoting opportunities for walking, cycling, public transport, within this same section, for example, it talks about local parking standards. So within that context of what sustainable transport is, there are a range of things that are considered sustainable transport. So be that walking, cycling, public transport, and local parking standards. So what does one put in a parking space? It's a car. So this section considers a range of measures and opportunities from public transport, walking and cycling, and car-based opportunities.
Sure, but if we look specifically at 112A, for example, to focus on the words, as you say, we're in the considering development proposal section. So par excellence, what we should be looking at for this scheme. It tells us to give priority first to pedestrian cycle movements within the scheme and neighbouring areas, and second, so far as possible, to facilitating access to high quality public transport. So we derive from that, can't we, that there is an encouragement to promote a shift to taking up those forms of transport, because it tells us that one of the things we should be looking at is if development is giving first priority to the use of those things.
Yeah.
And so what follows from that, I'm suggesting to you, Mr. Carville, and I'd be interested to know what your answer is that one has to critically analyse the likelihood of those sustainable transport modes being taken up in order to come to a judgment about whether first priority is being afforded to them, surely.
Yeah, and within the context of that, give first priority to pedestrian cycle routes within the scheme and with neighbouring areas. Internal layout is a reserve matter, so that's within the scheme.
Yeah.
And with neighbouring areas, I take that to mean the existing urban area. So the local highway authority are satisfied that there is appropriate pedestrian and cycle movements considered within that access point that's given.
But there's a subtle distinction, isn't there, between something being within the technical parameters of a maximum walking distance or a maximum cycle distance, and whether there's a likelihood of future occupiers using it. Would you not agree with that distinction as a matter of principle?
Between a technical...
Between a site and a location being within the technical maximum walking standard and the likelihood of people actually walking that particular route. Would you not accept those are slightly different things, aren't they? Different concepts.
I think they're guidelines that you talk to. They're not. It isn't the policy.
No. So to give you a theoretical example, something could be well within a maximum walking distance, but because it's through a dark, unlit, uninviting, haunted woodland, no one's going to use it, to use a ridiculous example. That's taking it to its extreme. You see, they're different things, aren't they, between being within the maximum standard and whether someone's going to use it or not. Yeah,
and everyone makes an individual choice as to where they want to travel and how they want to do it.
Yeah, and so it's appropriate and indeed necessary for an inspector to grapple with, to critically analyse the likelihood of future occupiers taking up pedestrian cycle opportunities and the access to public transport, isn't it?
Yeah, I think it's a material consideration of looking after the policy.
Sure. Okay. Righty-ho. I mean, the framework itself is a material consideration, though, isn't it? So, yeah. And you're saying it's a relevant thing to consider when you're assessing compliance with these framework policies, the likelihood of people taking up those opportunities. That's a relevant consideration to put into the mix, isn't it?
Yeah, and I think I consider that the appeal proposal has done that. So given with regard to the guidelines, which you probably, it's in the core documents as probably a material consideration before the inquiry as well. And then so as far as possible, that isn't even a requirement to facilitating access to high quality public transport, which I think Mr. Tivy agreed. It is a good quality bus service from the appeal site. So in my view, the material considerations of the framework have been positively met by the appeal site.
Okay, thank you. So moving on to weight to attach to conflicts in the scenario that the tilted balance is not engaged. So assume, contrary to your case, I understand your case is it should be engaged. If Mr. Tivy's evidence is accepted and it's not engaged, my questions then follow on that premise. So if the tilted balance is not engaged, the development plan is by definition up to date, isn't it?
If the tilted balance is not engaged, the development plan is up to date. I think it might depend on the parameters that you are considering.
Well, I was just, sorry, I didn't. Please finish the question. I didn't mean to interrupt you.
No, I think you need to also consider the merits of those individual parts of that planning consideration.
Well, so you're saying that there could be a situation where, having considered all the various options, a decision maker decides in their judgment that the tilted balance is not engaged. You're saying that nevertheless there could be cases where the development plan is still out of date. Is that right?
There is with regards to heritage, that the presumption can be disengaged. Or European sites, sorry.
Right, no, but just looking at para 11 again, so let's just take it in steps. It tells us where the tilted balance is engaged, either where there are no relevant development plan policies, or the policies which are most important for determining the application are out of date. So what I was suggesting to you is that the converse of that is that if the tilted balance at para 11D isn't engaged in a given case, it follows, doesn't it, that the development plan is not out of date, it is up to date.
Yes, I think I can agree that, obviously depending on the circumstance. Yes.
Okay, so moving on to para 12, so eking forward in the framework to para 12.
Are we going through all the policies?
Well, we could do. I'd love nothing more. Para 12, the presumption in favour of sustainable development does not change. The statutory status of the development plan is a starting point for decision making. Where a planning application conflicts with an up-to-date development plan, including neighbourhood plans, which we don't actually worry about here, permission should not usually be granted. Local authorities may take decisions that depart from an up-to-date plan, but only if material considerations in a particular case indicate that the plan should not be followed. And then just holding that in your mind and looking at para 15. Para 15, the planning system should be genuinely plan-led. So it's a function of government policy, isn't it, that the plan-led system is an important thing, not just as a matter of strict compliance with the law, but the government is putting particular emphasis on the plan-led system as being an important planning consideration on them.
Yes, we're in a plan-led system.
Yeah, but that's not just what I was just interrogating. Is there's a slight difference between saying, well, technically that's what the law says, section 38.6, and the language of para 15 and para 12, which is to say it should be genuinely plan-led, and the government's expectation is that a conflict with an up-to-date plan should result in refusal, save obviously for other material considerations. So it's a government expectation, isn't it, that particular importance be attached to the plan-led system and compliance with up-to-date plans. Would that be fair?
Yeah, there's a government expectation that the local planning authorities have up-to-date plans, yes.
Yeah. And therefore it follows, doesn't it, that if the tilted balance were not to be engaged in this case, there are powerful policy reasons to refuse planning permission because you would be in conflict with an up-to-date plan, and the framework tells you that you should refuse applications in conflict with an up-to-date plan. Would you not agree?
Yes, you can still but you can still do a balance, and you can still do material considerations if you so wish.
Not disagreeing with that at all. Just on the issue of what sometimes planners call pure policy harm. So if we forget the landscape and other things, pure policy harm arising from being outside the settlement limits. That's not something to be disregarded if the plan's up to date. It's something that the government is saying is important, and then there is merit in itself of following an up-to-date plan. Would you not agree?
Yes, to a degree. And the degree is that you can have, yes, harm to the plan-led system. And what I think you may refer to with other planners is that, but there have to be, you can have harm to the plan-led system in harm to a policy, but that has to manifest itself in a land use harm, in my view.
This is getting very conceptual and jolly interesting. So say there was no landscape harm and there was no sustainability harm and no other technical harm. Say this was purely a case where this was a development outside the settlement boundaries. Yeah, so imagine that. That's not our case, and it's not actually your case either, but imagine that. That is in itself harmful because it is in conflict with a plan, isn't it?
Yeah, I think that's what I just said.
Yeah, I think that's fine. I was just drilling down on that point to make sure I hadn't misunderstood it. Thank you. And it therefore follows that if there is a 5-year land supply and the tilted balance isn't otherwise engaged, conflict with an up-to-date plan is a matter which should carry significant weight in the planning balance, moderate weight in the planning balance in and of itself.
Yeah, the starting point is development plan and the tests tell us what to do.
And Mr. Tivy says that if there's a 5-year land supply and the tilted balance isn't engaged, the conflict with the settlement boundary policies by themselves, so forgetting the landscape and other harm he identifies, should carry moderate weight. If he's right about the tilted balance not being engaged, that would be right, wouldn't
it? Yes, I think I've agreed there is harm to that. Yes, whatever decision that the inspector comes to, if she were to grant the appeal scheme, there is a harm. I accept that there is a harm to the policy, and the plan-led system in that sense.
Thank you. Policy CS8, next please. Your case here is you've got a number of facets to it, as I understand it. First, or one of the facets, is that you say reduced weight should be attached to the conflict because the landscape character areas were not defined in the site allocations DPD, and the landscape character assessment was never scrutinised as a planning policy tool. And I just wanted to explore that point with you.
Mm-hmm.
Can we turn up CS8, maybe for the last time? But, you know, CS8 is at 7.1, page 80. And just let me know when you get there, Mr. Carwell.
CS8.
Yeah, page 80.
I have that.
Lovely. And it's the paragraph that starts, development must have regard to, that one. Development must have regard to the character of the landscape and its sensitivities to change, and where development is permitted, it will need to enhance the locally distinctive character of the landscape in accordance with the landscape character assessment, capital L, capital C, capital A. Do you see that?
Mm-hmm.
And I just wanted to explore this point about the landscape character assessments and whether they were interrogated as a planning policy tool. Can you go to page 149, internal page 149?
Oh, sorry, are we, which document? Are we in the same document?
Same one, sorry, same document.
Sorry.
149.
I have a printed copy of the policy, and so I was referring to that, but if you're not going to take me somewhere else, I will get it up.
Oh, fine. Oh, sorry, do you have that? So if you go to Core Doc 7.1, that should be the whole thing.
Yes, it is.
Yeah, okay. And if you go to 149 printed page or 151 on the electronic page, that's where I'd like to go.
Yes, yes.
And do you see there, about halfway down the page, the Braintree, Brentwood, Chelmsford, Mould and Uttlesford landscape character assessments by Chris Blanford Associates is listed?
Yep.
Yep, in the evidence base, and also the 2007 Fringe Studies is listed, that document. Do you see that?
Yep.
So they would have been open to interrogation by participants at the examination in public, wouldn't they? Because they're part of the evidence base for this plan.
That's right.
And notwithstanding that, the core strategy inspector thought it appropriate to have a policy, CS8, that said you've got to be in accordance with the landscape character assessments, didn't he? That was found sound. Just remind yourself of what's...
Yeah, development must have regard to...
in accordance with landscape character assessments.
Yeah.
Yeah. So it's not strictly right to say, is it, that the landscape character assessments and the contents of those two documents, at least, were not subject to scrutiny as a planning policy tool, because they were part of the evidence base for the core strategy. They would have been open to participants of the EIP to examine, and notwithstanding that, the inspector was content to find sound the policy that said you've got to be in accordance with them.
Yes, and I think obviously what I think the part two presumably would have done is gone a bit more granular than that. I can only assume from that what the wording is said, given it says further guidance will be set out in a SPD.
Yeah,
and defined in the site allocations DPD. Yes,
indeed, and that's the point you make at 4.3.18 in your proof of evidence. And it's just, you then go on to make an additional point. You say, as such, whilst I acknowledge the LCAs are defined in the landscape character assessment with associated planning guidelines, these have not been subject to detailed scrutiny as a planning policy tool. Well, that's not strictly right, is it? Because they were part of the evidence base for the core strategy. People could have criticised them at the EIP, and notwithstanding all of that, the inspector found sound a policy that says you've got to be in accordance with them. So they were subject to scrutiny as a planning policy tool, weren't they?
They're not a planning pool. Sorry, they are not a planning policy tool as such, because they aren't policies.
True, but the policy CS8, which is a policy,
yes,
that says you've got to have regard to the landscape, its sensitivity to change, in accordance with the landscape character assessments. So it's reading in those documents for part of the application of the policy, isn't it? Expressly.
Yes, I think what's here, yes, and as I say, I think that the further detail was going to be provided in the DPD, and it wasn't. So they are guidelines that inform those landscape characters. Sorry, the landscape character assessments are guidelines that inform a judgment. Yes.
Yes, so it's not strictly correct, is it, to say that they were not the subject of scrutiny as a planning policy tool, because in substance, I mean, I wasn't at the EIP, but they were before the EIP. They're part of the evidence base, and people saw how the policy was worded, and they could have said, "Oh, that's not right," because whatever.
But it relies upon a full assessment of relies upon those landscape character areas to be defined, but they're not defined.
But it says, just a minute. It says landscape character areas will be defined in the site allocations plan document, and further guidance will be set out in a supplementary planning document. But that's not to gainsay what's said before, is it? Development must have regard to the character of the landscape and its sensitivity to change, and where it's permitted it will need to enhance the locally distinctive landscape character in accordance with the landscape character assessment. It doesn't gainsay that, does it? It doesn't criticise or contradict that.
No, and I think on the evidence of Mr. Holliday, with whose evidence I agree, he has considered whether the landscape character assessment has been evaluated with particular reference to those Chris Blanford's studies.
Yeah, but I'm not going to ask you about landscape evidence because we've been through that, but just where you say at 4.3.18, it wasn't subject to detailed scrutiny as a planning policy tool. Well, that's just not right, because it was before the EIP, it informed the core strategy, and the core strategy says in terms you've got to have regard to these documents. So they would have been subject to scrutiny as a planning policy tool, wouldn't they?
Yes, there is some scrutiny of the landscape character assessments. What I was trying to get, I think you understand what I'm trying to get at, is that the next part wasn't done.
Yeah, sure, and you're right. But that doesn't mean that the previous bit of the paragraph we just ignore, does it? The bit that says development must have regard, that bit.
No.
No, and it follows, doesn't it, that I know it's not Mr. Holliday's evidence, but if Mr. Brown's evidence is accepted and the inspector were to agree that the proposal did not have regard to the landscape character assessments, didn't follow the requirements, that would lead to a conflict with CS8, wouldn't it? Because CS8 says that's what you're supposed to do.
Yeah, I think that's fair.
Thank you. And I accept, of course, that turns on the landscape evidence of the experts, and that's all been heard, and there we are. Thank you. Final point on CS8, you say it's not consistent with the framework because and reduced weight should be attached to it because of the requirement to enhance. Yeah? It says enhance, and you say that's not consistent with the framework. Can I just deal with a factual point? The planning authority aren't resisting your client's appeal on the basis of a failure to enhance, are they? Just remind yourself of statement of case and putative reasons, or the proof of evidence, or anywhere you'd like to go. But as far as I understand it, there's no suggestion that planning permission should be withheld as a failure to enhance. It's a complaint that there's a failure to conserve or preserve or protect, or words to that effect, isn't it?
Sorry, can I just leave you for 60 seconds? I'm not adjourning. There's something.
Of course, yeah. We'll pause.
Yeah, thank you. Thanks.
Talk about Christmas or something else, can't we, for a few minutes? Oh, it's gone dark. Yeah. Is it dark where you are in Congleton, Mr. Carwell?
It is.
Yeah. Well, I just wondered, 'cause you're that much further west, I wondered if it was still dusk there.
We're rapidly reaching the shortest day of the year, so yes, it's dark in Congleton at 5 o'clock.
Yeah. But then it gets lighter. So it's all progress after the 21st, isn't it? And that's good news. Right, there we are. We're just talking about Christmas and daylight, so nothing to do with the inquiry, madam. So I'll carry on.
Thanks. Thank you.
Yes, I was just going to ask you this point because your criticism or your observation, as I put it neutrally, your observation is that CS8 says you've got to enhance, and that's inconsistent with the framework. Come on to that if that's right in a minute. But just factually on this appeal, nobody's resisting your appeal on the basis there's a failure to enhance. That's not what's being said, is there?
I think reasonably probably can agree that.
Yeah, thank you. And so it follows, doesn't it, that the inspector's not being invited to find a conflict with this policy on the basis of a failure to enhance. And so she doesn't need to consider what weight to attach to such a conflict with it, does she? It doesn't actually fall to be determined on the facts of this appeal. There's no one's arguing it.
Obviously, CSA is referred to in the reasons for refusal, so the inspector is obviously duty bound to consider that.
Yeah, but you know, you've heard all the evidence, seen how it's all fleshed out, seen the state of the case. I mean, no one's saying, well, look, we accept all the landscapes preserved, but our real complaint is it's not enhanced. Nobody's advancing that case, are they?
Well, the council's issue is obviously that is the development of the site.
Yeah.
And if I understand the council's case, is that by virtue of development, it isn't enhancing. It is detrimental to.
Yeah, you're right. I mean, that's what's said, isn't it? But I was just making the point with you, Mr. Carville, and seeing if you agreed that actually the conflict with this element of the policy just doesn't arise on this case because no one's saying that's the reason it should be refused. The council's case is because there's a failure to preserve or a failure to have regard to the landscape character requirements. Nobody's saying it should be refused because of failure to enhance per se, are they?
Okay.
Well, and so it follows, doesn't it, that actually the weight to attach to that particular criterion doesn't arise because it's not an issue.
Okay, there's no if there's no conflict with.
Yeah. It doesn't matter whether that bit's in accordance or not, does it?
Correct.
But just delving in, because we couldn't resist, let's go into the framework. At page 5, almost every paragraph, page 5, para 8, right at the beginning, tells us that the sustainable development is achieved by delivering a number of objectives. Para C, an environmental objective to protect and enhance our natural built historic environment, etc. Right at the beginning, tells us to enhance, doesn't it?
Mm-hmm.
And then if you go to 174, zooming in a bit more local to the issue we're dealing with, it tells us, doesn't it, that planning policies and decisions should contribute to and enhance the natural and local environment by, doesn't it?
Sorry, which paragraph did you read there?
Sorry, 174.
Yeah, which one? Yeah.
Well,
the
beginning sentence, yeah. Planning policies and decisions should.
Yeah.
Says it there, doesn't it? And then it's the council's case. I know it's not your case, but it's the council's case. It's a valued landscape. If that's accepted, well, little a tells us to enhance again, doesn't it? Valued landscapes.
Mm-hmm.
So if it's a valued landscape, the planning policy tells you to enhance 3 times, and if it's not a valued landscape, it tells you to enhance it twice. Yep. And so it can't be said, can it, that a requirement to enhance is inconsistent with the framework because it uses the same said word.
Yes, they should contribute and enhance that. Yeah.
Sure. So it cannot be said, can it, that a requirement to enhance is inconsistent with the framework because it uses the same word 3 times for valued landscapes and twice for all other landscapes.
Can I go back to policy CSA?
Of course, please.
We've obviously moved on, haven't we?
No, No, we're still on CS8.
Sorry, as in the page you took me to in the PDF. I moved
Oh,
on.
sure. Yeah. So PDF page, printed page 80, electronic page 82.
Yeah, I think even within that though, there's, I mean, of the policy and within the framework, there is, particularly within the framework, there's a balance to be struck, and quite clearly, in order to develop any site, a greenfield site that the council needs to do to maintain its fibre supply, etc. The natural environment, if you want to start with, obviously development of the appeal site, some of that be lost, but then balanced against that is obviously our biodiversity net gain that's we discussed earlier.
Yeah, but just on the point I was asking you, the fact that a planning policy, a development plan policy, says that you should enhance the natural environment, that's not inconsistent with the framework. In fact, it is on all fours with the framework, isn't it? Because it tells you to do exactly the same thing. So how can it possibly be inconsistent?
And in my view anyway, of the appeal proposals do enhance those features of the site. And it wouldn't appear, as I say in my evidence at 4.320, it wouldn't appear disordinate in the context of the setting and the wider surroundings.
Yeah, so you and I can agree, can't we, that because CS8 has the word enhance in, doesn't mean it's inconsistent with the framework.
No, those words both enhance appears both in, or enhancement appears in CSA and in the framework.
Right, thank you. Righty-ho. Just quickly on 5-year land supply, and then we're on to the final furlong. You're right, Mr. Carville, did you want to?
No, I'm waiting for the question. I'm waiting for the question.
Righty-ho, good. If the inspector were to conclude you're right about the housing land supply, and it's at most 4.96 years, as you've put in your note, that's a small shortfall, isn't it? 39 units on my calculation.
Yes.
Yeah. And just have a quick look, if we may, at Core Doc 6.6, the Earl's Cone decision, and just what that inspector said about the shortfall there. Para 59 when you get there.
Para 59.
Yeah.
Yeah.
And just this point, isn't it? So 59 on page 9, the inspector there said the public benefits of the proposal primarily lie in the provision of 53 dwellings, including affordable housing to the local housing supply. This would include the social and economic contribution that future occupiers would provide to the local community, and there would be temporary economic benefits during the construction phase. Given the limited nature of the shortfall, I consider it is quite probable that this could be addressed elsewhere in the district and not in this location, where there will be an adverse effect on the conservation area. Therefore, I attribute reduced weight to these benefits. Now, I understand and accept there's obviously no heritage harm in this case, but there is acknowledged harm. We say more, you say a little, but there is acknowledged harm. Those conclusions read across, don't they? That it's a limited shortfall, there is some harm, it could be made up in less harmful locations?
I don't think. Obviously, that inspector there is considering a conservation area. There's obviously a statutory test with regards to conservation areas and their settings.
Not their settings, Mr. Carville.
Sorry?
Not their settings.
Sorry, there's a statutory test. I'll leave it at that. Sorry, statutory test.
Okay. But I accept that heritage isn't an issue here.
The framework
does
not tell us that. It tells us that in paragraph 11 and about whether there's a lack of 5-year housing land supply. Doing a test, it doesn't say where there's a shortfall and it might only be a little bit. Don't apply this. It says it's kind of it's a pass-fail test, isn't it?
Absolutely right. And sorry if I mischaracterised the question. No question that if there is a 5-year land supply shortfall, the tilted balance is engaged because it says that expressly. Quite right, Mr. Carville. My question to you is that when you're applying that balance, so you're balancing the benefits against the harms, it's relevant to ask, isn't it, the degree of the housing land supply shortfall in the amount of weight you attach to the benefits of housing.
Yes, in a broad concept, but I think when you put that to me there before, that inspector there also said, I consider it's quite probable this could be addressed elsewhere in the district and not in this location, given the adverse impacts on the conservation area. There's no evidence before the inquiry as to where else, if there is a shortfall, that may be met in terms of if the council made a decision now.
Okay, well, let's just break it down to see where we depart. So 59 in the decision letter, given the limited nature of the shortfall, you presumably would still agree it's a limited shortfall because actually it's less than that inspector found. In your case, it's 4.44 years, and you're saying it's at most 4.96, so it's about the same, if not less. So you'd agree it's limited.
The measures, yeah, I'd agree with this inspector's assessment of the shortfall.
And we can agree there's no harm to any conservation area in this case, but there is acknowledged harm even on your case, isn't there?
Yes, principally to the policy.
Well, yeah, but you've identified harm to CS8 and conflict with CS8 and RLP80 as well. So you've identified adverse impacts, less than the council, but still they're there, yeah? So that's the same, isn't it?
Okay.
Yeah. And then you don't agree, though, with the inspector's finding here, which is I consider it's quite probable this could be addressed elsewhere in the district and not in this location where there would be, and she says, harm to a conservation area, and we could say harm to a landscape. You don't agree with that?
I'm saying that should the inspector find there is no 5-year housing land supply, there is no site identified that the council would grant tomorrow in order to remedy that shortfall. All
right, okay, thank you. There is, however, the housing delivery test results. They do show that there is a positive record of delivery, don't they? Because the percentage shows that all that's required is an action plan and not a buffer or the tilted balance. There is a positive record of delivery in this council, isn't there?
Yes, that the housing delivery test is a retrospective assessment of housing delivery, and a 5-year supply is a test of future delivery.
Absolutely right. But what I was asking you is the housing delivery test shows that there is a record of past tense, a good record of positive delivery, isn't there? That's what it's showing in the past.
There is on the last year when it was found to be the spreadsheet shows 85%, but the figures before that were much lower.
Okay, so you think the housing delivery test results show there's a negative history of delivery, an adverse history of delivery?
I'm not sure what you mean by adverse history in the sense that
poor history, a bad history of development, of a delivery. Is that what you think?
Yeah, I think that's a relatively accurate. Yeah.
Right. Okay. Well, thank you. Bad history of delivery. Thank you. But on your analysis of the evidence you've had in front of you, you've come to a conclusion on housing land supply that's in fact a little bit better than the Earls Code Inspector, haven't you? I mean, the council doesn't accept either, but on your case, it's actually a bit better, isn't it?
Yes, because what I did was I reviewed the evidence that the council produced,
Sure.
and I made an assessment of there were sites that Inspector Sabu discounted, and then there was one site that was an outline, and then the council has since received a full application. So, on a very fair basis, I think I accepted new evidence that it wasn't before Inspector Sabu.
Quite right, Mr. Carmel, no criticism whatsoever, purely to observe that the situation has therefore improved even on your own case, isn't it, since what Inspector Sabu said, and then you've reviewed it later on with new evidence and you've come to a higher figure, haven't you?
That's right.
Yeah. And in terms of the likelihood of making up the shortfall, well, you've looked at the sites. There are a number of sites with extant capacity to deliver, aren't there? There's some very large sites. You disagree on some of the delivery rates. We've had all that discussion, but there are some sites with very large capacity to deliver housing, aren't there?
Yep.
And there is a local plan part 2 in train, effectively a site allocations document, which upon adoption would give a 5-year land supply, wouldn't it?
I'm not sure what the inspector is going to assess as part of that. I don't have their report before me, obviously, because it's not been written yet.
No, no, do I? But it'd be very unusual if a plan was found sound without a 5-year land supply, wouldn't it?
In my experience, actually, generally Part 2 plans, because the Part 2 plan doesn't assess the housing number, that was done in Part 1.
Yeah, but you're not saying that housing number's out of date, are you, Mr. Carville?
No, but it doesn't necessarily flow that there is a 5-year housing land supply as a result of the adoption of a Part 2 plan.
Oh, okay. So you think that it could be adopted and found sound even if it didn't deliver a 5-year supply against the up-to-date housing requirement?
Yep.
Right. Okay. Did you have an example of a plan that's been found sound post framework that didn't have a 5-year land supply and was found sound?
Sorry?
Did you have an example of a plan that's been found sound post framework, where the inspector said there wouldn't be a 5-year land supply, but nevertheless I'm finding?
But I don't think that's the test. That's my point. I don't think there's a test in a Part 2 plan. I don't think that test applies, because it's not setting the strategic policies, and the strategic policies set the housing requirement. No,
but that's only been adopted this year, hasn't it? So it's bang up to date, that housing requirement figure, isn't it?
Yes, but in that same year, in that same monitoring year, and in this appeal decision, the inspector has found there'd be no 5-year housing land supply. So I'm not quite sure how that moves the council forward in that respect, because it's this decision here is the plan was adopted. I think it was February. This decision is of a month ago, and in that same year, the council has found not to have a 5-year housing land supply.
Cool.
So even on a recently adopted plan, the council doesn't have a 5-year housing land supply on that appeal decision. Yeah,
but there's quite a good reason for that, isn't there? It's because the council hasn't counted any of the allocations in the local plan part 2 as part of its housing land supply, and you know that because you've reviewed its evidence. Has it?
No.
No. Okay, thank you. Just very quickly on the 1990 appeal decision, take this very swiftly because no one's relying on it to a huge extent, but it was for 17 bungalows and it was on the appeal site, or a part of the appeal site, I understand. Is that right?
It sounds like it is. I'll take your word for it.
And Mr. Tibby replicates or reproduces, should I say, in his proof of evidence at 6.9 what that inspector said. It's quite difficult to make out on the printed copy. 6.9 in Mr. Tibby's proof of evidence, he quotes from that inspector's decision: "The site can be seen from an area of the valley which includes several public footpaths, road edge and village cressing on the far side. All in all, I conclude the client's proposal would be detrimental to the open character of the countryside around the village and the scenic quality of the valley." That appeal decision and the inspector's judgment, that's a material planning consideration in this decision, isn't it?
Yeah, it's before the inspector, and it's a consideration, yeah.
And you say, however, nevertheless, notwithstanding that, you shouldn't put much weight on this, because in your 2.2.4, you say matters have changed on site. Clearly, matters have changed both on site and in the local area. There's no evidence, Mr. Carver, that I could find showing how the site had changed between 1990 and now, is there, before the inquiry?
No, I mean there was obviously no photographs of
Right.
the appeal site in 1990. My knowledge and understanding of the appeal site is that the introduction of horses is much more recent than 1990. So that's my understanding of it. I don't think there's any horses around still from 1990 either, so.
Right, well, I don't know. Okay, thank you. Final clutch of points, which I can take easily within 5 or 10 minutes, madam, which I'm sure is preferable to keeping Mr. Garvell overnight, if that's acceptable to him and to you. I'm conscious he's been going a little while, but are you all right for me just to finish off?
Yeah, if it's just 5 or 10 minutes, then yes, thanks.
I'm grateful. I'm sorry we've run over 5, my fault. Lastly, on the benefits, Mr. Carvell, public open space in the community park. As I understand it, there's no dispute it is within flood zone 3. It's in the 1 in 100 year zone, and that's not in dispute factually.
Just the community park area.
Just the community park area. Yes, that's right. Mr. Tivy then says, well, there would therefore be times of the year where it might not be usable, or it would be heavily churned up. I mean, he's probably right about that, isn't he?
There may.
Yes.
I don't think you guarantee that.
No, but equally, his prophecy that might come to pass, you're not saying, well, that's completely ludicrous because, and then supplying some explanation. It's something that could happen, isn't it? There could be times of the year when it's unusable. That's his evidence, and you're not saying he's completely wrong about that.
There are times that may happen. That may happen.
Okay, thank you. And he says, well, it's not going to be the subject of natural surveillance. He would be right about that, wouldn't he? Because there certainly wouldn't be likely ground floor overlooking from kitchens and living rooms and such because of the intervening hedgerow and strengthened planting. That would be right, isn't it?
Yes.
And therefore, would you not accept that might well, the combination of those two things, put some people off using it?
Again, I no. Again, people use areas how they want to use them, and
undoubtedly
sorry.
Undoubtedly true, Mr. Carver. With that,
and if I was sat in the park and then someone was staring out the window at me, I think I'd feel a bit looked upon, actually. So I'm not quite sure what you mean. I mean, yes, the houses will be screened by the existing hedgerow and planting. So Yes. And people go to use green spaces to get away from where they live, to experience rivers and the natural environment, which is what that area was going to do.
But you see where Mr. Tibby's coming from. I mean, it's a principle of good design, isn't it? That when you create amenity areas and recreational areas within and around schemes, that they be areas where people can feel comfortable, and there's natural surveillance for younger children to be supervised by their parents. You'd accept all of that just as general design principles, wouldn't you?
Yeah, I mean, you specifically referred to that natural surveillance from a house, and people with children, I don't suppose, are going to take their children to a play area and then go back home and look at them from the window. So there is no play area in that area that is within the kind of main body of the appeal site. So the purpose of or how I expect that area to be used is much like Cocos Peace is currently used. There is there'll be routes around it, and people will no doubt walk their dogs and things like that.
Okay. What about antisocial behaviour? If it's an area that's not got ready oversight from natural, obvious vantage points, it might give rise to antisocial behaviour. Do you disagree with Mr. Tibby on that? Say he's completely wrong, and never in your experience have you seen this kind of thing? It's a risk, isn't there?
Antisocial behaviour can happen anywhere at any time, I suppose, if someone's so inclined to do it.
But a lack of surveillance is his point. A lack of surveillance, he says, may increase the likelihood of antisocial behaviour and things that, well, antisocial behaviour. And do you disagree with him on that? Do you think a lack of surveillance reduces the likelihood of antisocial behaviour?
I think it's probably a neutral point. People who wish to commit antisocial behaviour will commit antisocial behaviour, should they so wish. Given the nature of the park, given what will be provided in that area, I'm unsure what antisocial behaviour would be able to happen.
Okay. Economic benefits. You say significant, Mr. Tibby says moderate. If there were a 5-year land supply, and therefore, by definition, other locations to meet the need, the economic benefits of housing delivery of 80 units could be met in a less harmful way, and that should bear on the weight you attach to them. Would you not agree?
Yeah, you could moderate that to yeah, there could be a moderate rate if there was a 5 supply.
Thank you. Would that be ditto for the supply of market housing? That if there were a 5-year supply, you should moderate the weight you attach to it, because, well, frankly, if you don't moderate the weight to attach to it, you're driving a coach and horses through the planlet system, rather, aren't you?
I think I explained in my evidence in chief as to why I would retain significant weight to market housing.
Yeah, you said because of the throughput. Sorry, I can't remember where I'm writing. I think you said because there's a necessary to have a choice and mix to enable enough throughput to allow for unexpected lapses, broadly speaking. I'll put that less articulate than you did, but that's your point. Say, because it's marginal. Is that your point?
Yes.
But isn't that the purpose of the buffer?
Yeah, yes, the NPPF has expectations of buffers to be applied to housing land supply assessments.
Yeah, so you're trying to put a buffer on the buffer, really, aren't you? You're trying to double count the throughput point. It's already been integrated into the housing land supply calculation because the buffer has been applied. That's the whole point of it, isn't it?
But I agree with the council in the situation where it says in the Hatfield-Peveril committee report that it's necessary to maintain that, and I think it's acknowledgement that not all sites within the council supply may come forward.
Yeah,
it's obviously a projection of what could come forward.
Yeah.
They may not all come forward, and there may be changes to situations where new evidence comes to light where a particular site can't be delivered for a particular reason, and if that site were to be removed from the housing land supply, they then couldn't demonstrate a 5-year housing land supply, for example.
I understand your point entirely, but do you not agree with me that that is the function of the buffer on the housing need? That's exactly why the buffer's there, isn't it? To capture that kind of situation, to allow for those kind of unforeseen lapses. That's the whole point of it, isn't it?
I think my understanding is the reason of the buffer is to ensure that the whole plan requirement is met in full over the plan period.
Yeah, and to account for lapses, failures, delivery, all those kind of unforeseen situations to enable there's a robust 5-year land supply. Is that why it's there?
Yes, I can agree with that.
Yeah, thank you. Affordable housing, I think you now say you would say significant, and you and Mr. Tivy are as one on that now. Is that right?
Yeah.
Yeah, thank you. And then just finally on this quick point about quick delivery, just make sure you understood this carefully. You're proposing, if the inspector were to grant permission, there should be a condition that said, is it 2 years to submit reserve matters and then 1 year to implement after that? Is that what you're suggesting?
Correct. Yeah.
Yeah, thank you. You've put at Appendix 4 some expressions of interest from house builders.
Yeah.
By all means, have that in front of you if you want. Yeah, one from Barrett and one from Barrett David Wilson and one from Mulberry Homes. I can't see that either of those people have said that they would be content with a shorter reserve matters and implementation period. Can you?
Let me just go.
Of course, yeah.
I mean, no, I know that they do not say that. No.
Yeah. And of course,
of course, if a permission were to be granted, a point I explained earlier is as you know, we provide an oven-ready site, as we like to call it, or I like to call it, not a Glavnism, I like to call it. The purchaser would look at those conditions because they would become part of a decision letter issued by the inspector.
Yeah.
And therefore, any purchaser would be cognizant of the conditions of the decision letter.
But Mr. Colby, you can't extend the time limit for submitting reserve matters applications or the implementation period by Section 73, can you? You do know that, don't you? You can't extend the time limit once it's granted.
Right.
You knew that.
I'm not asking to do that. Hence we suggest.
Sure.
Hence we suggested it. Hence we.
Sure, but you're not the house builder. You're not going to be building it out.
Right.
All agreed. The house builders, you have got expressions of interest here, haven't said they'd be content with that shorter time period, and the inspector doesn't know that that's all going to be worked out, because if she does grant permission subject to that shorter time period, there's no ability on the house builder to extend the period to submit the reserve matters application or the implementation period.
Yeah, and as those ones that are referenced in quite commonly at appeal, some of my colleagues have also offered that same approach.
Well, I know, but what I was asking is, how can this inspector put any weight on this accelerated delivery point? Because you don't know that the house builders who would be building it out are content with that time period, and they can't extend it if they're not. So, I mean, how can the inspector put any weight on this benefit? Because you haven't got any evidence from the people building the sites that they'd be content with this accelerated time period.
The site is still to be marketed, so
yeah,
it is in our interest to do that as quickly as possible, to get it to the market, to get it sold, so the reserve matters can go in.
Sure.
So there is no benefit to us to so it's effectively a self-impinged cross to bear, if you like. There's no benefit to us because we have less time to do it.
Sure, but you've got no, just help me on this. There's no evidence from the people who would be building this site that they would be content to get a reserve matters application in 2 years and to implement within 1 year after that, is there?
No, because they are expressions of interest, and there is no fixed house builder for the scheme.
No. Okay, thank you very much. Thank you, Mr. Carville. Those are my questions. Thank you, Madam.
Thank you very much. Okay, Mr. Robson.
Thank you, ma'am. I think, in the interest of everybody's sanity, I have no questions in re-examination. I think the points were all dealt with by Mr. Carville, and anything I can deal with in submissions, ma'am. Very grateful.
Okay, thank you very, very much, and thank you, Mr. Carville. So, okay, so are there anything procedural that you need to tell me before I close for today? Adjourn, rather.
Sorry, ma'am, I need to check the plan for tomorrow is conditions in 106.
Yes.
Is conditions in 106 are now to be in the morning, are they? Because your site visits obviously isn't
Yes. Yeah, that's right. So yes, we'll just carry on in the morning, and we may finish early for Friday afternoon, who knows. But yeah, we start at 9:30 in the morning with conditions and the section 106. I'll do the conditions first.
Yes, ma'am.
Section 106.
Good, and I absolutely, I mean, hoping for an early finish tomorrow. Hopefully we're not going on to 5 o'clock. I can't remember what Dr. Bow's estimate was for his closing.
Well, I can't either now.
I think I put about 45 minutes.
Try and beat it.
I think both you and I have beaten enough of our estimates for this inquiry.
Well, we're still within, aren't we? We're still there.
And the closings you will email to me as well before you deliver them, please. Yeah, so you won't be involved presumably in those two discussions, or will you? You might be involved in the section 106. I don't know.
I'll be on.
You don't have to be.
I'll be here. I'd imagine Mr. Tivy will be leading for the council, as I'm sure Mr. Carville for but I'm happy to be here to assist if necessary, but don't propose to. I have nothing planned to say, if that helps.
That's okay. I'm just checking. I'm just being nice to make sure that you've got enough time to write your closings. That's all, and get them emailed to me.
Very kind of you. Thank you.
Thank you.
But yeah, okay. Okay, I'll adjourn now, and we'll be back tomorrow at 9:30. Thank you very much for today. Thank you.
Thank you very much.